Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addicts live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican boys verbis Latinos.
You know what? I forgot to do something, and you guys just found it. Yes, I forgot to disable the party horn command. I'll get to that in a minute. Good morning, everybody. Welcome. It is Thursday. Hope you're having a fabulous morning or afternoon, wherever you are. Thank you for joining us here in the Court of Public Opinion. I am Recovery Addicts. Appreciate all you being there. Especially... rest assured, everyone. I know you guys are worried. I saw some questions earlier in chat. There was a problem. But rest assured, Sharon McDonald is on the case. Sharon McDonald, first in chat, a repeat offender for winning the internet. She's done this before and has done a great job with it. Sharon, congratulations on being first in chat. The internet is all yours today. We'll just package it up and email it out to you. Speaking of packages, Amy Karen just sent me a big, huge box full of all sorts of goodies that I had to fight my kids for. I've got, she sent some pens for Mrs. R.A., some just amazing pens, really cool sparkle one in here that I'm going to drop if I dump out, but there it is.
Are we going to just subject matter jurisdiction?
Some awesome pens. She's got a whole bunch of different keychain iterations, coasters, all with, the Recovery Addict logo on it. And then she sent these 2 awesome mugs. Let me show you this. Let's show camera 1 here. These awesome mugs that have like a frosted version of our logo on the front, and on the back is Recovery Addicts, Crime Watch, Pickles Not Politics. Just amazing. So awesome. Thank you so much, Amy. The kids are already super excited to claim everything, and I don't think I'll ever see them again. but just awesome work, Amy. Very, very grateful for that. I'm going to hide them over here so the kids can't reach them, at least without me knowing that they got them. But and Mrs. R.A. is definitely going to get the pens. I think she gets first dibs there. So appreciate that, Amy. Let's see. We've got a huge morning. This mug, by the way, comes with like
taking it easy.
A glass straw in it. It's like I can't wait to pour some lemonade in here, throw some ice in there, and just kick back and take it easy. Really, that's going to be awesome. Love it. Where were we? We were right at the very beginning, I think. We're just kicking off the show. I have to tell you, I've sort of got a confession. And there's a good chance that somebody on here is going to hear this confession, and they don't know what I'm about to confess to, because it happened last night.
I was kicked back, taking it easy.
Yeah, I was, I've got my regular youth activity meeting Wednesday nights, and afterwards we have a Zoom meeting, just like a little adult Zoom meeting, small group. And so I'm at the activity. It was awesome. Come back home, hop on Zoom, and on the way home, I'm like, I'm starving. I have not had dinner, okay? Because the court in Utah goes late, and I'm like, I've not had dinner, and oops, that's not right. Let's try that. There we go. The court went late, so I went straight from there to the activity. So I had like one lollipop and a bottle of water. I'm like, this is not going to tide me over for dinner till the next morning. So I'm driving home with my boys, and I call Mrs. R.A. on the phone, and I say, hey, how does a Wendy's Frosty sound? I'm trying to, get her to agree to let's go out and get some food. And of course, it's late in the day. She's like, really? Now? You want to go out this late? It's like a little late for dinner. I'm like, I know, but I'm starving. And I go up and I'm looking at Wendy's. I drive into the parking lot for Wendy's. I'm like, no, I shouldn't. I drive out and I drive by Chick-fil-A. I'm like, oh no, I shouldn't. And all the time I'm talking to Mrs. R.A. on the phone saying, how about this? What has this? You know, a chicken sandwich? You want a salad? Do you want, you know? And she's like, no, we don't, you know, just, you know, we made spaghetti, you know, the kids eat spaghetti type thing for dinner. I'm driving home, and finally I'm like, okay, the last one, there's a Hardee's. I'm like, okay, Hardee's it is. It's like Carl's Jr. for those of you out west. I'm like, I could use a good burger, some fries, and I'm already starting to salivate and drool. And I'm looking at my clock, and I'm like, I've got to be on Zoom in 5 minutes, and I know there are only 2 employees in this Hardee's because there are always only 2 employees in that Hardee's, and it takes forever to make the food, and it's not their fault. They just don't have enough people working there. And I said, I'm going to do the right thing. And I'm going to just go home, and I'm going to be on time for my meeting, and I'm just going to do that. And so I get home, and Mrs. R.A. sees me come through the door with no food. Okay, after we've been on the phone the whole time, she's like, "No, don't get anything." I'm like, "I've just got to go through my meeting. That's it." And so I start the meeting, don't think anything, and I hear one of the cars, a few minutes later, like beep beep, you know, as they park it in the driveway and set the little lock the doors thing. And Mrs. R.A. comes walking in with a plate, and it's got a big burger from Hardee's and fries, and she's got a big drink sitting there, and she's like, "Hey, I felt so bad for you, and you didn't have time, so I went out and got you the meal." and so I'm like, "Thank you." And so here I am, I'm on Zoom, right? And so my camera's on this camera right here. This is what they see, and I've got this plate, and it's like slid down here on the table, so I'm like sneaking fries into my mouth. You know, chewing as slowly as I can I'm sure they saw it. This is not one of those Zoom meetings you can hide on, right? Where there's like 30 people and you're on page 6 or something. No, there were just like a handful of us on there. So I'm taking like 20% of the screen up for whoever, and I'm just eating, and I eat all the fries. Okay, I'm sitting there, and this burger is just sitting there wrapped on the plate. And I'm like, oh my goodness, it smells. It's right underneath the microphone, so I'm just smelling this, and I'm like, oh, okay, you know, I can't bring the cup over and like with the straw because it's too tall. I think I might have done it on accident once, but I'm like, I can't just do this. And I'm like, what? I'm an idiot, right? I have $10,000 worth of equipment here. I can just sit still for a while and listen because I'm still participating. I can sit still and I can take a screenshot of this, what you see right now, and let me show you how that works. And you tell me if this is convincing or not. But let me go to, okay, we're going to delete that one. So I'm going to sit there like I'm in a meeting. And I'm going to take a screenshot, and then what I'm going to do is I'm going to just switch that screenshot right here, and nobody knows that I'm not paying attention, right? Because it looks like I'm there. Well, I am paying attention, but so I switched to the still shot, which, you know, is not me, but the still shot, it looks like me. And I switched that still shot, and I take that burger and I unwrap it, and I take this my first bite, and right as I'm taking that bite, I just bit it off, and it's in my mouth. The leader of the Zoom says, "Scott, what do you think about that?" I'm like, so I swallow the thing whole, switch back to camera. I did not take another bite for the rest of the meeting. I just sat there and looked at it and like, I just about choked to death on the burger I took a bite of, tried to sneak during the meeting. So that was how last night went. And now those people who are in the meeting know that I know what happened. So that's anyway. I thought I was going to be really sneaky, but I totally got caught completely. Lewis Cox, welcome to the gallery. Thanks for being a new member. I apologize. We normally do roll call in the morning. I got completely sidetracked telling you my updates. Let's see. Oh man. So yeah, now they're going to know because I did not tell them on the live stream. I think I got away with it. I mean, I don't think they saw me chew and swallow, but I know a couple of them do occasionally pop their head in on the live stream. So I'm owning up to it. That's what I did. I thought I could catch a little bite to eat while I was starving, and it didn't work.
I was kicked back, taking it easy.
Anyway, had a good breakfast. Got up nice and early this morning to make up for it. Got up nice and early, made the family omelets because my little boy loves omelets. And he eats. I think he eats about 4 to 6 eggs worth of omelets, and he's a small kid, but he just loves them. Okay, there's a new Sarah Boone letter. Hold on, hold tight. Let me pull that up here. New letter. We might have to do a quick reading here as we get started. Let me access my my email direct from the Orange County Clerk's office, where she sends me updates about everything that happens down there. Let's see, here we go. Sarah Boone letter right here. Correspondence filed from defendant to judge just this week. Here we go. Ladies and gentlemen, we have a Sarah Boone letter. Let me pull it over on this screen so you guys can follow along with me. Just one second. Because I know you like the handwriting and everything, but we're going to download it. We're going to call it Boone. What is it? Boone 7? Is this letter 7? I don't know. I have to double check the math. But she's almost like a pen pal of ours now. Really, it's that many letters have happened.
Are we going to address subject matter jurisdiction?
It's a shorter letter. Hold on just one second. We're gonna get this pulled up, full screen, hide the sidebar. How do I do that? Where's my sidebar? It's somewhere. Well, this will work. Okay, so we're gonna show it like this. Let me get up a super source. Maybe a 3-box. Oops. It's showing Emily D. Baker's screen. I was watching her stuff just the other day. Sorry, I'm so excited about this. Box source 1 is going to be box 3. There we go. And 2 will be 4, and I'm going to be there. And now we can switch. There we go. Okay, so let me get this a little bit bigger so we can see it. I'm going to get rid of Tina. Thank you very much for the update and the link. And then I'm going to pull it up right here on this so I can see it. All right, so this is to the judge, Frank J. Bankowitz, Esquire. It's dated March 22nd, but it was just filed on the 27th, I think. So we're a couple days old on this. It's got Sarah Boone regarding her case. It says, Mr. Bankowitz, this is my 3rd letter trying to reach you over another almost 6-week period now. The same 2 phone numbers you've given me still do not work. So that's not judge. This is the lawyer. Still do not work. So he gave her bad phone numbers. The one number, your personal cell, goes to voicemail directly and doesn't even ring. I've had this number since you personally gave me back in July 2022 upon your appointment as my attorney by the court. Not working 8 months later. The other number rings and rings and rings until it automatically disconnects me. Not working either. This is also the number you continuously tell me it just needs to be activated. Please activate. Even in my desperation to speak with you, I had an outsider caller try to reach you on my behalf who tried calling your office 3 times over the last almost 3 weeks, leaving a voicemail each time with no reply. We're both hoping you were able to reply to her email she sent today as another form of trying to communicate with you. I've exhausted my resources and again, just sitting here waiting for you to contact me in whatever way you are able as soon as possible, please. Time-sensitive matters are at hand, as I have made you aware of previously verbally in my letters. I know you have attempted to schedule the minimum 15-minute pretrial conference. I found out it is now on 3/31, which you said previously for whatever reason. I am unable to attend any of these conferences. How am I supposed to know what's going on, what you're reporting, and what is being discussed between all other parties except me, the main component to my case, especially if we, in a still unestablished attorney-client relationship, are not regular or proper communication with each other, Why can I not be in attendance and participate in my pre-trial conference? How else am I to be kept updated in real time and actual minutes during the conference if not there myself? I have no way of knowing anything if not updated by you, my attorney, and I do not have a computer to use/view myself. Help me understand, please. How can Court TV, different news channels, and even professional YouTubers attend my pre-trial conference and I cannot? How? I'm sure one of the other parties can help me with updates since they will all be in attendance for me. Also, should you be unable to provide why I cannot be included in my pre-trial conference for my case? I'm sure also everything from the conference, collected from everyone else, will be vomited all over the internet just like everything else has been, non-permissively, and can add even more dysfunction and ignorance to my prejudgment already made by the world in the great court of public opinion. That's where we are. I would like to be a part of all this, seen as it all pertains to me. Please, it is my right. So many questions, concerns, and piling up from not being, tell me court, did you mess up? That's all we get. We get 3 pages. There was a backside that was not scanned. There's more goodness in here. But we don't get it. All right. This is quite telling, because apparently Mr. Bankowitz still hasn't met with Sarah Boone. This is a problem for Mr. Bankowitz, not just Sarah Boone. This is a big deal for him. That is absolutely bizarre. Sorry, I've been ignoring chat. Let's see. They cut her off at 3 pages. Yes, that was the limit, apparently. She's filled up the personal correspondence to the judge folder. Wow. I don't know what to say there. I think I'll try to contact the court and let them know that they misscanned. Let's see. Do you think they're open right now? Should we do a conference call? I just need to contact Tiffany Moore from the court here. Let's go back. Okay. I think they probably know already, but somebody needs to tell them. Okay, here we go. Let's see. Register, log in. Where's the contact? Follow us. Contact support. Call center. Oops, probably not the call center. Records. Oh, that's just an online one. I thought I could call them. They don't make it easy here. We might have to sick our document hounds on a search for a number that can reach the records department at the clerk of courts. Okay. Anyway, let's see. I'm not bringing. Let's see. Seat. There we go. Now you can reread it with the sad piano music in the background with a little more emotion, please, too. It could be clipped for law nerds clips. Do you want me to do that? I'm going to have to turn off the sound effects just a little bit if we're going to do a true sad recording. I wish I got the rest of the letter. We need the closing. But okay, we're going to make this work. Here's what we're going to do. Okay, pop back over to Sarah Boone's stuff. It auto-populates on my computer. I do it so many times. Okay. Not protected. It would show if it was protected. The Florida's Orange County clerk documents are actually really, really good to work with. Can't believe I'm doing this. Okay, here we go. To Frank J. Bankowitz, Esquire. Mr. Bankowitz, this is my third letter trying to reach you over another almost 6-week period now. The same 2 phone numbers you've given me still do not work. The one number, your personal cell, goes to voicemail directly and doesn't even ring. I've had this number since you personally gave me back in July 2022 upon your appointment as attorney by the court. Not working, still 8 months later. The other number rings and rings and rings until it automatically disconnects me. Not working either. This also is the number you continuously tell me it just needs to be activated. Please activate. Even in my desperation to speak with you, had an outside caller try to reach you on my behalf, who tried calling your office 3 times over and over last almost 3 weeks, leaving a voicemail each time with no reply. We're both hoping you're able to reply to her email she sent today as another form of trying to communicate with you. I've exhausted my resources, and again, I'm just sitting here waiting for you to contact me in whatever way you're able. and as soon as possible, please. Time-sensitive matters are at hand. As I have made you aware of previously verbally and in my letters, I know you have attempted to schedule the minimum 15-minute pre-trial conference. I found out is now on 3/31, which you said previously, for whatever reason, I am unable to attend of these circumstances or these conferences. How am I supposed to know what's going on and what you're reporting and what has been discussed between all other parties except me, the main component in my case? Especially if we, in a still unestablished attorney-client relationship, are not in regular or proper communication with one another. Why can I not be in attendance and participate in my pretrial conference? How else am I to be kept updated in real time and actual minutes during the conference, if not there myself? I have no way of knowing anything if not updated by you, my attorney, and I do not have a computer to use/view myself. Help me understand, please. How can court TV, different news channels, and even professional YouTubers like Recovery Addict attend my pretrial conference and I cannot? I might have had a typo in there, sorry. How am I sure of one of the other parties can help me with updates, since they will all be in attendance for me also, should you be unable to provide why I cannot be included in my pretrial conference for my case. I'm sure also everything from the conference collected from everywhere else will be vomited all over the internet, just like everything has been non-permissively, and can add even more dysfunction and ignorance to my prejudgment already made by the world in the great court of public opinion. I would like to be part of this, seeing as it all pertains to me, please. It is my right. All right, that's as far as we can go there. She might have ran out of paper or ink. We do know she's previously run out of ink and had to order new pens. I'm recording this so I can fall asleep at night. How does she know all this info? She has access to the internet, I believe, and she also has people that contact. I did slip something in there, actually. Sometimes I get in the habit of saying things, and I realize I made some mistakes there. I may have inserted some words which were not actually in the letter, so my apologies if that inadvertently happened. It's strictly an accident. All right, so it's time to wake up again, all those who fell asleep to that soft reading. I'll give 10 memberships. I'm sorry. Hang on, Matthew. I can't read this right now through my tears. I'll give 10 memberships if you could force a tear right at this moment. Oh, that's funny. I can't. I'm sorry. I don't have that ability. Let's see. Kiefer says, how do you record YouTube, everyone? I think if you have a YouTube premium account, which all it does, I think it costs like $12 to $20. It's somewhere in that range. I don't remember, a month. It allows you to download videos, and I believe mine are able to be downloaded that way. If Sarah Boone is convicted, could this be the basis of ineffective counsel? I believe yes. And a strong yes at that. This is very bad. Carla, you just got here. That was a letter from Sarah Boone. We had a new Sarah Boone letter drop, or a partial letter drop. We're going to try to chase down the rest of the letter. I took a tiny bit of creative liberty in my reading, although all inflections were performed as written. She has access to the internet, and then she can watch us, tell her to come join us on the channel. I don't think she wants to join us on the channel. She wants her attorney to join her, and that's it. Yeah, that's funny things. I have a premium account. You can save videos. That works. There's also some tools out there, Puppy Dog Sherpa Bone Digger, like a 4K downloader, and there's some other ones. I will warn you right now. Trying to save videos from YouTube will get you into a gray area of the internet where you're very likely to get viruses. I would recommend using the preferred method of doing a YouTube membership and downloading that way. That's probably the best way to do it. And honestly, once you get a YouTube membership, you're going to be like, how could I live without this? No more ads. It's amazing. Where's Amber? She'll find the number. Kevin Riley says, just subscribe because Brandy Churchwell told me to. Kevin, Brandy is awesome. Love her on this channel. She does a great job. Occasionally, she's even able to pop into chat. But that's good. Let's see. Is it Shark Week? I don't know. Can you say more about the other letters? Carrie, I can. I've actually done a video about every letter from Sarah Boone, and I'll have to put it in a playlist. I've begged Mrs. R.A. to help me because I'm never going to get this done. Amber says, I totally just screen record. That works. On some devices, you can do it on a phone and things like that. You might have to make sure it's recording the audio as well as video and not just your audio. Check focus on your camera. Thank you. I'm on. Is that better for you, Adam? I was focusing on the microphone, unfortunately. Let's see. Kevin, welcome to Hotel California. You can check in but never leave. Taco, I'm glad you like the mug. Speaking of which, I need to fill up mine. I'm on my very last bottle of water here, so I'm going to have to stretch it out a little bit. Here's your ASMR warning. If you need a warning, now's the time. Do you want to hear a really random thought? A random thought? I know exactly how much water fits in the mug. But every time I wonder if when I'm pouring water into the mug, if this bottle is going to have enough to fill it. And I know that there's always going to be this much left in the bottle when I'm done because of the size of the mug. But every single time I'm like, is there going to be enough? Yep, too much. What does ASMR stand for? It's like an audio sensory. Oh man, I need help for the ASMR. It's people who like really focusing on pure sound and quiet and soft and the effect of sound on people. It's actually a weird part of YouTube, quite honestly. If you ever get sucked down that little drain, it's crazy. But I just go as far as pouring the water and that's it. Random thoughts this morning. It's a good morning. I'm in such a good mood. I do apologize for anyone who thought they were going to get straight to court business because I don't know if it was the Hardee's burger last night or the omelet this morning, but probably the package that came to the post office was probably a good one as well. Let's see. I wanted to talk about BK just briefly. My phone just buzzed, and just like that, I have the Orange County Clerk of Court number. This one's courtesy of, I think that's your business account. I wasn't going to shout that out here. Just one second. Dilly Pickles. There it is, Dilly Pickles. Thank you, Dilly. I can call. Do you want me to call right now? We've got time. We've got like 90. Let me check here. We've got, an hour. We've got an hour before court starts. So, let's see. Do you want to join me on the call? You're going to have to be really quiet. Okay, here we go. Let's just do this. Let's see if they're open.
Hello, you have reached the Orange County Clerk of Courts. We want to help you conduct your business as efficiently as possible. Our call center hours of operation are from 8 a.m. to 4 p.m. Monday through Friday Eastern Time.
They've been open for an hour and a half.
If you're calling to make a payment, we cannot process payments over the phone. I'm not doing that. You can make payments right from our website or at any of our 4 locations. Go to myorangeclerk.com for details. You can access many of our services anytime, anywhere from our website. Besides payments for traffic tickets or criminal fines, you can also find information about payment plans and other payment options at myorangeclerk.com. Payments can also be made at any AMSCOT location. Lawyers and pro se litigants can e-file court documents right from the Florida Courts e-filing portal at myflcourtaccess.com. Public court records can be viewed right from the website, and certified copies of court records and marriage licenses can be ordered here. Packets and forms for civil and family matters can be ordered and paid for right from our website shopping cart. You can also begin your marriage license application online with our e-marriage application.
Wow, they make that easy.
To access all this and more, go to myorangeclerk.com. That's myorangeclerk.com.
None of those were my options.
Your call will be recorded for quality assurance. To continue in Spanish,
I can record.
Please press 2. Para español o primo el número dos. If you know your party's extension, please press 3. Otherwise, stay on the line for further assistance.
I wish I knew my party's extension.
Please select from the following menu. For traffic attorneys, and compliance payment plans, press 1. For county and circuit criminal attorneys and compliance payment plans, press 2. For child support, divorces, injunctions, adoptions, name changes, paternity, and family attorneys, press 3. For county and circuit civil, small claims, passports, marriage licenses, evictions, foreclosures, and civil attorneys, press 4. For records management, press 5.
That's it. 5.
For probate, mental health, you have reached the Records Management Division. Please consider searching online prior to submitting a records request. The Orange County Clerk of Court's website contains millions of court records online by using My eClerk for free. For processing times and requests for copies of court records, please visit our website at www.myorangeclerk.com. For information about official records, including liens, mortgages, deeds, and recording a document, please hang up and call Orange County Official Records at 407-836-5115. For birth and death records, please hang up and call Vital Statistics at 407-836-7128.
Was that the right number?
For court records, press 1.
Oh, that's us.
Your wait time is approximately 10 minutes.
Oh, my goodness. No. Okay, here's a problem. If they have copyright music on the hold music, I can't play it on my channel. I have a dilemma. Okay, so here we go. I can't. I'll plug it in once we go live, but I can't play the music on my channel. Oh man, let's. The music's good. Oh, it's another. They're suggesting me to go back and do the other things that I didn't want to do, like go online. They're putting another plug for marriage licenses in. Carol, thanks for the warning. I went online. Here's the problem, G. Smith. I've got the documents. I've gone online. It's where is it? It's somewhere. Let's see. Where did the document go? I'll find it. So I went online and the document is incomplete. It was scanned improperly. So I sort of I'm at the mercy. If I go back online, I just get the same improperly scanned document again. Many of our services can be accessed on time. Hang on. I'm going to say what he says, okay? For example, you can make payments, also find out about payment plans and make other payment options. You can view court records and order certified court records and licenses. From our website, you can also begin marriage license applications and even order forms and packets for civil and family matters. You can also file court documents from the Florida Courts e-file portal, and you can contact us with a question or concern from our Contact Us page. All this can be done from our website at myorangeclerk.com. That's myorangeclerk.com. Thank you for your patience. A deputy clerk will assist you momentarily. Okay, so that's what they're saying. And then I got music again, or Muzak. Yes, Muzak is more accurate. Anyone else want to get married to SB? No. That's not why we're here. We're just here for the records. This is Florida taxpayers' tax dollars at work that we're wasting here. This has to do with the suitcase trial, Annie. Yes. What happened was the defendant in the suitcase trial in Florida. Oh All of our service representatives are still busy. For faster service, please visit our enhanced website. See, they don't have an option for, report a problem. All right, so I'm trying to listen and talk at the same time, and it's not very good. But yes, as we wait for Gwyneth Paltrow's case to start, which I'm going to put up on the big screen here, just 1 second. Here we go. The letter we have on the left side of the screen, that is a new letter from Sarah Boone. That is the suitcase murder trial out of Florida, which should be having a hearing tomorrow. Okay, there's supposed to be a hearing tomorrow. The court just published this document, which they got earlier in the week. Actually, they got it at the end of last week. They just barely scanned it in. But they only scanned in the first 2 pages and the cover envelope. So we're missing the remainder of the pages. And I'm not sure how many. She didn't number them, which she normally does. Let's see, is that page 3? Yeah. Anyway, so we're trying to get the rest of the letter. I'm sure she has a copy, which we might be able to get one from her, but I was hoping the court could do it. So we are waiting right now for a couple things. First of all, the Florida courts to come through. Box source 1, we're going to switch to this guy right over here. And we'll get that set up so it's live. Okay, that's supposed to start in 53 minutes. So we still have an hour before that kicks off. So we'll switch back here. It's still hold music. That's because they don't want people like you calling in. It's not like the court reporter could do anything. It's what's in the system and what's in the system. I hear that, Mustang, but at the same time, if these documents are destroyed too soon, they might throw away what is important and should be filed. So I'm notifying them of an error, a court error, that could end up in a mistrial or something. I don't know. Can I make it sound important that way? This should be extremely embarrassing. Not just embarrassing, it could end up on his official reprimand record. Clerk scanned 1 and 3. Page 2 is missing. Okay, did I see that wrong? She didn't scan the back then? Let's see. So page 1, that's the first one. The minimum 15 minutes. You're right, page 2 is missing. Page 2 and page 4 at least. They only scanned one side. Okay. Yeah, I think it was a double-sided error. I thought this was a person. They're telling me to go to the website for faster service, but it doesn't have an option on the website for this. Sarah Boone's writing is actually some of the best writing I've seen from an inmate as far as letters go. Very consistent. You have to realize everything she does well, according to her. And the writing is not bad. I'm not complaining. It's better than mine. That's what I'm saying. I think they just need to be notified of it. They probably still have the record. It hasn't been destroyed immediately. No, it's not a skit. Not a skit. I like her penmanship. That's probably one of her finest qualities that I've been able to find so far. Oh my goodness, Mustang Guy. Last night, the bit about the Gwyneth Paltrow, if you don't hold her accountable for the skiing accident, then you're going to have celebrities molesting children on islands. That was the most rapid escalation of from here to crazy I've ever seen in my life. Just absolutely bizarre, and you could see how quick his attorney was like, "All right, you sit down. We're done with you," type thing. Just got here. Did the trial started yet? No, not yet. We're waiting. Let me switch this up a little so you can see. Super source. Box 2 is going to be 2. How about that? So the Gwyneth Paltrow trial is still waiting to have a live feed. We don't have one yet. Comic Sans. She does write in Comic Sans serif. That's her definite font of choice. Yeah, it was horrible. It was nuts. It was bizarre. A+ in writing, F in hide and seek in gym class. Lee says, my mouse pad arrived today. Can we get that on a hoodie? Yes, I have it built on a hoodie. I just don't know. I have it built on Teespring. And it's actually put together and available, and it's cheaper than the other option that was going through Printify, which I like. And I just don't know if I can sell straight from Teespring or if I have to sell it somewhere else. So let me look. Let me pull that up here. Okay, Teespring. Let me log in. Here we go. Yes, my name is Scott. I'm trying to get access to a document that appears to have been scanned improperly. It's missing 2 of the pages. How would I report that?
Okay. You would need to email the records department back to let them know that.
Okay. So
or come into room 150.
I'm a couple hundred miles away. I'm up in North Carolina trying to get this. So do you have the email for the records department, the contact for that?
So it's a form you fill out on our website at myorangeclerk.com. You would just click on Contact Us and go to Records, and you can email them there and include your phone number. In the message area, you can request a phone call.
Okay. So you're telling me the message that I've been listening to over and over waiting for you is actually what I needed to do all along. Is that what I'm hearing? Thank you very much. I appreciate that.
No problem.
Have a great day.
Bye-bye.
Bye. Okay, I'll admit when I'm wrong. Okay, I'll admit when I'm wrong. And apparently online is what I need to do. So we'll take care of that. Or does somebody, I'm not sure. Amber, do you want to do that email? I know you're a document hound. You've probably already got one drafted. I'm not going to throw you under the bus, Amber, if you're busy. So, but okay. So, what if we have no internet? Yeah, that I should have asked that question, but I don't want to pretend that I don't. Yeah, email the records department. I tell you, I emailed the governor of Florida. Oh, sorry. Sorry, Dilly Pickles. I accidentally called you on accident. My apologies. It was a pocket dial. I set it down and I hit your button. All right. We could have went to room number 120 or something, Melissa. Yes, we could have gone to room number 120, which is just a hop, skip, and a jump down the road. Could have just booked a flight and been there later this afternoon. Okay, so super excited about that. Hopefully we'll get the rest of that letter, get that cleared up. Okay, no crank calls, no crank calls. I believe crank calls might be a crime in some areas. So I would be very hesitant because the Federal Communications Commission doesn't mess around, the FCC. And if I'd make an interstate crank call and break a law, suddenly I'm gone. I did email the governor. I actually put in a request. I talked to the governor's office himself. And somebody says, can I get a link to the mug? Scott Calvin. Yes, let me... I can actually put it in chat. It's easiest to do that right here. Anytime you want the link to the mug in chat, you can just say ! Mug, and it will respond with the chat. It might be hard for me to get it from there. Let's see. I'm sending a quick text here. That's why you're hearing the click, click, click. That's how fast I type. Posting now. Okay, there we go. So now I'm going to put that in chat for Scott. Let's see. Can somebody put mug in chat again for me? ! Mug. All right. Where are we at? We need to catch up with all the questions and stuff. What were we talking about? As far as what we expect today, in the first of all, the Gwyneth Paltrow case will be over most likely today. It's going to be, yes, thank you. That's how we get it right there. Here's the problem. I don't want to calling the attorney. We've tried that on previous cases, Amber, and the problem is the attorney has an attorney-client privilege, and basically, other than saying I'm their attorney, there's not much they can tell us. So it would all be a one-way conversation. It would be thank you, and hang up. That would be it. So it's sort of like talking to a wall, and you never know if they got the information or if it just went straight in the circular file. But what we do know is that this letter that this is copied to the judge. This is the judge's copy was scanned in improperly. Mr. Bankowitz has a hard copy mailed to his office. Okay, so he's already got the copy and all the other copies beforehand. This is the judge copy that he just keeps for the records. Let's see. Sarah Bailey tomorrow pre-trial conference will tell. I'm guessing from the letter, no. I am surprised. I'm surprised that she wouldn't be at the pre-trial. With this being the last pre-trial, she has requested to be present for all of them. Supposedly her attorney, it's sort of like I think he's contacted her the bare minimum and said, hey, I'm calling you, we've talked, and then hung up type thing. It sounds like he's told her, no, you can't be at any of the pre-trials, which I think she has the right to be at, and that may be a problem, especially if she's making any sorry, I got sidetracked. Squirrel. I'll turn your sounds back up for a little bit. Sorry, that'll help me keep focused. I think now I don't remember what I was saying, but I think he told her she can't be there, and she should be able to be there. Okay, home, stores. Let's see.
Alex stole it.
Yeah, Alex stole it.
I was
okay, so
back taking it easy.
On Teespring, I think I have to connect a domain. No, I can just view the store. Wait for it. Okay, I think, let me give you a link. How do I share my link? I think this is it. Let me post this in chat, and if I'm giving away my the back end access to the store, then so be it. But this is what I had come up with on to the post. There it goes. Okay, so can somebody click that and see if it works, if it goes to the right store? This link right there. I'm trying to find a better way to get you hoodies without the added cost of selling through eBay and the percentage they add onto it, so we can get it in the right price range. But it does. It's a good link.
Alex stole it.
Okay, that's all I had. I just had the two hoodies. I think that's the two quality of hoodies they offered, so I'm not sure. I will say I have not tried these out yet, so I don't know if they're any good yet. I've heard good things about the store, had good recommendations to use that, but that's it. All right, it's been a fun morning. Let's see where we're at. Let's get rid of Sarah Boone's letter.
Let no dead horse go unbeaten.
Let's go to a 2-box here, like this. But I'm going to be in one of the boxes.
I'm not a cat.
There we go. Now she's in the way. Okay, so we'll wait for the TV over my shoulder here to pick up the live stream in just a little bit. All right, her lawyer won't talk to her about what they've done for her. Might open the door for their privilege. It's proper for them to not release their own statements to anyone but the court. But Mr. Upper-Torso, this lawyer, Mr. Frank J. Bankowitz, has already previously been reprimanded by the Florida Supreme Court for failure to communicate with the clients. He's also been reprimanded for failure to pay taxes and on his employees and that was taken care of. But he's got 2 black marks on his books already. And the judge in this case as well has sort of said, hey, I'm ordering you to meet with your client because your client keeps writing me letters saying, where's my lawyer? Where's my lawyer? And so it's a bad situation, I think. He really should talk to her a little bit, although I know that the client does not control the lawyer, right? The lawyer is a professional. Just like when you go to the doctor, you don't go to the doctor and say, I need you to do this and this and this and this. The doctor's like, look, you show me the symptoms. I'm going to decide the best course of action. If you don't like the best course of action, maybe you need a different doctor. But I'm the one doing the treating. I'm the one that does everything. You don't control everything. Same way. The lawyer's the professional. They decide what to do. They don't necessarily do everything you want, although the client has some decisions they can make that the attorney has to stick with. And there are some that the client makes on their own, specifically whether or not they testify. The attorney can provide advice on that, but it's all the client's decision. Good morning, Brown Barn. All is well. Hope all is well with you as well. We did reach 10K yesterday. It was an amazing party. I need to turn off the party horn here before it gets crazy this morning. So you've got like 10 seconds to use it a little bit more before I mute that. Here we go. Let me see how fast I can get to it. See if I can stop people from. Let's see, where's the command? All right. I beat it. None of you can use it anymore. It's gone. Party is gone. Party is over. No more partying. Zero party, sir. Zero fun, sir. What's that movie from? Zero fun, sir. There we go. Okay. Yeah, you guys were so close. I see it. It's a little bit of a delay. Boo. Here. I'll do one more, but I'll trigger it from my end, just for you guys. There we go.
Back, taking it easy.
Let's see. What I find to be most amazing in this trial is that the plaintiff counsel asked the defense expert, "What percent of work do you do for the defense?" And the first question is. That is the first question I ask in a deposition. Yeah, so James, 100%, twice they got that. They're like, you're always on this side. Okay, you've got something against people that are suing for damages type thing. And they're like, nope, this is only 20% of my work. And twice he got that answer. And he's like, you need to know the answer to the question before you ask it, especially if you're trying to make a huge impact. And with that big presentation, it really pops the air out of your balloon pretty quick if they answer the other way. I'm a party pooper. Sorry. Yes, anything about BK? Wanted to talk about BK because although we have limited information, what we do have could be substantial. There was news that broke that the prosecution was informing the court and the defense of some possible Brady, or I think they call it Giglio. Is that it almost sounds like gigolo, but it's Giglio. It's got 2 G's, Giglio. Giglio. I don't know what it is. But they've got information that could be beneficial to the defendant that they have to provide to them. It's information they probably could have found out on their own, but had they found it on their own and not been disclosed, big mistrial. Boom, case blown up. The information has to do with one of the police officers that was involved in the investigation of BK. We don't know his role. We don't know if it's, honestly, I don't know if it happened, which state it happened in, if it's in Idaho, if it's in Washington, if it's, where was it? Back east, Pennsylvania, was that where he was? Or anywhere along the way, where he got pulled over. We don't know which officer it was, but one of the officers that was involved in the investigation at some point is currently under investigation for some type of improper conduct. And this could be something, some of the examples I saw were, imagine you have an officer doing a lineup of witnesses, and you have 3 witnesses, and 2 of them identify the right person, and the third one doesn't, and the officer only reports the 2 that identify the witness, not the one that doesn't. That would be a major issue. It could be something like that. It could be that he has prior cases that are now being overturned or appealed or have been overturned because the officer planted evidence and something as egregious as a very deliberately in trying to influence something to get a conviction wrongfully. So you could have this whole scope of things. It could be that he stole money from the petty cash drawer, or he stole evidence. It could be all sorts of things. But in this case, he was involved with the BK case, and he's under investigation. It's the right thing to do. It's the law, and it's also the right thing to do to tell the defense about it. And the defense, obviously, they come out and they say this could be a deal killer. They're blowing it up. That's what they want people to think. They want it to be bigger than it is. I don't think it is. I think if it was a deal killer, it would be a bigger issue. We'd see more action from the courts. We'd see more things. I don't think it'll be a deal killer. It might prevent some evidence from coming into trial because of this person. Brian Koberger is BK. Yes, he is. We're talking about the Idaho 4. That's all I know about the latest from that. So as it stands right now, BK, Brian Koberger, he was the person who was accused of stabbing the 4 college students up in the Idaho dorm. We know there's a witness that saw him. Okay, there's still a lot of evidence. They've got DNA evidence on the scene. At the scene, they've got all sorts of surveillance evidence. Both during the event from security cameras and after the fact from their search warrants with the geofencing, the cell phone, everything like that. So they've got a ton of evidence, but it's possible that a piece of evidence might be thrown out or might not be admissible because of this officer's involvement. Hopefully it's not a key piece. All I know other than that is that he still has not waived his right to a speedy trial. So this could still go to court this summer. We could see BK, facing charges in the court with a jury trial very soon. He did waive his right to a speedy preliminary hearing, only so that his lawyer had time to review the documents, everything that was against him. I think I don't know what the next date is for that trial for the next hearing, but it's probably going to be here, fairly soon. And then we'll get more information as far as the timeline of the court is going with from there. Let's see. Samantha Terry, I don't know what to do. Here's what I'm going to do. I'm going to remove you as a mod, and then I'm going to put you back as a mod and see if that helps. Okay, so let's see. I've removed you as a mod. I'm going to try to fix your magic wand here. You might have to say something again as a non-mod and see if it gives you all the magical privileges that you just so desire. Waiting for Samantha. Let's try this here. There she is. Hi, everyone. Ooh, I just saw something. Hang on. It's something else. Add as moderator. Okay, so you're back as a mod. Amber, I think I can fix the problem we were having with your account with what we wanted you to be able to do. Hold tight for just 1 second. Are you in here with us, Amber? Or are you still sleeping? I think she's sleeping. Squirrel. All right. We'll wait for that. Habit fishy shirts. You talking about my shirts? Love these. Sportsman's Warehouse. I get these ones at Sam's Club because I'm cheap. And they're awesome. They're ventilated on the back. They have this big, mesh pocket on the back. Fantastic. This particular one is long sleeve, but I roll up the sleeves. I have several in short sleeves as well. Good morning, Lisa. Good to have you here.
Are we going to address subject matter jurisdiction?
Subject matter jurisdiction. We probably should. I was looking at there's some California court stuff that's coming up. I was curious, and it's not high on the radar. But I was looking at that, and California has some very, very aggressive laws on the books about recording video from the courts in California or rebroadcasting video from the courts in California. And I know several other states have that as well. And some of them are sort of just like whatever. California goes for it. California thinks that they have subject matter jurisdiction over everyone who views or listens to the audio from a courtroom. And I'm curious to find how someone else has found them to be trying to do what I do. I'm a big fan of open courtrooms. I think that the public view inside the legal process is important for making sure we understand that the system is fair. and just that oversight is, the same reason that Congress has oversight over different things. I think the public should have oversight over the courts through public access, and I think what we do provides an important part of that. California does not think so. California thinks that you should not be able to see what they do after the fact. No one should be able to record it, rebroadcast, share it, save it, anything. So I might need some help there if anyone has some information that could help me on that part. Mo says, already having a bad day to cry from frustration. Just need to scream and need my good morning from RA. Mo, good morning, Mo. Good morning. It's Thursday, okay? We are so close to the weekend. So close to the weekend, my friend. Just hang in there. Here's what I'll tell you. Usually when I'm looking at something that's really awful upcoming ahead of me, almost always it's not as bad as I fear it to be. Okay, almost always it's a little bit better. And generally it passes faster than I think. And looking back, there have been some pretty horrible experiences that now I look back and I actually grew from. Like, I'm sort of glad I went through that. I wouldn't want to do it again, but I can see the benefit that it is to me now. Mo, I don't know what you're going through. If you are sick, on the other hand, I am hoping that you can just get better just as quick as possible and get back to full activity in whatever you want to do. But there's your morning. Let's see. Ask Emily D. Baker. She practiced in California. Yes, she was in the DA's office, right? I have to ask her. EDB. I'll put a contact out to EDB. Let's see, Perfectly Imperfect Lisa says, I watched your video about recovering the gold coin last night. I hope you got a picture with the gentleman with his coin. Cool story. I did. The family is very private, and so I've agreed not to share their family pictures beyond what they've given me a permission to share already. So, but that's cool. BK's only way to is right to a speedy preliminary hearing, not to a speedy trial at this point. Correct. My motto for life is, this might not suck. Look, the glass is half full, right? Can't see comments. That's my fault. They're back. Thank you very much, Maggie. I'm way behind in chat, too, so you haven't been able to see for a while here. I apologize. KQD, light skiff of snow on the grass, but didn't stick anywhere else. Thanks to Weather Watch for that. Thomas, thank you. Thomas sent me a document the other day, a PowerPoint. With a collection of screenshots from the show, of key moments, of reactions. My wife and I had a good laugh watching them and remembering the different moments. So thank you very much for that, Thomas. Appreciate it. Thomas is also my podcast partner, which tomorrow night, I don't know the time we've agreed on yet, Thomas. It's 8 or 9. Tomorrow night we're going to do another podcast. I've been looking at getting ready for that today. Going to start putting some stuff in our rundown for that. But it's going to be a lot of fun. Hopefully you are all able to join. It's held on this same channel, but soon we're going to move it somewhere else. Chat looks great on Microsoft OS. Awesome. Good to know. BK Murder was pulled over in my county on Highway 70. Crazy, just crazy, Mustang guy. Yes, that's bizarre. He traveled across the whole country, left to right, pretty much. So that's amazing. Can't wait for arrests on Stephen Smith. I'm hearing Buster is getting prepared. I don't know about that. I have not heard any evidence against Buster. I realize there's a lot of allegations, but I haven't heard of any evidence against him. I know he's come out with a statement saying he's not involved, and sort of with a legal front to that, I'm not involved, so I'm going to sue anyone who says I am type thing. Obviously, that's going to work its way through the system, but it'll be interesting to see. There's already been changes there with Stephen Smith's cause of death, the death record being changed to homicide. That was important. Let's see, storm chasing tomorrow night. That sounds like a blast. Do you do photography or just video or what? I'm curious. What time is the podcast? I think it's Weather Watch. Help me here. Are we doing 8 p.m. or 9 p.m. Eastern time? Are we planning to cover Wisconsin versus Allen Brown after? If we do, it's going to have to be catch up because we're going right now. The trouble we have with that one, John, is that it's an animal abuse case. That's I know. I realize he shot some police officers, but the case is animal abuse. The police officers, I believe, were shot in Chicago, and this is in Wisconsin. So we've got some issues there. Animal abuse cases are very hot topics. We have a lot of us who have a very soft space in our heart for animals and have expressed to me that they just would not want to watch something like that. Now I realize in that case, knowing that the police dog involved survived the shooting and is still in service, made a recovery, has appeared in court, was actually there in court. That's good stuff. I'm going to look at this once this case is over and see if I can present that in a way that I think would be appropriate without causing a lot of distress on our channel, and we'll see. But it might just be a video after the fact where we skip through some parts and do some highlights. But haven't made a final decision on that one, John. What time will hearings and trials start tomorrow? I have eye surgery in the morning. Mary Kay, today may be the last day for Gwyneth Paltrow. So it depends which case we go to next. We have, there was a hearing I wanted to cover from the math teacher murder that happened yesterday. So we want to see where that's going, and we might cover that. That's only about an hour hearing, so it might be a short live stream tomorrow as we just cover some stuff and catch up on things that we've missed. But that's it. Let's see. Haven't heard any direct evidence against Buster either. Just his name mentioned often in his case file. Lots of momentum in that case. Yes, tons of momentum, tons of interest. 8 p.m. tomorrow Eastern Time. Thank you, Weather Watch. I wanted to make sure I had your agreement on that. But podcast will be here on this channel at 8 p.m. The easiest thing to do, obviously, is to hit the subscribe button and then ring the bell, and then you'll get notified when we go live. It lasts about an hour and a half, depends on how much we want to talk. But it's always a good time. I absolutely love it. Thomas is an amazing podcast host to partner with. Just a phenomenal guy all around, and just hanging out and talking with him. To me, I'd do it even if there wasn't a podcast. But just glad that he's is willing to do that in front of everybody and share that with you. Yeah, a lot of people have said that these same sentiments, Abby, that the animal abuse trial, because that's the main component. I think if it were one of the charges on a bigger trial where there was a lot of other stuff, we might consider it. But I'm leaning to no, we're not going to cover that one. Did you hear that both of BK's sisters were fired by their employers due to their association? Wrongful termination. Yeah, that's an issue. It depends, of course, what their business is, what work they were in, but I'd have to see what the state laws are in Pennsylvania if that's where they are. It's like some states are able to fire you for whatever reason they want without notice. They can just fire you. But if they gave the reason and said, we're firing you because your brother is a murderer or accused murderer or something like that, that might be an issue. They might have a nice payday coming towards them. Yeah, the dog is amazing. The dog's really amazing and fortunate as well. But Alan Brown case is wrapping up today, so it's basically 2.5 days of testimony. I can say the worst part is the dash from the canine cop car when they start driving to the vet after. Yeah, that would be too hard to watch for sure. The Paltrow one is ending up today as well. We're finishing that here. Well, let's see, how long do we have? It's going to be live in 22 minutes, so we're going to be back here shortly on the Paltrow case. It's weird how we can deal with people being killed when it's animals getting hurt. We can't deal with that. Yeah, I don't know why we are the way we are. The Friday night show is a lot of fun.
Dead horse go unbeaten.
He did kill 2 people, Judy. You're absolutely correct. I think he killed 2 police officers. But that trial is going to happen in another state because that happened in Chicago. And then there was a police chase. I'm not sure how closely these two are related. And then in the police chase in Wisconsin is when the police dog got shot. And then they took him into custody. Somewhere in the landfill, a seagull is eating fuzzy pickled eggs today. I hope not, because that seagull will probably never eat anything again. Those eggs were so bad. Wisconsin needs no cause for termination. Yeah, most states are like that, but if they give a cause, and it can still be wrongful, even if you're a no cause state. What do they call that? I know Utah's the same way. It's like a right to work state or something. Jill says, hi, RA. I've been here since DB, but have never spoken. I will not be here for the police dog, though. We're not going to be there for the police dog for the reasons I've listed. But thank you, Jill. Thank you for popping in chat. Turn on your gift receipts option and see if you can win a membership. It would be awesome. Love to see that. I watched your uncle's recap on Speed this morning, and Owens showed over 50 photos, I counted, of Sanderson's good life post-accident in about 10 real-time minutes. Boom. Red Pen, I asked in chat, was that impactful for people? And everyone's like, yes. And here's the problem. He is claiming he's had this loss in his life enjoyment, in what he's able to do and in function, and he's got this huge dip. We haven't seen the evidence that he was that high before. We haven't seen anything that really convinces us that he was able to do 10 things at once instead of just 5. And now that he can only do 5 things at once, it's hard for those of us who can normally only do 1 or 2 things at once to say, yeah, you're seriously suffering. It's just hard to make that connection. I don't think the jury can get there. I don't think they can say, yeah, this guy, this poor man, he's a shell of a man left, compared to what he used to be, because there just hasn't been that convincing testimony that he was just, Superman on steroids. It's not there. And so when we see that he has lived most people's bucket lists in the last few years, that's very wow. It sounds like he has everything he wants, and he's loving it and laughing all the way to the bank, and as he jets around the world. Kevin says, I haven't watched the podcast on Fridays. What topics do you talk about? Kevin, we sort of do a little more open forum, but it's a lighthearted podcast where we bring up news stories from around the world in the U.S. that are sort of interesting. Sometimes we talk a little bit about trial, but it's less trial focused and more just funny news and little tidbits and a little top 3 type things. It's just a lighthearted channel. I think the feed just went live. So we should have, yeah. The camera's still not focusing on me. Let's see. There, I'm in perfect focus right now. Is that better? My son just came in and said it's not in focus. So yeah, the podcast is just a fun little update, get together, hang out, and it's done live. So just like this, you can ask questions. We'll ask you questions. We ask for your input. We say if you find a funny story in the news or something like that, send us a link on the burner phone. And obviously, if we select your story to share, we're going to give you all the credit for tipping us off that way. Giglio. Line on the stand, pronounced Giglio. Thank you, Alpaca Renee. I will commit that to memory and not accidentally say gigolo again, because that's completely different. Also not good for an officer to be involved. Name is Mud. Nothing graphic with the dog watching it. The most testimony and body cam of him shooting towards the dog. If people want to see the case, they should on their own. Quick case with no defense. It's no defense? Wow. Let's see. The evidence is that he was a B student and he was high functioning 20 years ago. But weren't we all? Yeah. Seriously, I don't get it. I don't see the loss. I don't see. Maybe he's being compensated for the stuff he's recovered from, and if he did fall, there could be a small settlement. I think they're not asking for the medical costs of recovery, because that was all paid for by the VA. I just don't see this. Even if it goes this way, I don't see him getting $300,000. I think it would be interesting if the jury does side with Terry and awards him $1. It's like, yeah, you're right, but you don't deserve any money. That would be interesting. Bama Girl says, good morning to everyone. Thoughts and prayers of the families of the 101st Airborne Black Hawk Division. Oh my goodness, I saw this. 9 airmen lost their lives last night during a training mission near Fort Campbell, Kentucky. 2 helicopters, I understand, went down. Just heartbreaking. I've got some extended family that are connected with the military, especially with helicopters, and I saw that and my heart just sank. That is horrible. Thank you, Bama Girl, for letting us know about that. Definitely with you on that one with the 101st Airborne. I think it's natural aging process. Sadly, I think I can do things I did at 18, but I can't. Right to work involves your right to not join a union in order to work. Yes, I think Utah is a right to work state. You don't have to join a union. They can't force you to join a union. But also, the part I was actually getting at, it's not really related to the right to work, is that Utah, they can fire you for any reason without notice type thing. At any time, they can fire you. It's one of the best states to fire people in, I think. Let's see. Pictures of TS were good, but went on a little long. TS just getting older, diagnosis, old age. What was the big deal about, he's like, I did not go kayaking. I did not go kayaking. It's like, okay, there's a kayak in the picture and you're trying on a kayak helmet. He's like, yeah, but that was for something else. I'm like, why didn't they focus on the times he went 4 times that he went scuba diving with a brain injury? He's got a history of stroke. The whole thing with his eye, and he's going scuba diving with the pressures and the changes. This is like a recipe for death. Yeah, it was just, I guess they didn't have pictures of him underwater. Matthew Harris says, I used to be stationed at Fort Campbell. I spent many nights jumping out of those helicopters. Sad day, waiting to hear if my buddies are safe and accounted for. Matthew, oh, I'm sorry. Heart goes out to you and your friends. Hopefully that that your friends are safe, but really for those 9 members of 101st and their families, just so hard. Doesn't right to work also mean they don't have a minimum wage?
Okay. Defense?
Yes.
Okay. So are we on the record?
Yes, we are.
Okay. Calling the case of Sanderson versus Paltrow. Attorneys are all present. We're here for some matters outside of the hearing of the jury. I believe the defendant has now rested. Did you resolve the exhibits yesterday?
They need to look at them
Yes,
we kept going. Do we have the indexes?
Jody has ours, but I have to print it out.
Why is he tearing up the paper?
We do that. Okay, so I'll tell you what we did is we pulled a bunch of exhibits, narrowed our index, but you need to go through them, and I wouldn't mind thumbing through theirs really quick too. So the master copy that goes to the jury is the one that said judge copy, actually. That's the one we worked from last night.
Okay.
And I think
We need to redact.
and there, Mr. Sanderson's address is on a few that we need to black out. So I think that actually needs 5 more minutes of work.
Okay. And
but I think we're close.
And so you're not ready to rest until you receive those exhibits? Until the court receives the exhibits?
Yes. But again, I think we could stand right there and do one last thumb through.
Do you have the list of exhibit numbers for the record?
Yes. And I think, did I understand Peter just emailed you that? And
I do have them. I mean, I have the list.
but I
Sure,
always
guys, they're
wanted to
early.
make 4 hard copies of everything. So, and is the plaintiff's counsel on that list? The email you just received from Peter?
Yes.
So I want to make sure there's no funny business here. One of the things that we inserted.
Shirt guy's like, yeah, front row seats in the corner.
Which I don't think was clearly done. But there were a few of these before and after things addressed by Dr. Black. And we marked them as 101.
Well, Men in Black just left.
G, H, and I. And those were not in the binder, and I couldn't remember. I would like those to go back to the jury, but I can't remember if Your Honor already ruled on that issue.
I mean, whether they were admitted? Well, anything that's on a poster would be only demonstrative.
Right, and this would be on a little piece of, a regular piece of paper.
Yeah, I don't think there were small versions of any of the poster board stuff that were received by the court.
Okay. And so we may need to strip a couple things off the bottom. Was it clear, for instance, like Mr. Sanderson's history, pre-collision medical conditions? Was that going back to the jury, or it's not going back?
No.
All right, so we still have 5 minutes of adjusting to do on that.
Okay.
A directed verdict motion may be made at any time, and
okay,
we're ready to do that right now. I don't think it'll be affected by the exhibits.
All right, great.
And just for the record, because I think it'll speed things up if we can.
Sure, Mr. Bueller. I guess whoever's going to make the motion, why don't you go ahead and proceed?
Sit down and just make those, or would you like me to stand up?
Why don't you come up here so I can?
Okay.
So you can bop you behind the ears.
Thank you, Your Honor. This motion is a motion for directed verdict on Ms. Paltrow's claim for attorney's fees.
She's really quiet.
Under Utah Code 78B5-825, attorney's fees are only available in Utah where there is an action or defense in bad faith. In civil actions, as you're aware, Your Honor, there's only attorney's fees to a prevailing party if the court determines that the action or defense was without merit and not brought or asserted in good faith. These are two independent requirements. They have not been met in this case. As the court's aware, we filed a motion for summary judgment earlier on in the case when Your Honor was not the presiding judge. That was denied based on questions that the judge had regarding the press conference that was held. And so what I want to talk about first is the standard for the court to utilize in the bad faith statute. It is narrowly drawn, and it's not meant to be applied to all prevailing parties in all civil suits. An action or defense is without merit if it is frivolous, if it is of little weight or importance, having no basis in law or fact, or clearly lacks a legal basis for recovery. A finding of bad faith turns on a factual determination of a party's subjective intent. A party acts in bad faith when he brings an action or defense and either lacks an honest belief in the propriety of the activities in question, intends to take unconscionable advantage of others, or intends to or has knowledge of the fact that his actions will hinder, delay, or defraud others. So therefore, Your Honor, an unmeritorious action, if that's how this turned out, and who knows, that's up to the jury, an unmeritorious action may still be in good faith as long as there is an honest belief that it is appropriate and as long as there is no intent to hinder, delay, defraud, or take advantage of the other party. That's what's key in this particular case, Your Honor. As the court's aware, the reason for awarding attorney's fees based on bad faith is to punish the wrongdoer, not to compensate the victim, and that fees should therefore only be awarded upon specific evidence of bad faith. There is no specific evidence. There is no evidence of bad faith in this case. This is clearly a he said, she said ski accident. We've heard the testimony of witnesses, of eyewitnesses. Mr. Sanderson had an independent witness that saw the accident. There were also experts who have testified that because of the location of his rib injuries, that he had to have been struck from behind by Miss Paltrow. There's clearly, and obviously the defense has their own side of the story, but there is clearly a evidence-based support for his claims in this case. Further, his damages. The damages are clear. There's no dispute that he sustained 4 broken ribs. And then, obviously, there's the claims for the brain injury. Yesterday, there was a great deal of medical testimony that was brought by the defense. They all agreed that Mr. Sanderson was not malingering, so he is not, fraudulently or lying about his injuries in whatsoever. Ms. Paltrow from the very beginning has brought this claim for bad faith and attorney's fees as a weapon to try and compel Mr. Sanderson to dismiss this case. As I said, the summary judgment was denied because of this allegation, this loose allegation that, well, there was a press conference. So we've now heard from the defense. There has been no evidence brought forth by the defense that the press conference was brought to take advantage of Ms. Paltrow's celebrity or that it was in bad faith. In fact, the only evidence regarding the press conference was brought through my questioning of Mr. Sanderson, and he testified that it was his personal injury counsel that held the press conference, that it was their idea, and that the purpose of that press conference was to seek to find witnesses to the accident.
So there was a motion in limine that sought to exclude evidence that related, or I don't remember what the motion sought, but the result of it was an order from the court saying that evidence that relates solely to the bad faith claim isn't part of the jury trial. And so the court was contemplating that there would be, that if the jury found for the defendant, that the court would take additional evidence on the bad faith issues, or those that related solely to the bad faith. Was that your understanding as well? And what do you think? What are your thoughts on that?
Well, I think, Your Honor, that there's been sufficient evidence that has come through through the trial that there is no evidence of bad faith. It's a very, very high standard to meet, and there's so much evidence here that shows it is clearly a he said, she said case. This was not based on Mr. Sanderson trying to have an ill motive. And there's a great deal of case law that I could go into, but I don't want to take the court's time right now on that. I think that the evidence that has been presented has been very clear that there is no bad faith in this case, that they could not prevail on that. And at this point, I really think that a directed verdict on the attorney's fees would be appropriate.
Okay, thank you. Mr. Owens? Do you have, well, first of all, I had two questions. Do you have more evidence, other than what came in here today, to support a bad faith claim? And number two, isn't the fact that your directed verdict motion was denied evidence that there is a basis for the plaintiff's claims?
Yes and yes.
Okay.
That's very honest.
I was precluded from talking about this stuff by their motion, so I can't be handcuffed and then slapped. I need to be able to defend a claim. I specifically wanted to talk about this stuff, but based on Kristen's motion, I couldn't, and now I shouldn't be slapped down about it.
So I would take the motion under advisement, Ms. Orman. I'd like to hear what additional evidence the defense has on the issue.
Your Honor, may I ask when you anticipate doing that? At a later date, or is that today?
At a later date? Okay. Well, I guess it depends. I mean, if...
Not today.
When the verdict comes in, then we can make a decision about when to hear the additional evidence.
That's fine.
I remember raising this issue and said, Your Honor, did you envision then
I remember that.
A later hearing at a time convenient to the parties?
Yes.
Thank you.
Mr. Bueller?
Good morning, Your Honor. On the issue of spoliation, there's a jury instruction, and we believe there's been no shred of evidence presented in this case that the plaintiff had a GoPro video. He denied he had a GoPro video. The only evidence is an email from his daughter who says, "Oh, I can't believe there's a GoPro." And
that was the testimony of the daughter as well, Shay.
Yeah, that's who I'm referring. But that doesn't mean. I mean, it could be anyone that had the GoPro video. Could have been the Deer Valley. Could have been anyone. But there's just absolutely no evidence. It was a mistake, and it would be absolutely erroneous if the court gives this jury instruction, because other than that mention in that email, which
same shirt, same shirts here.
The defense, and there's been no evidence at all brought in this case that there's anything to it, would be clearly erroneous, and therefore we request that the spoliation issue be stricken from the instructions, as it would prejudice the plaintiff on something that has no basis, has not been proven. They have nothing. In fact, the late produced meetup.com comments verify that, because the defense had been saying or implying or insinuating that, oh, the GoPro video must be in that stuff because it was mentioned in that same email chain with the daughter, Shay, and there's just nothing there.
Okay.
Thank you.
Thank you.
Let's see if we
So
can
I'm going
get
to
both
deny
shirts
the
in
directed
same
verdict
shot.
motion on the spoliation instruction. The defense, have you reviewed the instruction? There's a new one that came out, removing the word "the" from the bottom.
It's acceptable.
Okay. And
it's almost the same.
Mr. Bueller,
3 plaids.
I mean, you're certainly welcome to submit or request to the court some additional interrogatories so that it's clear from the record whether the jury made findings under spoliation or not. I think it could track the instruction itself. That way, if there's a verdict that's adverse to your client, you would know whether the spoliation instruction, whether there was any inference taken by the jury on the GoPro video.
Yeah, it gives more credence to the lack of evidence of this. So we'll consider that, and I guess we would have to do that pretty darn quick.
Yes, we would. I think that the daughter Shay testified that when she got off the phone, she thought there was a GoPro video, and I think reasonable inference from that, the jury could decide that there was a GoPro video and that your client had some control over that video. They could make that decision.
Right, but there was no evidence that he had control over it. It was just there was one. It was mentioned, and it means that every time a piece of evidence that's mentioned that turns out to not have any basis, then it becomes a spoliation issue. We think that's an erroneous level of proof. I've got 2 others, or actually, and then finally. Oh, do you mind if I go ahead now, Your Honor? On the,
go ahead, please.
Okay. On the issue of negligence, and I'm going to talk about both defendant's negligence and plaintiff's negligence. On defendant's negligence, at least for the record, we assert that there should be a directed verdict on liability, causation, and damages, and that is based on the evidence that's been brought before the court. Likewise, on the plaintiff's side, on the defendant's side, we should have a directed verdict in favor of the plaintiff. On the plaintiff's side, the charges from the defense against the plaintiff on the issues of liability, causation, and damages should also be brought. And I could summarize the whole case, but I don't think it's necessary. I think the court realizes that. But if you'd like, I could add more detail.
Bueller's Heart's not in this motion.
Verdict motion.
He knows he's not getting anywhere.
The $1.
Yes, the $1 that we would owe you. That's the second one. The first one is a directed verdict in our favor for our damages, liability, causation, and the only issue would be the amount of the damages for us. So I combined them two, so it's actually 2 directed verdicts with 3 subparts each: liability, causation, and damages.
And I have given it some thought, anticipating your motion, and based on my review of the evidence, I would deny both motions with all 3 parts in both motions.
Okay, thank you, Your Honor. Then I have one other. It's not a directed verdict motion, but it's a motion to take judicial notice of Terry Sanderson's life expectancy according to the Social Security Administration life expectancy tables and calculation. This is something that's commonly done. I'll just advise the defense that we're planning to use in our closing reference to the life expectancy of Terry to calculate a per diem. Have you
disclosed to them what number that you plan to use?
Yes, I'm ready to do that right now. It's they change with each day.
Right.
Apparently, Terry's about to die, according to the Social Security Administration.
In principle, does the defense have any issue with that?
Well, He's got 20 some odd health conditions, some of which are impact life expectancy. So I have some problems about it, but it'd be nice to know what they want.
Yeah, we're actually going to go lower than that. Would you like to approach?
Look at his jaw.
10 additional years?
Yeah, just 10 years, even though it says 10.8. It could be argued that Terry's he's a non-smoker.
Doesn't have time
he
to
has
smoke
other health
between drinks.
factors in his favor, that he's conscious about his health, and so we just want to, in closing argument, mention that he has a potential life expectancy of this, and then argue that on a per diem basis for his future non-economic damages. Non-economic damages, as you know, are not precisely derived. They have, it's more of a subjective viewpoint of the jury and the parties' arguments in favor of.
How about to address the defendant's issues with, the comorbidities, let's call them.
They can argue that too.
I realize they can argue that, but how about to address that if what the court takes judicial notice of is that a person who is 76 years old has an approximate life expectancy based on the Social Security tables of 10 additional years?
Yes.
Is it,
Your Honor?
That way I'm not taking judicial notice of the plaintiff's life expectancy, but rather what the Social Security tables say.
Right, Your Honor. And,
or I'll give you 5 as it relates to Terry.
I'll give you 5. I know what they are, counsel. Let me just say this. We don't plan to reference the Social Security tables. It would be just as simple that statement that Terry's life expectancy could be calculated at approximately 10 years. And the past 7 years since the trial date. I mean, it's like taking cognizance of the.
How do I make that conclusion because it involves an individual?
Oh, you don't have to make the conclusion. I'm just.
You just laid it out. I would.
Well, I'm just previewing what the closing argument will mention, and that it's not evidence in the case. It's argument.
If I'm taking judicial notice of it, it is evidence.
Well, I don't think the court needs to take judicial notice, but if the court would like that, we did produce this. I'm just giving you a preview in the defense counsel that we will be making this argument that he could potentially have 10 years of life, and that that's the basis for our damage claim. And then we're not raising it to the level of something evidentiary. It's pure argument for calculating non-economic damages.
Okay. Mr. Owens?
I don't have an objection to Your Honor's approach, which is under Social Security tables, a 76-year-old man is expected to live 10 more years.
And Mr. Bueller is proposing that not what happened, but that they just refer to it in closing argument. I mean, not that they don't refer to any particular table, but they just say, a man at his age, he's probably got about 10 years. Do you have any objection to that?
In its argument. But if the court is inclined to not prohibit the plaintiff from making that argument, then we would ask that the court take judicial notice of what I just gave you.
Okay. They can argue it. They can argue it.
Okay, so you can argue it without any reference to the table or me taking any judicial notice.
Unless counsel wants reference to it or the court does.
If you're going to talk about Terry, I'll stipulate to 5.
No.
Okay, then we'll keep it as argument.
Okay, which brings up a very important point I wanted to raise. There have been a lot of evidentiary objections during the trial that a particular question misstates prior testimony in the case. What I want to avoid is a lot of that kind of objection happening during closing argument. That, hey, he's not saying what really happened here in trial, or he's misstating what really happened here in trial. I don't want to see a lot of that objection during closing arguments, because my reaction will be the same as it has been throughout the trial. The jury will remember what people said. So if you think that the other lawyer or lawyers say things that aren't supported in the record, then bring that up in your part of the argument.
Fair enough, Your Honor.
And so because what I expect you to do with this one exception of this 10-year thing, I expect you to tether your arguments to the evidence that was in front of the jury and any reasonable inferences from them. Not to bring in outside data, not to bring in outside evidence, but just the evidence that was here in this courtroom. Okay?
Just to give you a sample, we would argue that Terry has approximately 10 years left, at least in his life. He's lived a healthy. He's not a non-smoker.
No objection. And there's not any objection to that.
Thank you.
Okay. Turning now to the jury instructions, does anyone wish to object to any of the closing jury instructions that the court put together?
We're reviewing them. I know you gave them to us yesterday. Give us one moment, please.
The only one that we might have a small suggested change or objection to, Your Honor, is the spoliation.
Can you speak up?
Sorry, it's the spoliation instruction that we have here.
Okay.
It's that first sentence. We don't believe that there's been any evidence that Mr. Sanderson was in possession of a GoPro, and so we would want the first sentence to be changed to Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed. Sanderson asserts that the GoPro video of the ski collision never existed. So it would be because there's been no evidence put on that he possessed it. There's been an inference of that, maybe at best, but it's, again, coming through his daughter's email to him.
I think that's a reasonable request.
Because there's been no evidence of his possession.
It's more neutral, I think.
So it would read now.
Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed, period, and everything else remains the same.
Yeah.
Okay.
Any other objections from the plaintiff to the jury instructions?
No, Your Honor, as we looked through them yesterday, we were like that.
Okay. How about the defense?
Your Honor, one thing I noted on the violation of a safety law instruction, the last sentence reads, if you decide that Mr. Sanderson and or Ms. Paltrow did not violate the safety law, you must disregard the violation. And I'm thinking maybe that should read safety law, because in the prior clause, there's no violation.
Thank you. That's correct. And then I did not include the inherent risk of skiing that the defendant requested. Is that one that are you dropping that request, or would you like me to give my reasoning why?
We want it, and we would like your reasoning.
Okay. Here's my reasoning. So the defendants have requested a jury instruction that was entitled The Inherent Risk of Skiing, and they were basing that on Utah Code 78B-4-401 and what follows, as well as the Donovan versus Sutton case, and so the courts reviewed those very carefully. A plaintiff asserting that a statute, and they're asserting that this statute provides support for the applicable standard of care, or that relates to the standard of care in a tort claim. And if a party is planning or is asserting that, they must demonstrate that the purpose of the statute was to protect a class of persons of which the plaintiff in this case is a member. Or the parties in this case are a member, and to protect them against injury or death resulting from the kind of harm contemplated by the legislature. And that comes from the Colosimo versus Gateway case. Further, a plaintiff must show that the law was intended to protect persons in the plaintiff's or the defendant's shoes from the type of harm that befell them. So the Utah Code 78B-4-401, the Inherent Risks of Skiing Act, is not a safety statute as is anticipated to be read through a jury instruction, but a limitation of liability statute in which the persons protected are ski area operators, not skiers. The act is not affording any protection to the skiers against injury, which is the type of harm at issue here. So looking specifically at this instruction as it has been submitted to the court believes that this inherent risk of skiing proposal, this jury instruction proposal, circumvents the proper application of the elements of a cause of action for negligence to the extent it allows the jury to reach a result without following the principles set out in the usual negligence instruction. It also creates a substantial potential for confusing and misleading the jury. A jury could rely on a more general understanding of inherent risk of skiing and that it is simply an unfortunate and unavoidable injury-causing event for which there is no responsibility, even though under traditional tort concepts the accident was caused by negligence. Compounding this confusion is the implication that the inherent risk of skiing constitutes a second ground of non-liability. An instruction carries a substantial risk. This instruction carries a substantial risk of diverting the attention of the jury from the primary issue of negligence and has a significant chance of creating the impression in the minds of the jurors of a second hurdle that the plaintiff must overcome if he is to prevail. This instruction creates a spurious additional issue in the case when in fact the sole issue is the presence or absence of negligence proximately causing the accident. The jury is faced with complex, conflicting, and less than compelling evidence, and the imprecise rules of causation and comparative fault create a significant temptation to abandon a rigorous application of the instruction and the elements of negligence and the burden of proof and return a verdict based on the simple notion that an accident was an inherent risk of skiing or somehow unavoidable. Apart from the inherent confusion, the instruction tends to reemphasize the defendant's theory of the case that the defendant was not negligent. To that extent, the instruction then constitutes an inappropriate judicial comment on the evidence. Of course, there are collisions caused by the inherent risk of skiing for which the defendant or defendants are not negligent. In such cases, if supported by the evidence, the defendant can certainly argue that they were not negligent and that the accident was the result of an inherent risk of skiing. And I think that would be an appropriate argument in this case. So defense can certainly argue inherent risk of skiing. There's been evidence of inherent risk of skiing. They can argue that neither party was negligent and this was purely an accident, and that neither party was negligent. But in terms of the court reading the instruction, those would be the reasons why I've declined to do so.
Your Honor, I actually misspoke earlier. I think I've got one thing that I just noticed to other instructions if we're ready to move on.
Sure.
On jury instruction, page 16, mitigation of damages, I believe the second sentence, it says any damages awarded should not include those that could have, and I think, been avoided needs to be added in there.
Thank you.
Thank you.
Do the defendant have any other exceptions they want to take to the jury instructions?
Yes, Your Honor, thanks. Yesterday, are you okay if I sit here?
Sure.
Yesterday, Your Honor granted a directed verdict on behalf of the defendant on the issue of post-collision hit and run. Help me if I'm missing something, but we previously provided to the court the defendant's proposed instruction 45, entitled Gwyneth Paltrow did not hit and run and flee the scene. I have a copy. It's marked up if you want it.
I've got it here.
Orange shirt guy is holding up the wall of the courtroom just to make sure it doesn't fall.
The denial of the directed verdict it doesn't use the word hit and run, and what we talked about yesterday was post-impact or post-crash conduct is still relevant to the...
Yeah, the failure to render aid portion of the ordinance is still being read. It's the failure to give a phone address and contact information that was directed out. So if you have an instruction that relates to that, I'd be glad to consider that.
And it also included Dr. Goldstein's testimony that was also the basis to demonstrate the availability of the post-crash actions or events.
So do you have another instruction that's more closely tailored?
I think the first sentence of the two sentences. So Your Honor chose to split the issue, and this is the heading. So the first sentence is what we want. I have already determined that Gwyneth Paltrow did not hit and run and acted maybe that's the extent of it.
Your Honor, I think that's inappropriate. It's preloading an issue that what isn't an issue. It's not something that we're asserting, and there's the motion in limine stands for, and we think that we could put in a lot of things on both sides that are at this stage irrelevant and distracting. And
there's been
prejudicial.
There's been evidence as well as argument, opening statement and cross-examination implying that the defendant left the scene without giving, in violation of some ordinance or some requirement that she give her contact information. So what I could read is that I have already determined that Gwyneth Paltrow did not leave the scene of the accident without giving her contact information.
She's there. She's behind the glass.
That's reasonable, Your Honor.
In back. That glass window, you can see her standing up in there. You can see the outline. It's not a reflection. It's showing through the one-way glass.
Any other, from the defendant, any other exceptions?
Yes, Your Honor, and you did rule on this, so I don't want to irritate you, but Deer Valley's Resort's dismissal, I do like the words "for no payment," and this was previously argued. I'm rendering an objection. I always get a kick out of this idea. It's so obvious we don't have to say it. Well, then why don't we just say it?
That's noted. I mean, the instruction's already been read. It's in the opening instructions. Any others?
Your Honor, I've had a lot of paper thrown at me. Is the oral argument, jury instruction that says if you find that there was no negligence, you can disregard the remaining damages instructions?
You'll see that when we get to the special verdict form. It's incorporated into the special verdict form. It indicates that if you find no negligence on the part of either party, you sign and date the form and turn it into the court.
So I think in the opening instructions it said something to that effect. There is a standard MUJI that says, I'm now going to instruct you on damages.
MUJI is Municipal Uniform Jury Instructions.
If you find that there's no negligence, you should disregard these instructions.
Okay, yeah, it looks like it's on...
It's the standard uniform.
The Introduction to Tort Damages page, I think it's 12 or 13 in your packet.
That's why they say MUJI, M-U-J-I.
Thank you. No other comments.
Okay.
She's behind one of my glass.
Turning to the special verdict form, I realize you just got my version of it. Have you had a chance to decide whether this meets your needs?
Your Honor,
I took this from the Florida claim, counterclaim verdict form. I took the concepts here.
Your Honor, oh, you printed it. Sorry, I was looking on my email. I see. Thank you.
Did you get that, Mr. Bueller?
Yes, we did. And we're just wondering if before closing argument we could get another copy because to counsel, I think.
Sure. Yeah. I just wanted to, there's one change that I think I might need to address with you.
They're burning
whenever
time.
You're ready, and then we'll have to print out new copies.
So I thought what we want them to do. This is a second exact copy.
Thank you, Johnny.
mean, we can wait to look at this until just before reading jury instruction, because I would like to read this to the jury during that part of things, if you're not quite ready.
Can we tell you in 2 minutes?
Sure. The one I can tell you when you're ready, it's the one change that I see.
I think the shirt guy would actually be a security concern for
It's 2/3 of the way down on page 2.
Because of how animated he is.
When you get to the bottom of the comparative fault questions, there's that separate section. Just above the damages line, it says, if Terry Sanderson's fault is 50% or more, rather than proceed to question 9, because that one's already filled in, I suggest that we just say, sign and date the form and turn it into the court.
I was kicked back, taking it easy.
I don't think they can tell him to move because he's in an appropriate seat for a member of the public, but I'd keep my eye on him.
Am I thinking that through right on the comparative fault? If Terry Sanderson's fault is less than 50%, then you answer the damages question. If it's 50% or more, you just sign and date it, and that means that the $1 that's been assigned to Gwyneth Paltrow is the counterclaim.
So they have to figure out the percentage of responsibility for this incident for each person. I hope they have some like D20s back there they can roll.
Your Honor, it doesn't necessarily mean that if Terry's fault is 50% or more, that the defendant's doesn't have 50% or more either. Or, stuff happens, inherent risk of skiing, accidents happen. The jury could deny awarding the $1 to Ms. Paltrow. So
he's fighting over a buck.
Well, if they
honestly
put 50-50 on the comparative fault questions,
yeah, then it would
then
work.
there would be no recovery for either side, right?
Right, but there's the possibility of, I guess they'd have to do that exactly. But if there's this
John Blake,
other,
here's your answer right here from Mr. Upper Torso.
Co-counsel Pete.
In other words, I guess what I'm saying is I think there's enough information in these answers to help us to create a judgment based on any scenario that they come up with.
I think that's acceptable, Your Honor. That change.
It seems like that to me, Your Honor, as well, but I just want to make sure that
sometimes a flow chart's helpful.
Yeah, that's true. It'd be nice if one of the questions, or it's important, obviously, that one of the questions allows them to connect Terry Sanderson's fault to the say that it caused Ms. Paltrow's damages. And do you see that as covered by comparative fault questions? Because number 4 just asks whether his fault is a cause of his own harm, not of Ms. Paltrow's harm. So you just want to make sure that causation
I see that.
question is addressed.
Should 4 read just like 2, counsel?
That was my thought, and then the comparative fault questions address whether Terry Sanderson's fault caused his own harm, or to what extent.
In other words, if a party's fault caused the other party's harm, is that sufficient Or do we need another question, or does that question need to be modified to say, was a party's fault a cause of their own and the other person's harm?
L, I don't think we'd have a lawsuit if there wasn't potential money on the other side.
I'm fine with it, just, with us redrafting 4 to read like question 2.
Right, and then any self-harm is captured by the comparative fault questions.
I'm going to go more into that, L, as soon as we have just a little break.
That seems reasonable to us, too, Your Honor.
Okay. So the question 4 we'll read now, was Terry Sanderson's fault a cause of Gwyneth Paltrow's
Here comes
harm?
Gwyneth. Oh, no. She walked towards the door and then stopped. L, I was looking at the, Mr. Sykes' website last night. I was looking a little more into him. He's in a small firm out of Salt Lake City.
The title of these sections, Gwyneth Paltrow questions, that should it be like defendant Gwyneth Paltrow questions, or should we eliminate that at all? I'm just posing that as a question because it seems kind of she's not asking that, we're asking that, and the vice versa.
Questions on Gwyneth Paltrow?
Yeah, above number 1, the title underlined in bold says Gwyneth Paltrow questions.
Just take the word questions out?
Well, I just, it makes it sound like they're asking it, but in reality, we're asking was Gwyneth Paltrow at fault, not Gwyneth Paltrow.
So how about if we just label it Gwyneth Paltrow?
Right, or does it need a title?
Okay, so
I think it helps direct their attention.
Mr. Sykes, he's the first name
about her
in his attorney's
actions.
firm.
Right, I see that.
It's Sykes something.
Just eliminate the word questions on each of the headings?
Yeah.
Let's do that.
They are contingency for almost all their cases.
And
they take on we only take
and
money,
I can also
we only charge money if we
delete
win.
it under comparative fault, and we'll just call it comparative fault.
Yeah,
So
I think that makes more sense.
probably the definition of an ambulance chaser. It also does civil rights type situations, things like that.
Can I go to 8 and 9 just for one moment?
Yes.
We're nitpicking, but Judge Tom Green used to say, if we don't get this right, we get nothing right. So number 8, what if we said, what amount fairly compensates Terry Sanders for non-economic damages? There's a bullet point that I don't understand.
Yeah, I took this off of the plaintiff's form. That's the way the standard MUJI does it, but it does it when there are more than one category.
True.
So yeah, that could simply be added to it.
That for non.
The only thing I thought about was that it clearly says non-economic damages, and there is a jury instruction that is entitled that, as well as the number 9 clearly says economic damage, and there is a jury instruction entitled economic damage.
And for the economic damages jury instruction, perhaps it should just say Gwyneth Paltrow seeks $1. I don't think they need to even need this big instruction on economic damages.
What do the plaintiffs want on economic damage?
Well, I think as the court pointed out, I think we already have the instruction. We've been working on the instructions for a while. We like to have it in there, and I think it clearly is indicated here on the special verdict.
What I like about it, Mr. Owens, is that it distinguishes the non-economic damage.
Okay. And then number 9, I would just say, what amount fairly compensates Gwyneth Paltrow for economic damages? Delete the bullet point and the ...
Okay. Is the plaintiff okay with deleting bullet points and the ... dots?
And the empty space to the right, the blank.
Oh my
This is on number 9?
On 8, I think it's just
this is
a
on
line to fill
this is
out,
on
right?
9.
8 and 9, just take out the bullet point and the dots.
And just include it as part of the sentence.
Yeah. And then what's this business of a blank space?
Under where I think at number 8, there's a missing line to fill out. That line.
Whose phone is that?
Damages for Terry
Bueller?
Sanderson.
Nope. Oh, it's one of the lawyers.
I'm not following you.
You want a blank after the $sign?
No.
What?
No, there's line underneath to fill out.
On question 9?
Well, it doesn't matter.
Agreed. That line shouldn't be there.
Just sort of
I'll do my best.
We're arguing over fonts, spaces, bullet points.
They are. They're tables. All right. So why don't we take just a short restroom break? Mr. Sykes is now here.
Headphones guy is actually the audio guy for the courtroom.
Bring the jury
he has
in.
the headphones on.
Can I mention one thing?
Sure.
We filed a pretrial motion on rebuttal witnesses, number 12, defense pretrial 12. It was granted. It sought to give you a little bit of a bench brief on the narrow scope of rebuttal witnesses. In short, they are not to just restate anything that could have been stated in their case in chief. I even had a judge in Logan literally say you can ask like 8 questions and then he can say yes or no with one sentence. I mean, and I was on and off in about 3 minutes because those were the only brand new issues that they couldn't have predicted. And so we asked that this rebuttal witness be strictly limited. It's not used as an opportunity for the plaintiff to just restate and sort of get the last word on things that.
So we talked about this when the motion came up, and the court agreed that these are rebuttal witnesses. They're not to strike off into new territory. They're not to clarify. They're to respond.
Correct. They're just
to issues that came up in the defendant's case. And then, of course, on the counterclaim. All right?
Brand new issues.
That's all. Basically 3 questions, Your Honor.
And who's the next witness?
It's Richard Bain. We're just waiting for him to get on the Zoom.
Okay. While you do that,
Bain's
then we'll
on.
take a short recess. Thank you.
Get ready for the green screen. Here we go.
As long, unless it takes longer to get him on the Zoom. Let the bailiff know as soon as you get him on the Zoom.
Okay, so the jury is walking in, the judge is walking out, so the judge walks back in. Let's see. We've got some fun stuff going on right now. Personal injury lawyers. Yes, I'm not against all personal injury lawyers. It's what I was trying to say is that if we didn't have personal injury lawyers who would operate on contingency, only rich people could sue, right? And that is not a fair system. We need to have lawyers who will be able to take a case for the underdog who does not have the financial means to seek redress for a wrong that they've received. And so it's an important part of the legal system. I'm not trying to slight that. I'm just trying to say that in this case, with it being a contingency case, without money on the other side, there probably wouldn't have been a lawsuit, because you can't squeeze blood from an orange, right? Unless it's blood orange, I guess. You can't squeeze water from a rock. And what attorney is going to say, yeah, I'll take your case, I'll represent you for free, and if we win, I'll get 30% of nothing. It wouldn't happen. So in that light, that's how I was trying to respond. That's why I mentioned he was an ambulance chaser type. But we need ambulance chasers. Otherwise, we're all going to die broken poor if bad things happen to us that weren't our fault. Did that answer it? Let's see. True of every civil case. Does the coffee attorney only have the one red tie? Yes, that's the coffee attorney who's back in the middle. That's Mr. Sykes. That's the one I was specifically talking about. He did, by my estimation, very poorly yesterday as he crossed the last 2 witnesses for Gwyneth Paltrow. He asked questions he didn't know the answers to, and the answers were not the ones he wanted, and it made him look very bad when he was trying to have get in the last blow, and instead he got beaten soundly. Did Terry bring his money bag in today? Hopefully, he just brings $1. That's going to be it. I honestly will say, from what I've heard, and I don't have a lot of history in civil cases in Utah. It's very difficult to get court fees or lawyers' fees added on to the case and have the other side pay. I don't think that's going to be a simple maneuver for them to pull off. Here, let me get SuperSource working again. 3 boxes. There we go. Oh, there's so many of me. Hopefully I'll agree with each other. Oops. Nope. That's not right. 2 wants to be 4. There we go. All right. So that's happening. Let's see. Active shooter alert on my scanner app. Forsyth, Texas. Winston-Salem, North Carolina. 2. Holy cow. Let's see. That's my state. Hopefully that gets resolved quickly. We'll keep an eye on that. Is the judge who decides on the lawyer fee issue? I believe the jury gets to decide on the issue. I'm not sure if the amount is decided by the judge, because that's if it's awarded or not, I think is a yes/no that the jury decides, and then the actual totals are run through the judge, because it's just like turning in receipts. Terry will owe her $1. Doubt they'll get legal fees added. Yes, but it'll be worth it for the lawyers who are probably being paid for by the umbrella policy that Gwyneth Paltrow has, at least that company. That it's worth it. Whatever they spent on this to not pay out $3 million, I think that would be beneficial. Yes, personal injury lawyers most definitely take on cases on contingency. Correct. I think it would be great if they paid in pennies. Let's see. Carol Martin says, what's the limiting motion? Mr. Apatroso had a really good definition of that earlier, if I can scroll up high enough to get it. It's basically a motion that's made before the trial begins, where there's a decision saying we're not going to allow a specific piece of evidence because it's more prejudicial than probative. So it makes my client look bad more so than it provides important information for the case. So that's ruled. There's a motion in limine. There might be something that's excluded through that motion, and we're not allowed to talk about XYZ during the case. But during the course of the case, as testimony comes out and doors get open, we use that term a lot. That opened the door. That will open the door to that information coming in. The judge says, I told you not to talk about it, but because the way you asked a question, that witness answered, and now they've said those words, which I said not to say, and I can't make them unsay it. I can't just say, strike it. Now the other side says, good, they said the words, now I get to talk about it. It rips the tape off their mouth. They're free to express anything they want about the topic. So those motions in limine, those are the ones they're listening for. When they say, did that open the door? I think we now get to respond. And that's usually where things get spicy as well, because one side really does not want it to come in. Let's see. I dated this judge in high school. My mom dated Jimi Hendrix. Is that the type of comment I'm seeing here, or was that actually true, Stephanie? That's interesting. Sykes McAllister, there's the name. Thank you very much, Thomas. That's the full name of Mr. Sykes' law office. It's a small firm. I think it's got 2 partners and 2, underlings. What do you call the lesser attorneys? For some reason that escaped me. They're not lesser. They're the ones that do most of the work, and the top ones get the credit. Associates, that is, associates. Did I say it before anyone told me? I think I did. It's my first civil case. Wow, we learned so much. Thank you for bringing this to me. Yeah, Rosie, we're not going to cover many of these. We're more about true crime. We did this to be like a lighthearted break from some of the heavy crimes. Back to back murder. It was tough. We had no break, and so we did this one, and it turned out to be a little heavier than we thought. Will we be able to access pretrial hearing for Sarah Boone tomorrow? Can we watch it live? We believe so. Florida is really open with their court system and friendly to the media that way. So we'll be watching for live feeds available. We were able to watch her previous pretrial hearings, which happened very quickly, so quickly that we almost blinked and missed it. So it's going to be pretty quick. That being said, a camera has to be there to catch it. So we'll see who's there. Obviously, Sarah apparently doesn't even know that she's going to be there, or she's found out that she's not going to be allowed to be there. So we'll see. If Sarah's definitely not going to be there, there's less of a chance of the cameras being there. Have not followed Lily Peters' case, or unless I know it by a different name. What's the basic one-liner on that one? Name is Mud says, I'll call into work and drive next county over to record Sarah Boone. If not, thank you, Name is Mud. It actually takes a little bit of work to get access in the courtroom, being approved as a media outlet. That then if you're the first one, and you have to be careful. If you're the first person requesting access, and then more people come after you, you have legal responsibilities to provide certain things for the group that comes after you. So make sure you understand very well what those responsibilities are, or how that court operates, because you might end up having to provide something that you can't do. Verdict in the case today, isn't it? I believe so. I think it'll be quick. Do we know the time Sarah Boone's pretrial hearing would be? Let me look at her. Let's see. Hang on 1 second. Need to find. Let's go back to Orange County. I'm not sure if it was like 9 a.m. or 11 a.m. or something. It's Florida time, so it's earlier than these late start courts. Okay, the hearing. I have to look at the calendar. I can see we've got the hearing for tomorrow. I have to find the calendar really quickly for Judge Wooten. Race car headed down our street right now. Okay. Orange County Court calendar. Hey, Knoxville agent, thank you so much for becoming a member. Good to have you in green now. Please take your seat on the front row. Appreciate the support. Thank you so much. Let's see. Looking for Boone. Oops. Okay, Sarah Boone, tomorrow, 10:45 a.m. is what I'm showing. Sorry, you guys probably found that before me. 10:45 a.m. is the time slot, room 60 on the 6th floor, with Judge Wayne Wooten. Now, what they do on a lot of these pretrial hearings, because they happen so fast, they might have 10 people, they might have 15 people slotted for 10:45. And they just fly through them. Some of them take less than 30 seconds to even mention. And so in a 15-minute period, they can get a lot of work done. This one, there's probably going to be something, especially if the judge has this letter from Sarah Boone saying he still hasn't contacted me. There's probably going to be some back and forth on that one, asking about, hey, what's up? I ordered you to meet with her. So that'll be interesting. Let's see. Let's see. Minor age cousin killed her. Wow. I'll have to look into that one. What state was that in? Like an umbrella policy, but no boat insurance. It got canceled. This policy got canceled. Yes, 10:45 a.m. Thank you for that for the pretrial. Aiden Fauci's mom is at 4 on. So we'll catch that maybe during the break before Sarah Boone starts up, if it does actually go ahead. Yes, the tumbler is wicked cool. Yes, it's right here. Got it right here. It's like a frosted glass, but it's smooth, and it's got it works. It looks best with the light inside. Hang on a sec. It's got the Recovery Addict logo. Sorry, it's out of focus because I'm locked my camera focus down. Anyway, it is really awesome. I love it. Glass straw, wooden lid. It's can't wait to throw some lemonade in there, some ice, have it clinking around. Let's see. Did GP's children testify? Sherry, yes and no. They gave depositions. And then they ran out of time because of all the timing in the court. Everything was off. And so instead they read the depositions. And so the attorneys read the depositions as if they were they sort of acted it out like they were reading a play from the script. And it was sort of funny just how they did it, especially because Man Bun has the voice of a 9-year-old child, which was perfect for playing Moses. And so it was interesting that way. But we got the testimony. Basically what it was they went skiing. They knew there was a crash that their mom was involved in. She was upset, and they know they didn't see anything. That's pretty much all the testimony. And then they wanted food. All they talked about was food. They remember going to eat. I sincerely hope they don't push back her trial again. She's set for April 10th. I'm ready. You and me both. And Sarah Boone. Sarah Boone wants to go ahead. Of course, she doesn't know that her lawyer may or may not be ready. She'll find that out either tomorrow or sometime after that. Lee Peters is in Wisconsin. Everything's in Wisconsin. What is up with Wisconsin? It's a heavy case. Both killer and victim are children and related with SA involved. Oh, my goodness. That's probably too heavy. That might be too heavy. Closing arguments should be really good. I think they'll be spicy. I think we'll have some objections as well. Still waiting for transcripts. On which one, P-Frog? So notice of appeal, but not actual appeal. I remember them saying it would take weeks for transcript. You're talking about Alex Murdaugh then. Yeah, the transcripts for that are going to take forever. I mean, the court was so long. It's going to take 6 months to get the transcripts done. And all they need to do is have that notice in. The notice has a time requirement, but once the notice is filed, then they have a long time to file it. So they're good. Britt Brett, I think the attorney, we know the attorney wants to quit, right? He's tried already, and the judge has said, no, I won't let you. And then he tried by not doing anything, and the judge says, hey, you have to do something. So the attorney does not want to be there. I mean, you think Gwyneth Paltrow isn't happy about being in court? This attorney is not happy about having to represent Sarah Boone. And she does have a coin-appointed lawyer. I think it's her number 5 or 6. I don't remember where she's at. And so many have bailed, and he tried to bail. He begged to bail, and the judge would not let him. Said it's going forward. It's taken long enough. So the judge is to the point where he says, look, we've had enough time. She's waited long enough, even though she's waived her right to a speedy trial. At some point, she has to be tried. We can't just hold her indefinitely. So she's on her 6th attorney. Thank you. I thought it was 5 or 6. I could not remember. He has a record of neglecting his clients. He does. You can find that on his, I forget the website, but you can search for all the black marks on attorneys' records. And he was reprimanded by the Florida Supreme Court. And one of them was directly related to that. Hey, you want me to turn off a camera? Hang on 1 second. Nope, that's the wrong one. Let's go this way. Okay, now it's just, this is showing. Mrs. R.A. is raiding the cupboard for books for homeschool. Lawyer still isn't communicating. Yes, I'd love some hot chocolate. Thank you. Appreciate it. I can hear the machine running. Lawyer still isn't communicating with Sarah Boone, according to Twitter. Yes, we shared her letter earlier. Thanks to Tina, gave us a heads up. She wrote another letter, Mel, to her lawyer and copy the judge. We're trying to find out. We're trying to get the court to correct an error because they scanned it into the system, but only scanned every other page. So we got page 1 and 3, but not 2 and 4. So we're hoping to get the rest of the document scanned appropriately. I saw the link to the interview. Ouch.
May be seated. Are we ready to bring the jury in?
No, Your Honor.
Okay. All right.
We're still not ready. The judge, the day's almost over. Wow, Gwyneth is looking, what is that, chic? What do you call that? More classy today. Oh, it's piping hot. Whew, it's scalding hot. Oh my goodness. This hot chocolate, it's in the red mug. More Stevens hot cocoa. Oh, the best stuff ever. Love it. Highly recommend it. It's gonna have to cool down or else I'm gonna burn my tongue and won't be able to talk for a week. If you look at the last letter, we've probably got time to do this as we wait for the attorneys to get everything sorted out. The last letter from the attorney asking to be removed. Let's see, where's that?
Dr. Bateman, would you mind speaking to us for just 1 second?
Dr. Bames here. Do we have green screen? Do we have a background? What cocoa is it? Picky. Let me give you a link for the cocoa. Oh my goodness, this is the best stuff on earth. Hold tight.
How do you guys? Ready for the jury?
We can hear you now.
Test.
Okay, here we go.
Test.
Okay.
Just need to type here so you know what it is.
I hear you guys. So how do you read?
Okay. And it looks like the video's a little slow, but we'll have your audio, so we're getting ready to bring the jury in.
There we go.
Thank you.
I put best hot chocolate in the world on there.
Roger that.
Because I think it is. I think I typed everything right. It's Stevens Gourmet Hot Cocoa. And it's made with water. It doesn't have to be made with milk. And it is still so rich, so creamy. It's heavenly. It's amazing. I think we're going to make RA-themed suitcase zippers, like a little zipper pull or something. Like a keychain that's just a zipper you can fidget with. I tell you, it's good. The chocolate machine, actually, this is funny. We hate this chocolate machine. At the same time, it's the only one out there, and we love it for that reason. It's a blender and a heater all in one. So you put the hot water in, and you hit the button, and it mixes it, and it dispenses. It's fantastic. I'll find a link for that one, but it's hard to find. I'll get a good one for you though. I'll have Mrs. R.A. help. Ooh, just slid my cup on the desk, and it's not being nice. That's awful. No zipper pulls. Too soon, Nicole. I like milk, but the thing about Stevens Hot Cocoa is they have about 1 billion flavors. Everything from candy cane, white chocolate, mint truffle, you name it. They've got flavors all over the place that almost anyone could enjoy. Yes, we're talking Stevens. They're right down the road. I think they're in Farmington, right next to Lagoon in Utah. They have one of their big stores or their factory or something. Some of the best stuff. If you're into hot chocolate, it's the way to go. Which color hoodie are people liking the most? I don't know what colors were available. Let's see. I don't know off the top of my head how many were available. The attorneys, I think, are biting heavily into the time available to them. I'm just sincerely hoping that Mr. Boehm has figured out his green screen, and he now has like an appropriate background that's not just a green screen. No zipper pull. You guys don't like the zipper pull idea? What's a better one? Maybe a suitcase luggage tag. Shirt guy is uncomfortably close to GP. You're welcome, Picky. Thanks for asking. I'm glad you guys agree. It's the best hot chocolate ever. Hazelnut is sold out. It changes very quickly. I would mark it as a favorite and pop back and check. Mint truffle is delicious as well. Okay, so I'm curious. If we were to do some Sarah Boone themed merchandise, you guys aren't buying the zipper pull keychain, nor are you big on the luggage tag, apparently. What would what would we do? What would we do? Something that says not intentionally, or some sort of comment like none of my bad decisions were intentional, or something like that.
Good morning, members of the jury. Sorry for the delay. Just be assured that we've been working very hard, and I think the rest of the morning, as a result, is going to go much smoother and much faster. So, thank you. Mr. Bueller?
Here we go.
Plaintiff Terry Sanderson calls Dr. Richard Boehm on rebuttal.
Mr. Boehm, I'm not sure if you can see me. This is Judge Holmberg speaking. If you could please raise your right hand to be sworn in as a witness.
I do not see you. I just see myself.
Do you swear that the testimony you are about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, reporter.
Once again, Dr. Boehm, if you could state your full name and spell it, please.
It's Richard Boehm, spelled B-O.
It's just B-O.
I think that's B-O-E-H-M-E.
This is going to be painful.
Can you hear me, Dr. Boehm?
That's affirmed. I can hear you loud and clear.
Okay. Thank you. I understand you're on vacation, and we appreciate your time. Dr. Boehm.
Yes, I am.
Dr. Boehm, in trial testimony this week, the defendant's expert, Dr. Irving Scher, disputed your findings regarding the ski collision between Terry Sanderson and Gwyneth Paltrow on February 26, 2016. Have you had a chance to read his trial testimony? Did you say something?
Bueller?
Yes, I have. I read it.
Okay.
We're losing a few of the words there.
Yes. So maybe Dr. Boehm, if you would start off your speech with something that will then kick in the audio, so so here's my answer, something like that before you answer.
Roger that.
He's got a noise gate that's being triggered.
Dr. Scher suggests that you made an error in your calculations. How would you respond to his suggestion?
Here is my answer. Dr. Scher mischaracterized my analysis, which led to his analysis being misleading and incorrect.
He's reading something.
Okay. Could you explain that in more detail, what the analysis is that you want to correct?
Sure. Well, Dr. Scher first wrote up the impact force formulas, and he labeled one of them wrong and one of them correct. And both of them are wrong. And why? First of all, the equation F equals 1/2 mv squared over d, where he substituted 1/2 at squared or 1/2 at and then at in the parentheses for velocity. You can't do that without solving for time or t first. Basically what you have from a mathematical standpoint, you have force and time, which you don't know. So you have two unknowns in one equation. So basically the equation is unsolvable. So you have to first solve for time. And you guys have there. So if you go over to the first one where you have x equals x0 plus v0t plus 1/2 at squared, you have to know the height at which Mr. Sanderson fell to the ground.
Dr. Bain, could you share your screen and show us your calculation? Let's see if
Watch. I want to see him share something that's completely not related to this trial.
I don't. I hear, and I'm trying to figure.
He's sharing his paper.
Have it.
It's all blurred out.
Pull it up. Over here.
You can't pay for this sort of entertainment, guys. This is amazing.
Do you have it?
Not yet. We'll try to share it.
Internet connection is unstable. This paper is blurred. This is like a train wreck. This is their big rebuttal witness. Gosh, I do it in my head, so I'm following quite well.
See that better?
Just give us a second.
Blur our screen.
Just a second.
I'm going to show it to you.
He's going to show us something that's not blurred out, apparently.
Lawrence, he's got it. He's got it.
Okay.
All right, I'm just had to unblur my screen, show it to you, but for my exhibit, 0 plus v at squared.
The jury's looking at this and going,
so the height at which Sanderson fell, which is x over t, and you can see that less than a 0.46.
Actually, we can't.
Okay. The second, where you substitute time in for to determine the who are falling downward.
This exhibit, has that been approved?
We know what it is because it's Earth.
Dr. Bain?
Everywhere on this gravity is on. Oh, if you...
Dr. Bain, we're having trouble hearing you. If you could avoid the pauses, it might work better.
Hopefully you sold your Zoom stock, guys, before this.
So you see the 1/2 with it there.
Your Honor, we're getting about a fourth of what he's saying, so this either needs to be fixed or stopped is our motion.
Yeah, Your Honor, let me just try one last thing.
Okay.
Dr. Bain, could you stop your video and then just talk once you've shown the formulas? That way the signal might be clearer.
Right, IT guy will.
He needs his IT guy to stop the video on Zoom.
Now.
Yeah, that's much better. Thank you, Dr. Payne. Appreciate that. Oh, man.
I'm sorry, counsel, but it doesn't sound like it's going to work.
Why don't you call him on the phone?
Phone would work?
Yeah. Dr. Bain? Dr. Bain?
Sir.
Can you hear me?
Yes, I can.
The best part is he's charging $500 an hour
phone
for this.
Because we're having technical difficulties with the video and the.
Roger that.
Okay, should I call your cell number?
Yeah, just go ahead and announce it right now.
On the iPad, if that gives you.
I don't see that. I've got other numbers for you. Can you?
He's going to give his number. Okay, audio should be muted for this, and if they won't, I will. But I'm not trying to out him. Call the iPad. Yes, he wants to do a FaceTime video.
Can I call your cell number? Well, I guess he's okay.
And he's gone. Dr. Bain has expired. Yep, that was $250. I think he's just stretching it out because he knows this is the last time he's getting paid by these guys. They're probably not going to hire him again. Please go to voicemail. Please go to voicemail.
We have the board remove jury's view.
I think it went to voicemail. It's just ringing. He's gonna be like, "Oh yeah, this is Mr. Bueller. Can you call me back as soon as you get this?"
Have it removed from the jury's view until it's discussed.
We're in court. We're trying to talk to him on the phone.
Well, can you find him? Oh my goodness.
Should I call?
He's called the wrong number. They're like, no, he's not here. He's on vacation. I'm sorry. I can take a message for you. Oh, my goodness. This is good stuff. This is great. You can't make this stuff up. Who had it on the bingo card? Key witness. Not available. Zoom crash. Left message on voicemail. Please return call. Jury waiting. Oh, man. Yeah, this is actually embarrassing. This is he's still explaining to the secretary. Oh my goodness. Terry has multiple law firms representing him. This is not a single law firm. For instance, Sykes is the only one from his law firm on this team.
I mean, they know what their time is that they have left, so.
Okay.
Gwyneth is like, they're using it all up.
You want me to FaceTime or what?
No, we're just going to do it by audio.
He's going to hold the phone to the microphone.
Yeah, just you're live in court, and the jury can hear you.
Don't swear.
Roger
please.
that. And so, do you have my equations up?
Are those the equations? There they are.
So now we're going to have
Dr. Bain
him try to walk an attorney
We've
through
got
the
your
equation.
equations up.
Okay. So, do you have the sheet where it starts off with x equals x0 plus v0t and so on?
Yes.
Okay, perfect. All right. So as I was saying, should I continue, sir?
Yes, please.
Roger that. So, in order
Roger
to
that,
make the equation
Tower.
work,
We're going to go ahead and land the plane now.
time, which is
Over.
t.
Yes, the call just dropped. The call just dropped. He landed the plane. Oh, my goodness. This is so good, and at the same time, so bad. So very bad.
Sorry about this.
Yep. Sykes like, there's nothing we could do. This was all out of our control. Jury, we went to all the effort to line this up, and technology has failed us.
Would it make sense to
just
take your next witness
go straight to
while someone
deliberation?
is outside trying to reestablish?
This is our only witness.
Okay.
This is all we've got, Your Honor. This is our Hail Mary.
One moment. I'm seeing a potential problem. I guess I could just bring it out while they're calling. I was prepared in cross to maybe show Dr. Bames some documents or even draw some things.
Yeah.
I wasn't sure whether I'd get into that, but depending on what I hear, I was going to do that. I know I don't have a ton of time, and maybe I decide not to, but this obviously makes it so I can't do that, which is a problem.
I think
if I decided that I
both
wanted
parties
to.
are going to be hamstrung on this. So why don't we take it as it comes?
That is not fair. That he can present his visuals, but he can't question him on other visuals. That is, ooh, that seems like a big issue to me.
Yes, we do. We lost you. We lost you there.
He's like, well, did you get everything you need?
Look at the phone to see if we're still connected. But in any event, once you get the time, 0.466 seconds, that's the time it takes to free fall from a specific height, X, which is measured on Mr. Sanderson, which is 3.5 feet to his ribs. And then you substitute T into the equation velocity equals 1/2 AT squared. In this case, typically for free fall equation, it's V equals AT. Now, the reason I put the 1/2 in there with the asterisk, and keep in mind, I've been on this case for 2 years, and up until this point, no one has ever asked me why that asterisk is there with the 1/2. Well, keep in mind that those equations are for free fall events. So if you're suspended in the air by X, 3.5 feet, and you are dropped to the ground, that's the velocity that you would get. However, we know that Mr. Sanderson is not suspended in the air when he collides or when he makes contact with Ms. Paltrow. So he's actually standing on his skis, so he's standing upright. So when he falls to the ground, it's not a free-falling event. And you can appreciate that because when he falls over, the speed of his feet that hit the ground is 0, whereas the velocity of his head is certainly much greater than the velocity at his feet. So you have to know, which I took his measurement in the office, how high the point of interest is, which is his ribs, because that's what he fractured in the collision. So once you do that, you substitute the 1/2 AT squared asterisk into and that turns out to be 2.29 meters per second, and you put that into the impact formula, and then you obtain what the impact force is. So the equation should be written Fi, impact force, equals 1/2 in parentheses V sub T asterisk all squared, and then over D, the distance through which the energy is transferred from the ground to his ribs, which I measured in the office. So you have to know those quantities and understand that this is not a free-falling event. So that's the big difference here. And once you have the 2.29 meters per second and you substitute that in, and you just use Mr. Sanderson's weight as the mass in that equation, you realize that there is not enough impact force to fracture those ribs. So there has to be a mitigating circumstance, i.e., something fell on top of him in addition to him falling to the ground to cause those ribs to fracture in an otherwise healthy male. And so when you do the calculation, the object,
healthy male, is
typically to fracture ribs on the lateral side, which is where he fractured his ribs, takes about 4,000 newtons, thereabouts, plus or minus 400 newtons, 4,000 newtons plus or minus 400 newtons to fracture those ribs. And when you work backwards, the mass required to do that indicates that the object that fell on Mr. Sanderson had to weigh at least 100 pounds. So, based on what I know about this case, any human that weighs greater than 100 pounds falling on Mr. Sanderson onto his right side, fracturing those ribs, would qualify as a traumatic event from an impact force calculation standpoint. Now, so once you understand that, then you start to consider other possible scenarios as to, is there any other way he could have fractured those ribs? The only other way he could have, if you consider him striking Miss Paltrow from behind, is that if he were to do that, he would have to generate a rotational force on him and Miss Paltrow, resulting in him falling on the ground and Miss Paltrow falling on top of him. Okay? Now, keep in mind, as I already calculated, you look up there, it took less than half a second to fall to the ground. And so for him to ski into Miss Paltrow and then rotate 180 degrees to the ground in less than a half a second requires a rotation rate of greater than 400 degrees per second. Now, Olympic divers, that is, when they do their twisted and turnings on their competition dives, don't generate any greater than 400 degrees per second on their dives. And then when you take into consideration Newton's first and third laws, you know, Miss Paltrow is certainly not twisting and turning if she's struck from behind. So in order for her to rotate around with Mr. Sanderson has to, according to Newton's first and third laws, grab her and then take her to the ground in a twisting fashion where she lands on top of him. Now, Olympic swimmers, if they were to grab 100-pound weight or more and try to do those rotations, that's just not going to happen because the center of gravity is too far away from the moment or the initial point for rotation. So that's probably not going to happen. But let's hypothesize that this did in fact happen, which is highly unlikely. If Miss Paltrow landed on Mr. Sanderson and he landed on his back, that means she landed on his chest. And if that were to happen, the ribs would not fracture on the lateral aspect of his chest as we see in the medical records. So we know, based on that and the low probability of the rotational or the angular velocity, that did not happen. So that only leaves one possible scenario to satisfy Newtonian physics, the Mr. Sanderson's measurements, and his medical records, and that means that he was struck from behind, went down onto his right side, made contact with the ground with his elbow. The energy was transferred into his ribs that fractured the ribs. Now, I would like to add that had the rib fractures not occurred, no one would be able to do this analysis, period. And that's all I got to say about it.
Thank you. That's all for me. Defense counsel, question you next.
Roger that.
Roger that, good buddy. That's a 10-4.
Mr. Egan?
Thanks, Your Honor. Am I to talk through this? Can you hear me, Dr. Boehm?
Barely. Is this Mr. Egan?
Yes, it's Mr. Egan.
Hi, good morning, Mr. Egan.
Good morning. Given the limitations we have, I'm not going to ask you some things I prepared. I can't show you a number of things. So this may take a second, less than we'd planned here. But let me start this way. Dr. Scher, you watched Dr. Scher's or read Dr. Scher's trial testimony, right?
Yes, I read it. I did not watch it.
And so you didn't see him writing up the equations on the board for the jury and discussing those for them?
I did get a text picture of his equations.
Okay. But did you get a text picture of the drawings that he drew for the jury?
Yes, I did.
And Dr. Scher has significant experience applying the principles of biomechanics to skiing, correct?
To my knowledge, he does. I don't know him personally or professionally.
And you do not have that kind of experience, correct?
With regards to what, sir?
Applying the principles of biomechanics to skiing?
I have not worked on skiing problems, if you will.
Okay.
But certainly.
And Dr. Scher has studied the physics of skiing and ski equipment, correct?
Oh, yeah, that's my understanding of primarily bindings with skis.
Yeah, I think it goes beyond that, but that's right. And you have not done such studies, correct?
No, not on ski bindings, sir.
And did you learn anything from Dr. Scher's testimony, given his experience with ski, applying biomechanics to skiing, and your lack of it? Did you learn anything from him?
Did I learn anything? I mean, all I learned was that he assumed a free fall event, and it's not a free fall event. That's what I learned primarily, and that's why that basic assumption flaw is analysis.
And that's the only thing you learned?
I'm sorry, I didn't hear that.
And that's the only thing you learned?
Talking to the
Yes, that was basically that's why I'm here today.
Do you know, is this
better?
I
hear you much.
Can you hear me better if I do
now.
this?
Absolutely.
Okay.
Absolutely.
I'm just, leaning in front of the jury here.
No, I appreciate that. I can hear you really good now. 5 by 5.
Thanks. Yeah, it's a first. Okay. So, do you know anything about DIN settings? Those are the settings that dictate when ski bindings release.
No, I do not know anything about that. I haven't skied in 40 years.
Right. Okay.
And you show his number.
Also, that means you wouldn't know how much force it would have taken to release Mr. Sanderson's boots from his skis, correct?
I did not calculate that.
Not just that you didn't calculate it. You don't even know what force it would require. Is that right?
No, that is correct. It's not required for my analysis.
Okay.
Man Bun's hand's getting tired. He's going to have to switch arms here in just a second.
Did you catch in Dr. Scher's testimony that he's read the voluminous literature on rib fractures and the biomechanics of rib fractures?
I'm sure he has, but we did experiments in the lab in the military doing that. So
okay. But my question was just: did you see that part of or read that part of his testimony?
That's what he portrays.
Okay, and it sounds like you dispute his reading of that literature.
No, I don't. I mean, he portrays that he knows a lot about biomechanics. Sure. I don't know. I've never been in a discussion with him to familiarize myself with his level of knowledge in that field.
Even Moses historically needed help holding his arms up.
You
right?
said earlier that part of Dr. Scher's mistake in your mind is that he didn't acknowledge that he didn't solve for T. Is that what you said?
Well, that's one of them.
Okay, so that we're just going to stay on that one for a second.
Roger that.
Did you?
Objection. Let the witness finish his answer, counsel.
He answered my question. I was just going.
Mr. Boehm, did you have anything else that you needed to say to respond to the previous answer?
No, we can move on, Your Honor.
Okay, thanks, Dr. Boehm. I don't mean to interrupt. I'm just trying to be quick because I don't have much time.
I understand, Mr. Egan.
So I'm
in a hurry too. I'm trying to make a luncheon.
I got it. Yeah, well, we appreciate you making time during your vacation.
Got a sandwich waiting.
Did you miss in Dr. Scher's testimony where he pointed to the pages in your equations where you solved for T and he just assumed what you had done?
Right. I mean, basically, he did an analysis or a critique, I might add, on my analysis. I don't see where he calculated it himself.
Right. He was just working off yours, just assuming what you had done and then doing his own calculations.
Right. That is correct.
Okay. Thanks. That's all the questions I have. Thanks.
Thank you, Mr. Egan. Appreciate it.
Mr. Bueller?
Dr. Bain?
Yes, sir.
Okay. So you did see the calculations from Dr. Scher.
Well, I saw what he did, which was critique my analysis, and that was it. I don't know if he did any calculation based on what I saw in his testimony.
If you could quickly focus in on what is the error that you think Dr. Scher made?
Well, the biggest one, well, there's two of them. First of all, with the rotational aspect, he did not consider Newton's first and third laws, so that's a violation of classical physics. And then second of all, he assumed a free fall, and we know that Mr. Sanderson did not free fall to the ground because he was standing up and he fell over, and the velocity when you hit the ground, when you fall over, is much less than a free fall. And we did those studies at the Naval Under Research Laboratory because we were interested in that research for our military personnel. So knowing because you can appreciate standing up, when you fall over, the speed of your feet is 0, whereas the speed of your head is something else. And it's much different than a free fall event.
Okay. Thank you. That's all I have. Counsel?
Thank you. And am I allowed to leave? Over?
Just have one question, if that's okay, Your Honor.
James Egan has one more question.
Oh, okay. Mr. Egan.
Yeah. Oh, thanks. Yep. Thank you, Lawrence. I'm back, Dr.
Go my
Bain.
phone.
That's great.
One last question. You were talking about free fall. Do you recall the testimony from Mr. Sanderson that he went airborne during the accident?
I don't recall that. No.
Okay. Thank you.
Boom.
Anything else?
Just one question. Is it possible for for Terry Sanderson to have gone airborne when his skis were on the snow?
No, that's not going to happen because the skier would have to go, that hit him from behind would have to be going in excess of 50 or 60 miles an hour, which I think is highly unlikely unless we're dealing with an Olympic downhill skier here.
Okay. That's all I have. Thank you, Dr. Bain. No more questions.
Thank you.
He wanted a yes.
And, Your Honor, am I excused?
Yes, you are. Thank you, Mr. Bain.
Thank you.
Thank you, Your Honor. Thank you, guys.
I'll stop
guys
charging
have a great
now.
day out there in Utah.
Thank you. That's all we have. No more witnesses, Your Honor.
So you rest a rebuttal case?
We rest our rebuttal case, yes.
Okay. So you've now received all of the evidence.
Your Honor, we were thinking of calling somebody, but we decided not to.
Okay. So you've now received all of the evidence. I just need to ask the lawyers a couple questions, and then we'll proceed. So could you approach the bench, please?
Okay, so that was embarrassing, and they ended with a dud. Their plaintiff has said he was free falling. He got hit so hard that he was free falling through the air. And they asked their expert, who's on their rebuttal expert, the last question: is it possible that he got hit and was flying through the air? The plaintiff is in the background nodding, and he's saying, no, it's not possible. So it's like, whoops. Yeah, good 10-4, good buddy. He can go ahead and continue on his route. All that CB talk with the Roger over copy of 5x5. Let's see. That was funny. A yes undermines the equations, so he had to contradict the plaintiff. So I guess there was no win for them, no matter which way he said. If he said yes, then it goes against his equations, and if he said no, then it goes against the plaintiff. Cameraman's showing us a little bit of the courtroom here. I'm surprised that gentleman there in the front without the tie is allowed to be there, but I guess he was released, right? If he was not released, then he shouldn't have been there in the courtroom hearing any testimony. So we'll see. He was supposedly the only eyewitness. Worst arrest in court history. Yeah, as far as finishes go, this was a poor one. It would be equivalent to you've probably seen a couple videos on YouTube of maybe some track stars where they're right at the finish of the race, or a bicyclist just finishing a major bike race, and right as they get to the end, they're riding no hands with their hands up, and they end up wobbling and crash, and then somebody else like pedals slowly, and they're carrying their bike across the finish line, and they end up finishing second. I think that's what we just had here, with a dismal finish at best. Judge giving both sides final times. Yes, now the math is being done right here, and this is what they're worried about, because the plaintiff took so much time with the Zoom call and with everything, and I'm sure Sykes is going to be like, hey, that's not our fault, it was technology. But yeah, it gets billed to them, unfortunately. So they may not have the full hour and a half that they wanted. I think they wanted an hour and a half, an hour and 10. Let me see. What was... They wanted an hour and 10 minutes in closing on the plaintiff's side, and defendant wanted an hour. That'll be split between Mr. Owens and Superman as they bifurcate the case.
Okay, members of the jury, you have been handed the closing jury instructions. There's one more document you'll get before the parties argue, but we're gonna give that to you right after the break. I'm going to read through these, and then we'll take a short break. So these are jury instructions 18 and 22 through 42. If you turn to page 2, and you can make notes on these if you'd like. So page 2 is jury instruction number 18, which has already been read to you, most of it, as modified, because I did modify it during the trial, and I read it to you during the trial as it stated right here. So now you've got the complete 18, the modified 18. Turning then to jury instruction 22, which was also read to you during the trial on limited purpose evidence. Turning then to 23, a closing roadmap. Members of the jury, you have now received all of the evidence. 3 things remain to be done. First, I will give you additional instructions that you will follow in deciding this case.
That's right now.
Second, the lawyers will give their closing arguments. The plaintiff will go first, then the defendant, then the plaintiff may give a rebuttal. Finally, you will go to the jury room to decide the case. In the jury room, you will have 2 main duties as jurors. First, you will decide from the evidence what the facts are. You may draw all reasonable inferences from that evidence. Second, you will take the law I give you in the instructions, apply it to the facts, and reach a verdict. Instruction 24, closing arguments. When the lawyers give their closing arguments, keep in mind that they are advocating their views of the case. What they say during their closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence.
Just the closing.
If they say anything about the law that conflicts with these instructions, you are to rely on these instructions.
The defense
Counsel, could you remove that
closing.
easel? It's kind of blocking my view of the jury. Number 25. You can just shove it over next to the screen. Legal rulings. During the trial, I have made certain rulings. I made those rulings based on the law and not because I favor one side or the other. However, if I sustained an objection, if I did not accept evidence offered by one side or the other, or if I ordered that certain testimony be stricken, then you must not consider those things in reaching your verdict. 26, fault defined. Your goal as jurors is to decide whether Terry Sanderson was harmed, and if so, whether anyone is at fault for that harm. You must also decide whether Gwyneth Paltrow was harmed, and if so, whether anyone is at fault for that harm. If you decide that more than one person is at fault, you must then allocate fault among them. Fault means any wrongful act or failure to act. The wrongful act or failure to act alleged in this case is negligence. Your answers to the questions on the verdict form will determine whether anyone is at fault. We will review the verdict form in a few minutes after your break. Instruction 27, negligence defined. You must decide whether Gwyneth Paltrow or Terry Sanderson was negligent, or whether they were both negligent. Negligence means that a person did not use reasonable care. We all have a duty to use reasonable care to avoid injuring others. Reasonable care is simply what a reasonably careful person would do in a similar situation. A person may be negligent in acting or in failing to act. The amount of care that is reasonable depends on the situation. Ordinary circumstances do not require extraordinary caution. But some situations require more care because a reasonably careful person would understand that more danger is involved. To establish negligence, Terry Sanderson has the burden of proving that 1, Gwyneth Paltrow was negligent, and 2, this negligence was a cause of Terry Sanders' harm. If you find that Gwyneth Paltrow was negligent, then you must determine whether that negligence was a cause of Terry Sanderson's harm and whether Terry Sanderson sustained damages. Gwyneth Paltrow claims that Terry Sanderson was negligent in causing his own harm, and that should read, and in causing her harm. To establish Terry Sanderson's negligence, Gwyneth Paltrow has the burden of proving Gwyneth Paltrow has the burden of proving that 1, Terry Sanderson was negligent, and 2, that this negligence was a cause of Terry Sanders' harm and her own harm. I'll send in a corrected instruction 27. If you find that Terry Sanderson was negligent, then you must determine whether his negligence was a cause of his own harm and her own and Ms. Paltrow's harm, and whether Paltrow sustained damages. Instruction 28, allocation of fault. If you decide that more than one person is at fault, you must decide each person's percentage of fault that caused the harm you determine was suffered in this case. This allocation must total 100%. Mr. Sanderson's total recovery will be reduced by the percentage of fault that you attribute to him. If you decide that this percentage is 50% or greater, he will recover nothing. The same is true of Ms. Paltrow's recovery. When you answer the question on damages, do not reduce the award by Mr. Sanderson's or Ms. Paltrow's percentages. I will calculate that later. Instruction 29, violation of a safety law. Violation of a safety law is evidence of negligence. Terry Sanderson claims that Gwyneth Paltrow violated Parts A and B of the following safety law, and Gwyneth Paltrow claims that Terry Sanderson violated Part A of the following safety law. This is Summit County Ordinance Section 523, reckless skiing. A, reckless skiing prohibited. No person shall ski in a reckless or negligent manner so as to endanger the life, limb, or property of any person. B, skier's duty to injured party in the event of collision. Any skier involved in a collision resulting in injury to any person shall immediately stop at the scene of such collision and render to such person injured in such collision reasonable assistance, including the caring or the making of arrangements for the caring of such person by a physician, surgeon, or hospital for medical or surgical treatment, if it is apparent that such treatment is necessary, or if such caring is requested by the injured party. If you decide that Mr. Sanderson and or Ms. Paltrow violated the safety law, you may consider the violation as evidence of negligence. If you decide that Mr. Sanderson and or Ms. Paltrow did not violate the safety law, you must disregard the safety law, and decide whether they acted with reasonable care under the circumstances. Jury instruction 30, I've already determined that Gwyneth Paltrow did not leave the scene of the accident without giving her contact information. Jury instruction 31, spoliation. Ms. Paltrow has presented evidence that a GoPro video of the ski collision may have existed. Sanderson asserts that the GoPro video of the ski collision never existed. If you find that 1, a GoPro video of the collision likely existed, and 2, that any such GoPro video was in the possession or control of Sanderson, and 3, that the plaintiff intentionally or negligently disposed of or lost the GoPro video of the collision, or otherwise failed to offer a reasonable excuse for failing to preserve the GoPro video of the collision before a defendant had an opportunity to review and evaluate it. Then you may, but are not required to, conclude that the evidence would have been unfavorable to Sanderson. Instruction 32, Introduction to Tort Damages, Economic and Non-Economic Damages introduced. I will now instruct you about damages. My instructions are given as a guide for calculating what damages should be if you find that either Terry Sanderson or Gwyneth Paltrow is entitled to them. However, if you decide no one is entitled to recover damages, then you must disregard these instructions. If you decide that Ms. Paltrow's fault caused Mr. Sanderson's harm, you must decide how much money will fairly and compensate him for that harm. If you decide that Mr. Sanderson's fault caused Ms. Paltrow's harm, then you may award Ms. Paltrow $1, which is the maximum amount she seeks. There are 2 kinds of damages, economic and non-economic. I will explain the difference between them. 33, proof of damages. To be entitled to damages, a party must prove 2 points. First, that damages occurred. There must be a reasonable probability, not just speculation, that a party suffered damages from the other party's fault. Second, the amount of damages. The level of evidence required to prove the amount of damages is not as high as what is required to prove the occurrence of damages. There must still be evidence, not just speculation, that gives a reasonable estimate of the amount of damages, but the law does not require a mathematical certainty. In other words, if a party has proved that they have been damaged and they have established a reasonable estimate of those damages, the other party may not escape liability because of some uncertainty in the amount of damages. 34, economic damages defined. Economic damages are the amount of money that will fairly and adequately compensate a party for measurable losses of money or property caused by another party's fault. Mr. Sanderson is not claiming any economic damages. Therefore, you should not award Mr. Sanderson any economic damages. Ms. Paltrow is seeking $1 in economic damages. 35, non-economic damages defined. Mr. Sanderson is seeking non-economic damages. Non-economic damages are the amount of money that will fairly and adequately compensate Mr. Sanderson for losses other than economic losses. Non-economic damages are not capable of being exactly measured, and there is no fixed rule, standard, or formula for them. Non-economic damage may still be awarded even though they may be difficult to compute. It is your duty to make this determination with calm and reasonable judgment. The law does not require the testimony of any witness to establish the amount of non-economic damages. In awarding non-economic damages, among the things that you may consider are 1, the nature and extent of injuries, 2, the pain and suffering, both mental and physical, 3, the extent to which Mr. Sanderson has been prevented from pursuing his ordinary affairs, 4, the degree and character of any disfigurement, 5, the extent to which Mr. Sanderson has been limited in the enjoyment of life, and 6, whether the consequences of these injuries are likely to continue and for how long. While you may not award damages based on speculation, the law requires only that the evidence provide a reasonable basis for assessing the damages, but does not require a mathematical certainty. I will now instruct you on particular items of economic and non-economic damages presented in this case. Instruction 36, pre-existing conditions. Terry Sanderson is alleged to have had physical, emotional, or mental conditions before the time of the ski collision. He is not entitled to recover damages for those conditions. However, he is entitled to recover damages for any aggravation of the conditions caused by Gwyneth Paltrow's fault, even if those conditions made him more vulnerable to physical or emotional harm than the average person. This is true even if another person may not have suffered any harm from the event at all. Gwyneth Paltrow has the burden to prove what portion of the alleged harm is the result of pre-existing conditions. If you are unable to make such an apportionment, then you must conclude that all damages, if any, you find were suffered by Mr. Sanderson were caused by Ms. Paltrow. 37, mitigation of damages. Each party had a duty to exercise reasonable diligence and ordinary care to minimize the damages caused by the other's fault. Any damages award should not include those that could have been avoided by taking reasonable steps. Terry Sanderson has the burden to prove that Gwyneth Paltrow could have minimized her damages but failed to do so. Gwyneth Paltrow has the burden to prove that Terry Sanderson could have minimized his damages but failed to do so. If a party made reasonable efforts to minimize damages, then your award to that party should include the amounts that he or she reasonably incurred to minimize them.
Your Honor, my memory is that jury instruction 38 was stricken by both parties yesterday.
Okay. It wasn't.
It was not.
It was not stricken.
I apologize. Please proceed.
Okay. 38, collateral source payments. You shall award damages in an amount that fully compensates Terry Sanderson. Do not speculate on or consider any other possible sources of benefit Terry Sanderson may have received. After you have received your verdict, I will make whatever adjustments may be appropriate. 39, four-person selection and duties and jury deliberations. Among the first things you should do when you go to the jury room to deliberate is to appoint someone to serve as the jury foreperson. The foreperson should not dominate the jury's discussion, but rather should facilitate the discussion of the evidence and make sure that all members of the jury get the chance to speak. The foreperson's opinions should be given the same weight as those of other members of the jury. Once the jury has reached a verdict, the foreperson is responsible for filling out and signing the verdict form on behalf of the entire jury. In the jury room, discuss the evidence and speak your minds with each other. Open discussion should help you reach an agreement on a verdict. Listen carefully and respectfully to each other's views and keep an open mind about what others have to say. I recommend that you not commit yourself to a particular verdict before discussing all the evidence. Try to reach an agreement, but only if you can do so honestly and in good conscience. If there is a difference of opinion about the evidence or the verdict, do not hesitate to change your mind if you become convinced that your position is wrong. On the other hand, do not give up your honestly held views about the evidence simply to agree on a verdict. To give in to pressure from other jurors or just to get the case over with. In the end, your vote must be your own. In reaching your verdict, you may not use methods of chance, such as drawing straws or flipping a coin. The verdict must reflect your individual, careful, and conscientious judgment. Instruction 40, do not resort to chance. When you deliberate, do not flip a coin, draw straws, choose opinions at random, or use other methods of chance. Instead, you must weigh the evidence carefully and come to a decision that is supported by the evidence. If you decide that a party is entitled to recover damages, you must then agree upon the amount of money to award that party. Each of you should state your own independent judgment on what the amount should be. You must thoughtfully consider the amounts suggested, evaluate them according to these instructions and the evidence, and reach an agreement on the amount. You must not agree in advance to average the estimates. Instruction 41, agreement on special verdict. After the break, I'm going to give you a form called the special verdict that contains several questions and instructions. You must answer the questions based on the instructions and the evidence that you have seen and heard during this trial. Because this is not a criminal case, your verdict does not have to be unanimous. At least 6 jurors must agree on the answer to each question, but they do not have to be the same 6 jurors on each question. As soon as 6 or more of you agree on the answer to all of the required questions, the forepersons should sign and date the verdict form and tell the bailiff that you have finished. The bailiff will escort you back to this courtroom. You should bring the completed special verdict form with you. And then jury instruction 42 I'll read to you at the end of the trial. So that completes these instructions. I wonder if you could write your names on the top of that, because as you noticed, I did make some changes to a few of the instructions as we went along, and I'll have the bailiff insert the new and take out the old, if you could do that, the new instructions, before they're given back to you. Yes? Pardon me?
Names and numbers, or just names?
On the verdict form, the foreperson will write their number and their name when they sign it. And there's only be one signature on it, which would be the foreperson. And when I select the 2 jurors that will unfortunately have to leave us before deliberations, I'll just tell you your juror number. I won't say your name, and I'll give you further instructions about those 2 individuals. So I'll do that in a few minutes after all the arguments are completed.
Do we have a break before arguments?
At this time, we'll take a recess, and thank you.
Okay, first I want to answer a question for James Rogers. He's listening only, so he couldn't follow in chat. He was asking about bifurcating the case. In this case, bifurcating is only happening on the defense side for the argument. So we're going to have both James and Mr. Owens. Mr. Owens is going to handle the liability side, and James is going to handle the damages side, I believe, or I might have had that reversed. But they're not actually splitting the case up that way, just on the defense closing. That's one. And let's see, who was we had Banjo Jones. You had a question about the name to the channel. I think anyone who's been on the channel will tell you.
I would like to get a hard copy of the special verdict form just so I can read it one more time.
We've got some issues with the verdict form. I wonder if you could come into chambers and we can kind of go through that.
Thank you. And then
might be a longer break.
Can Peter Jensen have the defense binder index? And certainly one of the plaintiff's lawyers is welcome to be present to do the final swap out with the new index. He's
Sure.
not adding one thing. He's deducting.
And is that something we need to do before closings?
No. He could do it at the moment. They are discharged to deliberate.
Normally,
sure.
Well, if you want to get those into evidence, I suggest you try as soon as possible.
Well, I do move to admit the new index, all those documents on the new index, which they have. Any objection?
Are there any objections to the index of defendant's trial exhibits? No. All of the exhibits been received?
So
okay.
That's on the new index. And now he just needs to make the changes, including blacking out Mr. Sanderson's
contact information, Social Security, birth date,
address is the one that's most common.
Okay. All right, so take a quick break and then have the bailiff bring you back to my chambers on the special verdict form.
Okay. So let me answer this for Banjo. I appreciate you bringing up the question, first of all. I think anyone who's been on the channel will know that I am a huge supporter of individuals who are in recovery or in the 12-step process or they're a different process in recovery to addiction. We cheer them on regularly. We have many members here who celebrate and share in chat to our great acclaim the success they've had in their recovery and their sobriety periods. I myself, I've been to those meetings as a support individual for someone going through addiction and have the utmost respect for that. My name was not made to be a play on that. Typically it's referred to as addiction recovery instead of recovery addict. I chose the name because I was addicted to recovering artifacts from the ground. This is a new hobby I began when I basically stopped my gaming addiction. I was severely addicted to gaming. It nearly cost me everything I had. I realize it's not a drug or alcohol addiction, which is more commonly thought of when you think of addiction recovery, but for me it was just as real. And so I don't take that lightly. I'm not poking fun at it. I'm very supportive of it and encourage anyone who is in a recovery of their own to make it one day at a time, and that's all we can do. But so I appreciate you bringing it up. You'll never find me making fun of addictions on this channel, and anyone who's going through addiction has my wholehearted support. But thank you very much for bringing that up. Let's see. We have let's see, awesome Brit Brat, 13 months on the second. What day is the second? Is that going to be Monday? We'll throw a party, Brit Brat. How about that? I think we'll have something. I think that's Monday. That'd be really cool. Congratulations. Okay, why are these forms redacted in advance? Why weren't they? The problem is they didn't realize, I guess, they didn't realize that because they're showing them, this is the first time a civil case has been broadcast in Utah, okay? It's never, ever been shown on TV or the internet or anything else. So these are things that normally are shown in court. Personal data is, we just sat through, several days of medical history that's very personal, things like that. A lot of that's normal in court. You sue like this, you say there are medical damages, all that is open to the public. But being open to the public and being open to the internet is a little bit different. And so they've redacted some of this information because they at one point they were showing the social security number, address, phone numbers of people that isn't important to the case. The jury doesn't need your social security number to determine its outcome. So they're learning and they're redacting information as they have that on the documents. They should have done it in advance, but yeah, not. Let's see, tow trucks, recovery tow trucks. Recovered 5 years. Thank you. Awesome girl in Texas. Congratulations. Are you the only one that can't see me? Am I too tall? I raised my chair a little bit, and now I just about dropped my iPad on the floor. Why did the judge put in the instructions about hit and run? Debbie, I thought that was thrown out. He said that he sort of addressed it because probably it was in the open and then said, I've determined that it didn't occur. And so he sort of talked about it, but then also said she didn't leave the scene. I've determined that didn't happen. That's the one thing that he ruled in the motion right after the plaintiff rested that he sided with the defense on and said, yeah, I'm gonna say that didn't happen. That won't be going to the jury. Let's see, Marcy, I was totally addicted to gambling, but walked away one day out of the blue, never turned back or had the desire to return. It's been 14 years for me. That is awesome, Marcy. Congratulations on that. Amazing. Do you know the number of stars in the state seal have any significance? 1, 2, how many do they have? And let me see if I don't, as far as the inner stars, I think that's more than the number of counties. They have like 27 counties, right? How many counties are in Utah? My what was it, 4th grade or 5th grade geography teacher would not geography, but anyway, 5th grade I think was when you learned the counties in Utah. Let's see. Carol, awesome. 15 years. You're an inspiration. Appreciate you so much. Thanks for being here. 37 years. Amazing, Cece. That's how I was approved to a travel rewards credit card thanks to this trial. Adam, you should have enough points to fly all of us to like a meetup somewhere in the Bahamas. That would be amazing. Let's see. Do we have any more questions? I think we had questions about the bite me. I see yours as well. 50 inner stars. Okay, well, 50. It would probably have to do with the number of states than in the U.S. Which state was the last state to join the union here? 50. I'm going to Google here really quick. We're going to get smarter here together. Okay. The actual state seal or the state flag, it's funny because the Wikipedia still shows the old state flag. I believe the legislature just changed it. It was a blue flag with a version of that state seal, just the inner portion with the eagle inside the stars. Let's see, symbolism had 46 stars, 23 on each flag. Utah was the 45th state to join the union. I don't know. I'm not seeing what the stars are. Maybe they just needed something to fill the space. Let's see. Let's see. Civil case only live on TV because of Gwyneth Paltrow. I wonder if we see more civil cases live on TV after this trial. Lawyers were entertaining. Yes, I think they were sort of surprised by the coverage a little bit, by how much coverage they got. Closings will be very good, probably about an hour each. There are 50 little stars. Okay. Watching two trials and both are on break. I'm sorry I rescued dogs. It's funny, when lunchtime falls at the same time, we have nothing to do. There are 29 counties in Utah. See, I could try to name them all, but I would not get there. How many people need to live in an area to make it a county in the U.S.? I believe it's the state has those requirements, and they draw the boundaries. I don't know how many, because Utah especially, it's hard to imagine. In North Carolina, we have a ton of counties. I don't even know how many are here, but there are a ton. There are some in Utah that are extremely sparse, very, very sparse, and others that are extremely populous. I mean, Salt Lake County is almost all populated. There's very little extra space left over, maybe some mountain areas. So you have the full range of counties. There are some areas that's just desert and just no civilization. I'm not sure about the appeals, Marcy. I'm not sure exactly how that is going to work on this one. This is my first civil case following it on the channel as well, and I'm still learning how that goes. You guys are going to get dumped on snow again in Wisconsin. That's what you deserve for moving up to the northern countries. Yes, we can do a poll. Jill, that's a great idea. Even though we haven't heard the closings are not evidence, so that's not going to be a factor to consider. 1 second. Okay, quick poll. Is there a special wording you want, or do you want 3 options? Amy, the northern county countries are not all that bad. I know. I'm just saying it comes with the territory. The further you get from the equator, generally, the colder it's going to get during the wintertime. I'm going to say, how would you vote if you were on the jury? How about this? I'm going to change that because we need to be able to have a hung jury. We're going to add a split. Or no fault. How about that? Okay, here we go. We'll put the poll up. Hopefully I didn't spell anything wrong. That would be to my everlasting shame if I did. How do you think the jury will vote? Poll was up. Team Terry, Team Gwyneth, or split with no fault. Which honestly, I would be sort of pleased at if there was a split. I just learned about Kool-Aid pickles. Have you had these and did you like them? I've never had them. They sound sweet. I think I'm past the point in life where I really enjoy Kool-Aid. There was a time where I couldn't get enough of it. 100 counties in North Carolina. Thank you, Carl. I should know that. 102 in Illinois. Amy, I know. Northern countries are not bad. I preferably like cold weather. My wife is very happy being down here where it rarely freezes.
It's a tough road for everyone. I'm proud of all those who are recovering.
Lulu, thank you so much. I'm sorry it cut off some of that. It says, my son is in recovery after years of addiction. It's a tough road for everyone. I'm proud of all those who have or are recovering. Thank you very much, Lulu. And we're pulling for your son as well, as for you, as being a support for a recovering addict is not easy either. Thank you very much. Appreciate you being here. Where's Matthew Harris when you need him? What was the question on this for Matthew? Okay, if quit smoking counts as recovery from addiction, I stopped smoking about 4 years ago at age 42, June 22nd of June, after I had a heart attack, age 46 now. Awesome, Crusoe. That is amazing. Hopefully you're seeing the benefits of that, and that's driving you to continue on your new path. This Maribeth, this sounds like an amazing collection. Courthouses are some of my favorite buildings because of just the amazing architecture, and even going way back. Typically, a courthouse in a community is one of the most impressive structures to see. As a city is developing, the courthouse tends to be the first big, amazing place. It's like a county seat type thing, and mostly because the courthouses were multifunctional early on. Like lots of things would happen there. It was sort of like the center of the community. No hung jury, since this doesn't have to be unanimous. Yeah, but I agree on the hung part. They only have to have 75% one way or the other, so they can have a split decision. But they can decide that both are equally at fault, or that there's no fault. So that's why I put that third option there. I would vote in favor of GP award $1 plus all legal fees. It'll be interesting to see how that works if they go ahead and do that. Vote as to who is guilty or not guilty. Yes, which side you're with. It's like I'm voting in favor of this guy because they're sort of countersuing each other.
You are a terrific spokesperson for how people can evolve from the devastation of addiction and those that try to survive in spite of them.
Thank you, Jan. I don't consider myself a spokesperson at all. I'm still learning a lot about it. But I have massive support for people who are doing that, and just major encouragement for them. Let's see. I'm seeing some great counts as to how long people have quit an addiction in their life, which is awesome. What would happen if they decide for both? How would they financially decide that? Okay, so the judge said basically that if you, it's the 50% mark, which is where money goes one way or the other, right? So if Terry's 51% responsible, he gets no money. But at 50%, he could get some. And I don't know how that would work. How could you say you're equally responsible and you have to give, half of what Gwyneth Paltrow wants to her and half of what Terry wants to him? So Gwyneth gets 50 cents and Terry gets $150,000. I don't know exactly how that'll work. It's a little bit confusing for me myself. We might have to get some legal minds brought in here to answer that part. We've outgrown our courthouse in our county. New one in process should be complete in 2024. I imagine it's probably going to be an awesome building. the new courthouses are impressive. Multiple courtrooms, all types of safety features, because they're designed for how we use courts nowadays. Beforehand, it was like marriages and everything else is regularly. I mean, you can still get married in the courthouse. 8 years ago, awesome Queen Olive. 7 years ago for Don NC. And drink 3 years ago. Now I'm classed as boring. Hey, boring is great. I would take that boring any day. Have one son over 7 years clean and one 6 months, both drug addicts. Awesome digital designs by PJ. That is awesome. I sure hope Terry receives 0. Katerina, I think it's going to be hard for the jury to, even if they do see that he's at fault. There was a part in there in the description the judge read that said you have to look at how his life has gotten worse because of this. And man, those 50 pictures of vacations all over the world, and just having fun everywhere you can possibly travel to. It doesn't look like his life was. You don't get the impression that he was like suffering. That he's like, I wish I could do so much more. Yes, he retired, but that was 10 years earlier. His eyesight went out. That's why he couldn't do what he loved. I mean, as a doctor, as a optometrist. So I can't attribute that to the crash. Although if the crash, as the judge said, if the crash added to what he was suffering from, there could be some damages there. The ribs, maybe he has a case for the ribs, the 4 ribs. If it is 50% Gwyneth's fault, and those 4 ribs, they might be worth $10,000 each broken. I know that seems like a small number, but generally, I worked in a metal shop where it was not uncommon for people to lose fingers. I mean, it wasn't so common that the OSHA would shut us down, but it happened a time or two. And there was a going rate. There was a chart. It's like if you lose a finger, you get this much per knuckle. You get if it's the thumb was worth more than the pinky finger type thing. And yeah, there's a chart out there. There's got to be a set rate for how much a rib is worth as well. Let's see, 20 holidays after the accident. 4 of them were scuba diving. That blows me away. Heavy rain in California. That's just what you need, Heather. You guys have had so much moisture, so much snow. If it heats up really fast, California is just going to slide off into the ocean. It's so much water. Let's see. Marie says, I think recovered addicted people are nice and humble, so we have a nice forum here. I only stopped smoking 22 years ago, but still nice. Awesome, Marie. That is awesome. Congratulations. Got married in a courthouse, still going strong, coming up on 18 years, the 8th of the month. Rachel, great. That's really cool. I have some family that were married similarly. I wonder if he'll ski again since his life expectancy is 5 to 10 years. That was just weird to me. It sounds like he hasn't. Like he tried and then he stopped. That was one thing where I did get the feel that his life has changed somewhat, even though he said he went 3 times, once with his daughter and twice by himself after that, and then sort of said, skiing's not for me anymore. The state where this is being heard is not a pure comparative negligent state, but a contributory negligent state. So 51% in favor of one party allows recovery. So yes, so at 50% though, it's 0, right? One person has to have at least a fraction, the tiniest percentage more responsibility than the other for there to be a recovery. I might have said that wrong previously. Thank you, James. I thought they can't give him money if the accident hurt his existing conditions if the jury doesn't think GP caused the accident, right? She's got to be responsible first before they can say, and here are the damages. James, appreciate the heads up and correction on that. James is one of our legal minds from the the world of court cases. Just close your right eye and look to the left for the slow skier. Just see what you can see in front of you right now. Now imagine you're doing that downhill. Eddie, I wonder, would that be something they could have done with Terry on the stand? Could they have said, I'm not an eye doctor, but can you demonstrate your vision on the stand? Could they, put a patch over, have him cover one eye, and then have him read a chart with the other, and see, how many fingers am I holding up, type thing? Would that have been illustrative for the jury? Some people put on fake smiles to not show what they're going through. Yes, and obviously Facebook is going to be full of that. Very few people use Facebook to show just how miserable life can be sometimes, and how heavy and disappointing, and just how much we fall short of our own expectations, let alone everyone else's. That's not what Facebook is for. Facebook is, and Instagram and Pinterest typically are, it's almost the photoshopped version of us. It's what we want people to see us as. We're actually, we're creating how people see us there, and so you can go into the psychology of that sometime. That's amazing. Alan Brown, am I wrong? Day 3 and already done closing. Poll is 94% guilty. Yeah, I think it's open and shut case on that one. We're not watching that one. It's got animal abuse in there. I'm glad the dog survived, but sorry, I'm tangled up in my own cord here. It's killing me. It's killing me, Smalls. Okay, let's go ahead and close out the poll, because I always forget to do that. I've actually ended live streams and still had the poll open, like yesterday. So poll shut out. Team Gwyneth has 68%. A split with no fault is 27%, and Team Terry with just 4%. So very, very little support just directly for Team Terry. Do you think that Terry gets disability because of his eyesight? Many do. I don't know. I mean, he's a veteran, and so there are benefits that are available to him. But I think they might have to rule, and Thal could probably help me on this. They might have to rule that he was that the injury was a result of his service or time in service, that to get certain benefits. Although he'd be entitled to care for sure. Let's see. I'm barely on Facebook anymore. Done faking it. It's hard to hold that smile for that long, right? That's why I don't get on social media. Yeah, I know there have been a couple social medias that have tried to start up their focus is make it real type thing. One of them was, I think, on TikTok did it, and there was another one that I don't remember the name, where they said they tried to encourage people to post something about themselves very quickly. So there wasn't time to set up and do the makeup and the lighting. It's like you've got 60 seconds to make a post of what's happening right now type thing, what you're seeing or how you look type thing. And that was trying to make it more real. But it didn't work. It never felt real. You knew that it was coming, and it's like, okay, here it comes. I'm going to get a notification, and I'm ready. Oh, there it is. Go. And it's the same things you had before. But the problem with the eyesight issue is he would have to turn his head to the side to side. A lot of people with disabilities still ski and try to remain active. Yeah, I don't know if he should or shouldn't be skiing. I think so. I'm not saying that in his condition that he was irresponsible just to be on the slopes, but he clearly had enough conditions going on that he should have been mindful of his limitations and skied appropriately. Now, we didn't go a lot into this, but the ski run, the bandana run they were on, is a busy run for a couple of reasons. Not because it's like just an amazing run that's like, oh, this is my favorite type thing. No, it's an intermediate run that so it's sort of like the skill for everybody, but it's a required route to get to some of the harder runs. So people who are much more advanced have to ski on bandana to get to the ski lift that will take them up to another route. So that's why it's often busy. And then you end up having what you have at the ice skating rink, right? When you go on like family day at the ice skating rink, and there are kids out there who are like stumbling around and falling on their butt every 2 seconds. And then there's the guy on hockey skates that's flying through and spraying ice over the wall and things like that. So that's bandana. And in his case, Terry was one of the more advanced skiers. I think arguably more advanced than Gwyneth Paltrow. Social media is the new addiction of the masses. Been off them for years now, says Judge Pickles. Let's see. He shouldn't have skied without understanding he could get hurt, and suing over the hurt he received is ridiculous. The fact that he sued the ski resort first, or also, it did seem like he's just going for money. And yeah, you do something dangerous, and then you're like, holy cow, that's dangerous. I got hurt. Give me money. It doesn't work like that. My son has low to no visibility in his right eye. He hangs from helicopters, climbs towers, and he snowboards. He does not let it hold him back. He's also 29. Yeah, I'm not saying that he can't. I know I know people who have what I would call a severely limiting disability that still do things much further beyond what I'm comfortable doing without the disability, as far as extreme sports go. We say howdy here. Yes, this is something that stood out to me in the cross the other day, where he was talking about how he knew that something was different. If you caught this, he said, I used to walk in the room and everyone's like, hey, Terry, Terry type thing. And now he walks in the room and like, oh, it's Terry. And it's like, it's almost like he was the star of attention and now he's not. There's a new star. Okay. Maybe his star has risen and fallen. And because he's not the center of attention, because he's not receiving all the accolades and everything that he was before, clearly something's wrong with him. I don't know that there is. Terry was very loose with a blindness. Oh, do you think that hurt him or not? Holy cow. Here he is an eye doctor, okay? He knows what blind means. He literally works with eyes and people's vision day in and day out. And then when he goes to the doctor, he tells them on 3 different occasions, I'm blind in one eye. Uses the term blind. I use that loosely as an eye doctor. When people come in, I tell them, oh, you're blind. No, he doesn't. There's no way he would use that loosely. I think he lost a lot of credibility there. Black humor, maybe, or dark humor. Let's see. Terry, live your best life. Tomorrow's not promised to anyone. Ski on, hike on. That's what he's doing. And I think arguably, if that's the advice from the doctors that said, hey, you should do this to keep your mind active, it's working. I believe his mind was very active. He seems to be pretty much on it. The tests that the doctors took, even though he self-reported that he was feeling like he was doing worse in areas, we heard evidence that those tests that tested those areas, he tested very well in. He did sue Deer Valley. It was dismissed. There is a risk to skiing. Yeah, that fine print on the ski ticket means something. Ready for closings? Yeah, they're hammering out some details on the paperwork on the verdict papers. So as soon as those are done, the judge will be back. Terry's not blind. Yeah, the whole Epstein Island thing. Wow, I went back and watched this again, and I think. JT, it was JT or Toyo, one of you guys posted on Twitter just this clip where you take it and it's in context. It's not like splicing it out. He's saying, if we don't hold celebrities like her accountable for what they do, next thing you know, we have celebrities on islands molesting children type thing. And that for me was a logic jump that I just did not follow. That was like, okay, that's borderline crazy. Cruiser Chris World Network says, good morning, Scott. This is your residence down stand-up comedian because I'm in a wheelchair, but I like to make people laugh. Awesome, Cruiser Chris. Love that. My friend's car isn't ready. Tonight we have winter weather advisory. I'm sure it'll be ready tomorrow. All-wheel drive is a good thing. You need all-wheel drive once that snow hits. Katerina, I don't even know. There may be some allegation or story where those two are tied together. I'm not going to get into it here. It really just opens the door for a political discussion or a heated discussion that could turn political really fast, and we don't want to open that. We'd rather do pickles, not politics. Yep, closing arguments. Woot, coming soon. There were a couple people who testified that he was fixated on this case, that this became his everything. Yes. Anything you post on social media, even if you delete it, it will come back. It'll come back to bite you. Okay. All right. I was open to opening the phone lines if we've got a pause with the knowledge that that they could come back at any moment and we'll have to cut somebody off. Don't see the poll. The poll is gone.
Dead horse go
I can scroll back and see what it was. I think it was like 64% for Gwyneth, 27% for split, and like 4%. Well, that leaves a lot unaccounted for. Well, phone lines can't be open now. Judge is back. Sorry. I missed the chance.
Ready for the jury?
Yes.
Yes.
Thanks, Cruiser Chris. We get it. You like to make people laugh. That is awesome. Making people smile is a skill and a gift. Comes the jury. Bring them in. So we're going to have closings and then I think he might read a couple more instructions, like the verdict forms and things. And then we're going to go to closings. No verdict yet. They haven't started deliberations. They still have a few more instructions to be read from the judge. Specifically, the verdict forms will be read to them. And then we'll have closings about an hour each. And then they'll start deliberating while we're on lunch.
Can you see it? Okay, you should have on your chair a document, 3 pages, called Special Verdict Form. I'm going to go through that right now. Members of the jury, please answer the following questions in the order that they are presented. If you find that the issue has been proved by a preponderance of the evidence, answer yes. If not, no. At least 6 jurors must agree on the answer to all of the required questions, but they need not be the same 6 on each question. When 6 or more of you have agreed on the answer to each question that is required to be answered, your foreperson should sign and date the form and advise the bailiff that you have reached a verdict. Gwyneth Paltrow, question 1. Was Gwyneth Paltrow at fault? Yes or no? If you answer yes, go to question 2. If you answer no, go to question 3 below. Question number 2, was Gwyneth Paltrow's fault a cause of Terry Sanderson's harm? Yes or no? Regardless of your answer, go to question 3. Terry Sanderson, question 3. Was Terry Sanderson at fault? If you answer yes or no. If you answer yes, go to question 4. If you answer no, go to question 5 below. 4, was Terry Sanderson's fault a cause of Gwyneth Paltrow's harm? Yes or no? Regardless of your answer, go to number 5 below. Number 5, if your answers to question 1 and 3 are both no, you should not proceed further except to date and sign this verdict form and return it to the courtroom. Otherwise, continue to question 6. Comparative fault, question 6, Gwyneth Paltrow. What percentage of the fault do you assign to Gwyneth Paltrow? If your answer to either questions 1 or 2 is no, then enter 0%. And there's a blank and a place for you to put your number in. Proceed to question 7. Question 7, Terry Sanderson. What percentage of the fault do you assign to Terry Sanderson? And there's a blank and a place for you to put your percentage in. If your answer to either questions 3 or 4 is no, then enter 0. The total must equal 100%. If Terry Sanderson's fault is less than 50%, answer question 8. Do not deduct from the damages any percentage of fault that you have assessed to Terry Sanderson. The judge will make any necessary deductions later. If Terry Sanderson's fault is 50% or more, do not answer question 8 and proceed to question 9. Damages Terry Sanderson. Question 8. What amount fairly compensates Terry Sanderson for non-economic damages? $blank. Damages Gwyneth Paltrow. Number 9. What amount fairly compensates Gwyneth Paltrow for economic damages? This cannot exceed $1. $blank. When 6 or more of you have agreed on the answer to each question that is required to be answered, your foreperson should sign and date the form and advise the bailiff that you have reached a verdict. So we'll now hear from the lawyers with their closing arguments. Plaintiff will go first.
So plaintiff has 1 hour, then defense, and then plaintiff has 10 minutes to rebut. That's Mr. Sykes. Watch for the hands.
We'll check with the expert here.
Hello, hello.
Sounds good. Can you actually do it again?
Hello, hello.
Yes.
We can't hear.
Ladies and gentlemen of the jury, thank you for your attentiveness during these 2 weeks. It's been a hard, long case. I've tried a lot of cases in my lifetime. This has been a hard, long case. And by the way, it's about an hour each way going to Salt Lake with traffic, so that adds to it. But you've been very attentive. I've seen you taking notes and paying attention. No one nodded off. So thank you again. Now, I'll turn on my... Lawrence and I are going to split this. Let's see here. Nope. And by the way, I apologize for my cold. You can't really choose when those come. I've got asthma, and it makes it worse. But I've done everything I can to try to resolve it. Took all the tests. I'm negative for COVID, etc., but it still has plagued me. So I apologize for the coughing. Maybe a little bit more of that. Okay.
It's not the coughing that
there are really
bugs us.
3 issues in the case. Number 1, who hit whom? Okay. Number 2, did it cause any damage? Number 3, what are the damages? What are the damages? Now, Gwyneth Paltrow, in this case, is not a liar. Terry Sanderson is not a liar. Okay? Gwyneth is a good person. Okay? She's a good mother, and she loves her children, and she's passionate about many things. Now, we don't usually say good things about other people in our closing, but I think that's an accurate statement. Okay? I think that she believes, and I believe Gwyneth Paltrow when she says she believes. She says, Terry hit me in the back. And she believes it. It's a sincere belief. She's not a liar because of it. Pardon me. But the problem is, a sincere belief doesn't make it so. Now, excuse me.
Someone's going to put together all his coughs in a video. It'll be his whole closing. It's just cough, 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 cough.
Pardon me. When you're involved in a ski crash, it can be very confusing. I don't care who hit whom. You know, it can be very confusing. So I think she sincerely believes that she got hit in the back. The problem is, you have to make a decision based on the evidence that you've heard here. Okay, on the evidence. Now, let me tell you, to illustrate this, about something that happened to me about 1.5 years ago. Okay? We live in downtown Salt Lake, and we use that Costco, or shop at that Costco, on 17th South and 3rd West. Some of you have probably been there.
I've been there.
Largest one in the world. Okay.
We are having a hard time hearing. I'm sorry.
Mr. Six, where's the microphone for that? Is it on your chest?
Yeah.
Maybe it's not turned on.
Oh.
I'm picking it up, but it is just so faint in the room.
It says on.
I know. I mean, I'm picking it up just fine on for the record, but no one else can hear you.
Well, maybe put it higher on your lapel.
Maybe cough right into it, see if it's working. Wear 2 mics. Who's going to hold one and wear one?
Is that better?
Oh, here. Hand it to me. Is it on? Testing?
Oh, yes, it's working. Gwyneth's trying not to laugh.
Sorry about that, folks. I just got gas at Costco. It was about July of 2022. No, 2021. And I was at intersection. It's a pretty busy intersection. There are 2 lanes, north and south, 2 lanes east and west, 2 each. And there's a left-hand turn lane. I had a red light. Okay. And I was the first one at the intersection. I had a good look at it. I looked in my rear view mirror on my left side, and there's a green arrow for each direction going east and west, turning south and turning north. Do you understand that? So I'm waiting because I have a red light. And there's a lady across the way from me, car heading west but turning south. She had a green arrow, like I saw one her heading north. I look in my mirror, and here comes a guy at about 40, 45 miles an hour on the inside lane of 17 South. I said, my goodness, he's going to hit that woman. He's making that turn. And sure enough, smacked her hard.
I reached for my business card.
Didn't slow down at all. Well, I had a good view of it, and the car spun around, but I was able to get by. There's a Maverick on the southeast corner of that intersection. Okay? I pulled in there, ran to her car, and asked her, are you okay? Like everybody does. She said, yeah, I think so. I didn't think she was, looking at her. But she said she was okay. Okay? So I ran over to the other guy. I was the first one there. Some people were beginning to stop. And the guy that ran the red light said, are you okay? He said, yeah, I think so. I said, well, why'd you run the red light? You know what his answer was? I didn't. It was green. Well, I wasn't going to sit there and argue with a guy like that under those circumstances, but he said it was green. So when the police came a couple minutes later, and you got to be careful as an attorney, I gave them my card, not to get the case. You know, I can't do that. You know, unethical. But let people know who I was so they could call me. Get a cop a card, and I gave each of the persons a card. And about several months later, I started getting calls from insurance adjusters wanting me to tell what happened. And I tell you that story because so often people that are in these types of events have a totally different viewpoint. So we don't hold anything against Gwyneth for her viewpoint. It's sincerely expressed, but she's wrong based on the evidence. Okay? And Terry's correct. Now, what's the evidence that Gwyneth hit Terry? Okay. Number one, and there's no particular order on this, but Terry's a strong skier, advanced intermediate. Mr. Christensen said he saw him going down the hill doing wide radius turns. That's side to side, all the way, back and forth. Now, on a beginner's run, that's highly unlikely for an advanced skier. You don't do that. You don't do that. There's too many people. And so that doesn't make sense. Number two, I'll call it the scream heard around the world. Okay? This is being broadcast everywhere, by the way. It's on court TV. I'm getting emails every day from Canada, Great Britain. There's a loud scream. Terry heard it. A loud scream. Craig Ramone heard it and looked over. Several other people heard it. Carrie Oakes said she heard it. Peter Christensen heard it, so caused him to look over. It's before the impact. And you don't, if you're the downhill skier, like Gwyneth claims she was, you don't scream at something you can't see. You don't. It's the uphill skier that's going to make that scream. And that was Gwyneth Paltrow. Distraction. Everybody here probably been a parent. Most of you not, some of you maybe. But I've had my kids up there, and they want me to watch them ski. And mommy wants to ski. Now, Carrie Oakes said that, and that the deposition segment that you read said that 3 times. Okay? 3 times. And that's important. Can we show Gwyneth's deposition up here?
Your Honor, what are we talking about here?
Mr. Sykes, is this deposition testimony that was read into court?
Yes, exactly.
And is it only deposition testimony?
Yeah.
Okay.
Deposition meaning trial testimony?
Well, it was read into court.
May we approach, Your Honor?
Sure.
Okay, first objection during the closings. If I think my understanding is the judge is going to assign this time, these approach times, to the losing party of the objection. So we'll see. There's an interest for them to make this brief. Now we know that he has asthma. I'm not sure why he went in that much detail. He's been apologizing for this cough throughout the trial. We've had this is the 4th time during this trial, Richard, that we've got that soundbite in some variation. Sometimes it was from defense, sometimes it was from the plaintiff, sometimes it was from the judge saying, "What are we doing here?" But that has been like the soundbite, the quote of the day. He was skiing wide. He miscalculated his turn. My kids were listening yesterday as Terry was giving his description as he lurched off. He pushed off his right foot to dive to the right, and it just didn't make sense to me. They're like, "You would have gone left if you pushed with your right foot." They're trying to reenact it. Looks like it might be allowed.
You could make the screen only show the part that was actually read in court.
Is that okay, Judge, like that?
That looks good.
Okay. Now, Mr. Paltrow, isn't it true? Isn't it true? I'm just a country lawyer here. Okay? Isn't it true?
Bingo.
Let's see if I can move it over a little bit. Okay? That your kids wanted to watch you ski. Or, pardon me, that the kids wanted you to watch them ski. Isn't that true? Vegas the time. I can still watch my children ski and be skied directly into my back by someone. Okay? Which is what happened. And I'm going to omit Mr. Owen's statement and my own, and here's how it reads. Isn't it true that your kids want to watch you ski? Or, pardon me, that the kids want you to watch them ski? I can still watch my children ski and be skied directly into my back by someone, which is what happened. Now,
we need Papa Bear hands. That would be the trifecta. We get the Papa Bear hands of the jury.
This is my witness, and Craig Ramone. We thought about having him testify again today about those drawings, but we decided not to do it. But he saw the whole thing. He saw the impact. And he's the only one that saw it. That's a key piece of evidence. Now, who is Craig Ramone? He's an acquaintance of Terry. He's part of a meetup group. He's not close to Terry. They went to get garlic burgers twice, okay? He has no dog in the fight, ladies and gentlemen. No dog in the fight. He's independently wealthy. You can tell that by what he does.
Your Honor, that assumes facts not in evidence.
Well, it's
just a minute. Objection overruled. The jury will have to recall what the evidence was. And
the evidence was he sold his business, I don't know, 10 years ago, and all he does now is ski and travel and scuba dive. Okay? He has no reason, no motive to falsify this. Okay? Confirmation, those meetup emails that you saw. There was one of the last evidence, I think it was 44, was it? I won't go over it with you. But we printed that out, I think, Saturday or Monday. It gives you the number of days since it was entered. And you add those up, you go right back to February 26, 27, 28, around there. Strong evidence. Terry has repeatedly said to his medical providers that he was hit in the back over a period of years. And that he has problems, medical problems from it. The broken ribs, that's one of the strongest pieces of evidence you have, that Terry was the guy that was hit. He was the downhill skier. Okay? 4 broken ribs, 2 of them separated like that, weren't together. And that's very serious, it's very painful. But the pattern of those broken ribs, 2 MDs, one from Utah and Dr. Bain. So that pattern of broken ribs supports the fact that he was hit from behind. Now, I'm not going to go into all the details of that. That's what he said. And Dr. Bain, who just testified again today, said that Dr. Schur was simply wrong in his philosophy, or his formula. He assumed it was a free fall, and it wasn't a free fall. Broken ribs. How do you get that without a significant impact? Now, the flaky Deer Valley investigation, I think, suggests a cover-up. Eric Christensen, I think, was unbelievable and inconsistent. And there were a number of things. I'm not going to go over each one of them, but I will talk about one. The claim that Terry said he was okay. Now, some of you have probably had broken ribs or loved ones that have had them, you know. Even Steve Grant up here said it's extremely painful. Now, this whole process took place between 11:55, which is the time of Graf's incident report, and 12:02, when Ramon flagged down the ski patrol, and 12:04 when Whitney Smith arrived. So we're talking about 7 to 9 minutes, okay? And they would have you believe that a man with 4 broken ribs, 4, 2 separated, told not only Eric Christensen that he was okay, but 2 other unnamed, unidentified ski patrollers that never logged it in. He told them he was okay. Now that's just unbelievable that that would happen to a person with 4 broken ribs. Not just 1, but 4. Ski between the legs. I don't know how many of you are skiers. I don't remember. You said it in your interviews 3 weeks ago, but to have someone ski between your legs, he thought it was a sexual assault. Okay? But to have someone with both skis, to someone that's moving and shooshing back and forth, it's just another unbelievable claim. That can't happen. Now, and then Gwyneth skis away to lunch. The only way that Terry Sanderson knew that this was Gwyneth Paltrow, as Christensen got angry and said, "Your buddy just took out Gwyneth Paltrow," which is an odd comment to make. Like, just took out a person, you know, but he had to put in Gwyneth Paltrow. That's the only way we know that. That's why you're here. Now, causation. This event caused an injury. Well, I've already mentioned this. The impact was significant enough to break 4 ribs. You know, the impact in the fall, that is a significant impact. The location in the right front is where you would expect it under the circumstances. Loss of consciousness. You know, it was only a few minutes, maybe 2, maybe 3. But there was a loss of consciousness widely reported in the medical records and that day. Widely reported. I mentioned the OK. I don't want to mention that again. So it was significant enough at the time. The very first thing that anybody noticed was that Terry forgot how to ski. He was snow plowing down the hill, an advanced intermediate snow plowing down the hill. Think about that for a minute, you know? And Craig Ramon says, "Hey, Terry, you forgot how to ski." And that's when Craig Ramon said, "I got to flag someone down." So he did, and he told that person, he's got a head injury. That's the words he used, a head injury. Now, it took him 5 seconds, and Craig acted it out up here, 5 seconds to be able to tell him his name. He didn't know where he was at first. That's a significant impact. That's a concussion. Now, ski patrol flagged down at 12:02. Whitney Smith arrives. What a sweet person. And Terry's taken off the hill in a toboggan. Now, you know, that's no fun, but it shows you something happened. She rides disoriented, rib pain, loss of consciousness. By the way, Alina Fong, who treats thousands and thousands and thousands of TBI victims, said loss of consciousness is not required. Okay? Not required. Headache. And that day, I think at the clinic in Park City, dullness in the front of the head. And Whitney Smith said, "Go to the ER." And Dr. McMahon said, "Go to the ER." So the next several months, you have numerous symptoms of TBI that show up in the VA records. Cognitive, personality, social, and emotional. I could go through and show them to you, but you all saw them. But then, one of the most significant pieces of evidence here is a sudden and precipitous change in Terry Sanderson. Sudden and precipitous, okay? Now, I'm not talking about when he came home and Carlene, you know, said he didn't want to be touched. He's got 4 broken ribs. But Carlene, who loved him, said it was a love relationship. She wanted to marry him. They've been together 300 days a year up here and then down there in St. George for about a year and a half. It's a long time to look at someone. She loved him. She traveled with him. She wanted to marry him. And you saw how she choked up when she explained how the relationship ended, that he changed. His personality changed. Polly Gresham, Shay Hareth, same thing. Big changes. They didn't see him as often. So that sudden and precipitous change is a sign of brain injury. Diagnosis of concussion. The VA diagnosed it. Multiple physicians diagnosed it. All the defense experts admitted it. Every one of them admitted it. They minimized the extent of it, but they all admitted he had a concussion. Every one of them. Every one of them. Dr. Gibby, Dr. Fong, Dr. Goldstein, Dr. Bing. The only question was severity and permanency. But every one of them, they didn't want to admit it, but they gave different numbers, between 5 and 20% of people that get a concussion. It's permanent. They have permanent problems. 5 and 20% between that. Dr. Fong thinks it's higher than that even.
Thank you, Robin. Appreciate you so much.
Now, the physics. Dr. Boehm explained the physics, I think, second day of trial, and a little bit today. But he's a neurologist, but he's also a biomedical engineer. That's different than Dr. Scher. He's a biomechanical engineer. But Dr. Boehm specializes in how force affects the body. Very highly respected in that field. That's very rare, not very many of them. Terry talked about the loss of friendships. Mark Horath, good example. They were good buddies, went skiing, and didn't like him anymore. He talked about excuse me, the woman that he was going to Europe with. Don't remember her name, you remember it, but she changed her mind at the last minute and had an empty seat. That's how Jenny got to go. The experience of his granddaughter turning into her for how to tie a knot. Big changes. Craig Ramon said Terry, after the accident, seemed like he could talk to the wall for an hour and have a good conversation. Faking. Every witness you heard from the defense admitted that Terry was not faking, malingering, exaggerating, or magnifying his symptoms. And Dr. Goldstein said there are tests embedded in his tests to find that. No evidence of that at all.
Thank you, Jeff.
And by the way, the VA records continue up until the present day. And they didn't show you any single VA record where that was ever suggested of this man. NPH. They suggested, that could, it's the normative, what is it called again?
Normal pressure hydrocephalus.
Normal pressure hydrocephalus. He's got it, but no symptoms. And it didn't change over about a 13-year period. 2009 to 2021. Dementia, they kind of implied that maybe he's got that, but when we cornered them on cross-examination, not a one of them said he had dementia. And there's no reference in these thousands of pages of records any diagnosis. Degradation of imaging. Okay, we have imaging, I think, from 2009 to 2021, and all the defense experts, plus our own, said there's no degradation on these imaging. He's got white matter abnormalities. Probably half of us do. Nothing showed in there. No problems. No increase. You heard that just as recently as yesterday.
He's probably about halfway done.
I'm going to say just a few more things here in terms of time over to my colleague, Lawrence Bueller. This is actually his case. He asked me to help. That day when Terry left his home to go skiing at Deer Valley, that meetup group, February 26, 2016, he anticipated, like many, many other days in his life, a fun day of skiing. Okay? And he never returned home that night as the same Terry. He never came home, figuratively speaking. Terry has tried to get off that mountain, but he's really still there. Part of Terry will forever be on the bandana run, figuratively.
About 3 inches of him.
People who are just after money, and that was suggested. He's just after money and fame. Somehow going through all of this and spending all the money he spent on experts. He's doing it for fame. Give me a break. But he spent hours and hours trying to get better. If you heard anything about him, he is almost, what's a good word? Extreme in trying to get better. He does everything he can to get better. Anyway, we hope that you will help bring Terry home off that mountain with a fair verdict today. Now, before I turn it over to Lawrence, I want to say one more thing about executive function. Okay? I had an experience up here that taught me about that. 40 years ago, I was in the legislature with a guy named Glenn Brown. I think he's still alive. He's in Colville, has a dairy farm, or did. And I used to kid him about milking cows, you know. So he invited me up to his farm. Young lawyer, going to show me how to milk cows. Never done it. Got up there, and he showed me around his barn. It was really sophisticated, 40 years ago. I mean, it's probably better now. But when you think about why Terry never came home, think about this story in executive function. Because he put a little stool out there for me, and I sat down in my jeans and tried to milk a cow by hand. It's very hard to do for a country boy like me.
So the country boys do really well at it. I grew up in the city.
I was able to squeeze out a little bit of milk, you know. He gave me some, take home. Glenn Brown's a great guy. But I asked him about this situation. I said, how do you do all this? He showed me this very sophisticated situation that milks cows automatically. Does it automatically. He says, without this, Bob, I could never make it. Couldn't do it. Can't get enough people to come help me do it by hand, like my grandpa did. That's executive function. That's what it does for us. We're able to do a lot of things in life. And that milking mechanism was executive function for Glenn Brown's farm to produce milk. Now, this is one of Terry's saddest problems, his loss of executive function.
Can't milk a cow.
He cannot organize and manipulate his life to do things like he used to do. It's the saddest thing. And that's why part of him is still up there on that mountain. Thank you. Lawrence?
He says milking a cow is a hard thing to do for a country boy like me. Then he said, I grew up in the city.
That's why. Sit down.
I grew up in the city. I'm a country boy. I grew up in the city.
I'm going to have a few more comments for you when he's done.
I'll be back. Oh, man. This just gets better and better. Okay, let's see if Bueller can do a good closing here. Terry deserves a good close, at least.
Still good morning. Good morning, everyone.
23 more minutes.
Mr. Bueller, I don't know that we're picking you up yet.
Okay. Can I try this? See if it works on me? Sure.
Just wipe it off and clip it to your tie.
Just do a testing.
Yes, I can hear it. Just so
Oh, wait, no.
faint.
I had it on testing.
I'm actually just hearing it.
The clerk says, yes, I can hear it. It's still really faint. Oh, wait, I still had it off. Let's change the batteries. This has been on for like a straight week. The mic has not worked at all.
Day in technology.
The judge is like, take your time. Stopwatch is running. I'm not sure where he went. He needs that. He needs to go back to get the microphone. He walked away. This will be a lot better. The mic should be a lot better. The first part, they were using an ambient room noise, and we were getting a whole bunch of noise in the background. If this mic's turned on, it should be much clearer.
This case is simple. You've heard the first two parts of this. Who hit whom? And what are the damage that were caused to Terry?
And then the next question is, how much are those damages? And that's the part of the case I'll deal with. This case is about answering the simple questions the law asks us to put on the form that we call the verdict form, which you'll get in a few minutes, or maybe in this afternoon.
Why does it feel like he's complicating the matter?
Verdict. That's an interesting word. It comes from Latin. It's actually two words. It means verus, truth, or dicta, or to tell, or told. So combined, it means truth told. And that's what you're here for, is the truth told.
I'm going to count the sniffles just because I'm bored. I'm up to 3 already.
So what does the law want us to tell the truth about? Well, let's look at what the verdict form says. The first question is, was Gwyneth Paltrow at fault? As my colleague Bob Sykes said, the evidence is clear. There were 4 broken ribs, an eyewitness. There's lots of other evidence, too, circumstantial evidence that Ms. Paltrow hit Terry Sanderson on February 26, 2016. The stories have been consistent for 7 years. So the first question, we answer yes. Now, earlier, it was in jury instruction number 27, the judge defined what negligence is. And judges around the country have a hard time defining what it is. It's very abstract, very abstract. And what it means, basically, is they knew it was dangerous to ski while distracted. They knew that someone could get hurt if they continued to do that. And they did it anyway. Did they know the damage would be this serious? Well, we've all heard about collisions. Collisions happen on the football field. Collisions happen even on sidewalks sometimes. People get concussions. And Terry, there's no doubt, suffered a concussion. But Terry's damage is not just a concussion that goes away in a few minutes or a few days or a couple weeks. We know that Terry's damages, or his concussion, persisted for more than a year and a half. And that's been verified by Dr. Fong, Dr. Gibby, Dr. Goldstein, and Dr. Bain. Even the defense's experts admit that he had a concussion. They quibble on how long it's lasted. But none of those defense witnesses actually examined Terry. And as Bob pointed out, none of them really acknowledged that Terry had problems. One of them refused to acknowledge the before and after witnesses. His 2 daughters, actually 3, but 2 daughters that testified in this trial, Shay and Polly, his friend Mark Harath, finally, or the first witness after Craig Ramon, was Carlene Davidson, his ex-girlfriend. They had known each other for 18 months before the crash, 6 months after the crash. She testified that the damage continued, thus making it a permanent, this is a tongue twister, persistent concussive symptom. And that permanent persistent concussive syndrome is the long-term brain damage that we're talking about. So what it means is every waking hour that Terry has, he's got this brain injury that causes so many problems for him, from executive function to just, being able to deal with people. And as those witnesses showed, Terry has a problem. He looks fine. It's an invisible injury. People know, that's what they say about brain injury. It's an invisible injury. You see someone with a brain injury and they look fine. What's wrong with them? If he has a brain injury, why isn't he in bed and moping around and not doing anything? Well, that's the opposite of Terry. While the crash took much of what he had and left it on the mountain, Terry still has that drive to get better. And even though persistent concussive symptoms are permanent, they last a lifetime. They last forever. So 16 hours a day, Terry is dealing with this injury, such that, as Bob mentioned, when people get to know him, after a while, they don't want to deal with him anymore. I'm sorry I have to say this, but I've known Terry now 6 years. This is just argument, but
I don't want to deal with him anymore.
Now, the 4 broken ribs, those were painful for maybe 3 months or so. But the brain injury has persisted to this day and will last until he dies. The executive function, the social abilities, the mental problems, driving to the store, not knowing where you are and having to use GPS just to get home.
Somebody winding their watch.
These are real injuries that Harry, who is a very bright person, you would not know it just talking to him for 10 minutes. But once you get to know him better, you realize he's got these problems that just change everything. So as I talked to someone left me a message, and every time I hear this voice message, it just makes me cry. Just because it's so just kind of flat, but he says, this person suffered a similar injury 30 years ago. Persistent concussive syndrome or injury, permanent brain injury. And she said, it's permanent. Your personality change is permanent. And you lose everybody who knows you. You lose everybody. Yeah, your family, they'll put up with you, and maybe the lawyers, but really they're just putting up with you.
Decision's still out on the lawyers. Depends how much you're worth.
So let's go to the next question. Well, I'm going to go through, because this is a complicated case, Ms. Paltrow is suing for $1. We're going to go through these next questions. Was Terry Sanderson at fault? Terry was hit from behind. Craig Ramon saw it. The rib injuries show it. Now, Dr. Scher, for the defense, who's not a medical doctor, he's a mechanical engineer, deals with ski bindings mostly.
World-class Pictionary.
He says that Terry Sanderson likely skirted under Gwyneth Paltrow and somehow twisted around and broke his ribs. As Dr. Bain confirmed again today, that's impossible. It defies the law of physics. So I think you have to answer no. I mean, it's a clear no. Was Terry Sanderson at fault? Number 3, no. So then you go to 5 below. And since 1 is yes, this is like a puzzle.
No, I just want you to mark it. Mark it.
Here, I got a pen. Here. I've got one.
It's a sample ballot. We're going to fill it out for you.
So was Terry Sanderson at fault? I'll go back to the first page. Was Gwyneth Paltrow at fault? Yes.
Watch if he gets the wrong one, has to scribble it out.
I forgot to do number 2, and you have to go in order. Was Ms. Paltrow's fault the cause of Terry Sanderson's harm? It clearly is. Terry Sanderson was hit from behind. There was a scream, and he was hit from behind. So the answer is yes.
Gwyneth
so then we go to 3.
Not true.
And because we answer number...
Wait for the courtroom feed. It's lagging here. It's hanging up from the court. We're here, but it's paused.
0.
There it goes.
And to be honest with you, this is the first time I've seen the form because it was just finalized before we started the oath. So I have to think about this one a little bit, but let's think about it together. What percent of fault do you assign to Gwyneth Paltrow? If your answer to either 1 or 2 is no, then enter 0. Well, both are yes.
He's going to get this wrong. I swear he's going to make a mistake.
You have to... Because Terry Sanderson did not cause this crash. You can't cause a crash when you're hit from behind.
Look at Gwyneth, who is chewing gum, I might add. She's about to blow a bubble.
What percent of fault do you assign to Terry Sanderson? Well, it has to add up to 100, so you have to put in 0 there. If Terry Sanderson's fault is less than 50%, answer question 8. Well, it is. So we skipped 8. What amount fairly compensates Terry Sanderson for non-economic damages? Non-economic damages.
He's going to run out of space as he's driving.
Our time on Earth is the most valuable time we have that we know of, at least in this existence. Our time on Earth is one of the most valuable things there are. There are paintings on a wall that are worth $50, $100 million. There are houses in these mountainsides that are worth 5, 10, 20, much more millions of dollars. There's even racehorses that are worth tens of millions of dollars. Well, Terry's none of those.
Not in Utah.
Terry's in the last days of his life. He probably has at least 10 years left, according to what a lot of people think. He guards his health. He doesn't smoke. He's trying to pursue a healthy lifestyle every single day. Yeah, he goes to the doctor, but since the crash, it's been 7 years, and let's say another 10 years. Every single day, he's got 16 hours of dealing with this brain injury, this persistent concussive symptom that causes all these problems. So how do we calculate that? As the instruction says, for non-economic damages, jury instruction 35, which you all have, it gives a detailed instruction about that. Pain, suffering, loss of enjoyment of life, and a retired person, well-to-do person like Terry, who worked all his life, these are the golden years. These are the most valuable years when you can enjoy your retirement and actually do things like travel. But now he has to travel with other people or he gets lost. Dr. Fong and his other therapists, most of his therapists have said, what's the best way to deal with your brain injury? Well, do the things that make you happy. Be active. He could sit around and mope around and be an obvious brain injury victim, but no, Terry doesn't want to be brain injured. He wants to live life to its fullest. So 16 hours a day, he's got this issue where a big part of him was left up on that bandana ski run.
They forgot to put all of them in the toboggan that day.
So you have the power here. This is, before we were just arguing and presenting evidence and the judge was ruling on it, but now the judge is going to pass the case to you. And this is where you decide what happens next. So I'm going to suggest, I'm not going to ask, this is not a, Terry asked me several years ago when I first learned of his case, well, what do you think it's worth? I said, well, Terry, if you could turn the earth backwards like Superman, go back in time, and how much would Terry take to not have what he has now? And he says, I'd rather go back in time and never have this. So how do we calculate this? Well, I'm going to suggest a number. This is just a suggestion that we do it with 16 hours a day. About the formulas, Dr. Bain and Dr. Scher gave you a lot of formulas, but hopefully these will be more simpler than all those. So that's 16 hours a day. Times 365 days a year. Then the next question is the years. Well, it's been 7 years since the crash. Terry's likely to live another 10 years. Probably, we hope, longer, much longer. He wants to live at 130.
Who laughed?
But, at least 10 years.
Did Terry laugh at
7
that?
years since the crash, 10 years, that's 17 years. So we're going to times the next number, 17. Then the question is, how much is, not the price, there's no price that you can give for Terry's time, but what is the value?
We're currently at
that's been taken away from Terry. What is the value?
$99,280.
I mean, there are lawyers and experts and lots of people here that are making low wages, but a lot of people are making $300, $400, $500 an hour. Well, I'm just suggesting a number, and you can put in whatever number you want. This is for the non-economic damages that Terry deals with every day. So that's the next number. 16 times 365 times 17. I'm going to suggest a number. You put in the number you think is fair for Terry. The full value of the harms and losses that he's dealing with every day. I'm going to say $33.
Wow.
$33. And I've done the math because I told you in the opening, except for the small change at the end, a couple $100.
$3.25 million, roughly.
This equation is $3,276,000 for the 17 years that Terry has to deal with this permanent brain injury. Yeah, you could say, well, it's priceless, but an old shoe that's priceless. No, this is the most valuable time of his life, and so that's the amount that I suggest you consider. So what is this case not about? It's not about celebrity. It's not about that. Yeah, there are lots of indications of that, but this is about a man's life. What does the defense want to make this case about? They want to make it about Terry's multiple issues. The 69-year-old Terry that was on that hill, oh yeah, he had all sorts of medical problems, but the defense wants to make it about that. But that didn't mean, he was skiing on that hill at Deer Valley. I can't think of any place that I'd rather be skiing than Deer Valley.
They're almost out of time.
Backcountry Powder, but the point is he was healthy enough to ski, and now he doesn't ski. Now I'm going to tell you a quick story about the legend of King Morgan. King Morgan was the real king back in England about 1,000 years ago. Back then, the kings were the law. someone had a dispute, a farmer knocked an eye out of his neighbor. It was eye for an eye justice. They'd take the eye out of the guy who did it, and what did the victim get? Nothing. Well, King Morgan one day said, you know what, I'm going to invite 12 of my nobles, the guys that have the littler castles, and I'm going to have them come in, and I'm going to have them listen to a case. And he heard the nobles heard the case, and then they said, well, we think this should be decided this way. And the king said, yeah, you're right, and that's good. So they did it a few more times, and finally the king said, you guys decide the cases. I'm going to go off and do what kings do and hunt and fish and fight battles. Well, that's the same system that was adopted in the Magna Carta almost 1,000 years or 800 years ago. And it's the same system that was brought over by the pilgrims that we celebrate Thanksgiving for. And it's the same system in our country. And we're the only country that still has the jury system where people like you decide the cases. Winston Churchill, the Prime Minister of England during World War II, he said, America is a great country. And one of the reasons it's so great is its jury system. And no other country has it. And if you want to weaken America, take away its jury system. Thank you.
We'll take a short recess.
Big finish, everybody. Big finish.
Maybe about 15 minutes.
All rise for the jury.
This is good. Okay, call me a dunce. I don't know my King Morgan history. 1,000 years ago, King Morgan. Who was King Morgan?
Minute break.
Okay. You know of Captain Morgan. They're claiming they're arguing right now. Just in that little brief moment, I heard they're arguing for more time because they've had technical difficulties. I'm not sure if they're going to agree because the other side, defense, had to limit their questioning of their rebuttal because of the technical difficulties they had. I've never heard of a King Morgan. Okay, so somebody educate me a little bit. Who is King Morgan? Is this a fictional character? I mean, is this something out of a book, or is this a real person? I Googled King Morgan, as I've never heard of him, and nothing came up, so I must have done something wrong. He can't be faking, right? I know of Captain Jack Sparrow, Captain Morgan. King and Morgan was a songwriter in the 60s. Yeah, but do we have a real king in England? Don't think there's a King Morgan. This would be hilarious if he gets called out on this. I might be completely wrong. I might have to just go back and study, and maybe there's this amazing king who pontificated about the jury system 1,000 years ago in England that I didn't know about. Let's see. Morgan the Old united the former kings of Gwent and Gwilsing, that sounds Welsh, in 1942 under the name of Morgwyn, and they were broken up again immediately after his death, remaining separate until about 1055. So this was a little bit more than about 1,000 years ago. Okay. So Tish, apparently there's somebody back there. I'm educated. Doesn't sound like King Morgan, King of England type situation. Maybe in the same country, but or the same landmass. I found him on SoundCloud. As in English, I have no idea. Only Morgan was a bishop-elect of Durham. Man. Okay, yeah, I think he took some creative liberties there with Morgan a little bit, saying he was the King of England. Ancient Welsh king. Established trial by jury. Okay, so he sort of fudged the facts a little bit. Not necessarily the King of England. All right, we'll let him have a pass because he pulled some history out that I didn't know. Obviously related. It looks like it even tied into the jury system. So we'll let that slide. I'm still stuck on the milking the cow. city boy, who's the poor pumpkin, country bumpkin lawyer, Mr. Sykes, who's been a country boy throughout the entire trial, chooses the closing arguments to let everyone know that, in fact, he's been lying about that, and he's really a city boy and has no idea how to milk a cow. That was not on my bingo card, but just crazy. There's the buffer sound. Sorry. What's buffering? Let's see. Verdict in for Brown's case. Let me see if we can pull that up. Hold on one second.
Alex stole it as well.
Alex stole it. Give me just 1 minute here. We'll have that one pulled up. It's the Midwest Killing Spree video. Pull this over here.
I'm not a cat.
Okay, so let's go to the 3 box here so we can watch everything at the same time. We've got a 15-minute break. I'm not sure if we're going to get. I'm not sure if we're going to get the verdict in time. So let's put me on the other screen. Box 2 is 3. There we go. And I'll bring in the audio from 3, which we don't have anything yet. There's no feed, but that's the defendant right above us. That's the Brown case, the guy who apparently shot a couple of police officers and a police dog. The dog survived. I believe the officers did not. Can I help you fix your internet at work? Of course we can. I've got peeps for that. I've got peeps for that, Portland Trailblazers TV. Thought Sykes was going to say he was kicked by a cow while milking it. This is what frustrates me. He's in Summit County. Just looking at the demographics of Summit County in Utah, where Park City is, all these ski resorts, it's a very wealthy county. 60% of the homes in Summit County are second homes. Getting some audio from someone, not sure who. I'll watch here. It looks like that'll be in the Brown case. 60% are second homes. These are not people who are out farming on the weekend or catching up with anything, around the barn. And so to relate to the jury, to really connect with them as a parting, stick in your memory type of thing, he tells a story about milking cows, which I would just wager most of the people on the jury have never done. And that no one in their family has ever done it. But he uses that, and then in order to drive the point home, oh wow, it's happening right here. It might happen on the break. Let me switch this up. To drive the point home, he completely surrenders the "I'm just a poor country lawyer" argument to tell that he's actually from the biggest city in Utah, Salt Lake City.
You may take your seats. All right, we're going on the record on Alan M. Brown, 21 CF 1344. Let's have the appearances, please.
Good afternoon. State appears by Alexander Smathers.
Alan Brown, appears in person with Attorney Addison Kuhn.
Good afternoon. I'll ask the jury foreperson, do we have a verdict?
Does he read his verdicts himself?
Hand all the paperwork to the bailiff?
I don't remember. I think it's going to be quick. 1, 2, 3, 4, 5 pages, 6 pages. 7, 8, 9. That's a lot of pages. Okay. Separates them out. There's from the used and not used.
I'm not a camel.
This is the I'm not a camel judge, for sure. Let's see what.
All right, I'm going to read each count into the record. State of Wisconsin versus Allen Brown, 21 CF 1344, verdict form, count 1. We, the jury, find a defendant, Allen M. Brown, guilty of first-degree reckless endangering safety as to 1. Avelia is charged in count 1 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Answer yes. Dated as 30th day of March 2023, signed by the foreperson. Verdict form as to count 2. We, the jury, find a defendant, Allen M. Brown, guilty of first-degree reckless endangering safety as to Colin Coltrip, as charged in count 2 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Answer yes. Dated as 30th day of March 2023, signed by the foreperson. Verdict form as to count 3. We, the jury, find a defendant, Allen M. Brown, guilty of first-degree reckless endangering safety as to Terry Tiff, as charged in count 3 of the information. Please answer the following question. Did the defendant use a dangerous weapon in committing this crime? Answer yes. Dated as 30th day of March 2023, signed by the foreperson. Verdict form as to count 4. We, the jury, find a defendant, Allen M. Brown, guilty of possession of a firearm as charged in count 4 of the information. As to count 5. We, the jury, find a defendant, Allen M. Brown, guilty of harassment of a police animal as charged in count 5 of the information. Dated as 30th day of March 2023, signed by the foreperson. Verdict form as to count 6. We, the jury, find a defendant, Allen M. Brown, guilty of mistreating an animal as charged in count 6 of the information. Please answer the following questions. Did the defendant cause injury to the animal and know that the animal was used by a law enforcement agency to perform agency functions or duties? Answer yes. Question. Did the defendant use a dangerous weapon in committing this crime? Answer yes. Dated as 30th day of March 2023, signed by the foreperson. Verdict form, count 7. We, the jury, find a defendant, Allen M. Brown, guilty of failure to comply with an officer's attempt to take a person into custody as charged in count 7 of the information. Dated this 30th day of March 2023, signed by the foreperson. Verdict form, count 8. We, the jury, find a defendant, Allen M. Brown, guilty of driving or operating a vehicle without owner's consent as charged in count 8 of the information. Please answer the following question. Did the defendant possess a dangerous weapon while committing this crime? Answer yes. Dated as 30th day of March 2023. Verdict form, count 9. We, the jury, find the defendant, Allen M. Brown, guilty of attempted escape from custody as charged in count 9 of the information. Dated this 30th day of March 2023, signed by the foreperson. The defense wish have the court poll the jury.
Yes, please.
Right. What this means, folks, I'm going to ask you individually, and I'm just going to use numbers.
They put on no defense.
I'll start out way in the back, closest to the door. You'll be number 1. I'll go through here 6. I'll come back. You'll be 7, and I'll go through 12. I have 9 verdicts. They all have answers to them. They all have verdicts to say guilty. They all have the answers to the questions that says yes. So I'll ask juror number 1, is this your verdict on all these verdicts as to Mr. Allen? Juror number 2, are these all your verdicts as to Mr. Allen? Juror number 3, are these all your verdicts as to Mr. Allen? Juror number 4, are these all your verdicts as to Mr. Allen?
Yes.
Juror number 5, are these all your verdicts as to Mr. Allen?
Yes.
Juror number 6, are these all your verdicts as to Mr. Allen? I'll go to the front. Juror number 7, are these all your verdicts as to Mr. Allen?
Yes.
Juror number 8, are these all your verdicts as to Mr. Allen?
Yes.
Juror number 9, are these all your verdicts as to Mr. Allen?
Yes.
Juror number 11, are these all your verdicts? No, I'm sorry. Juror number 10. Are these all your verdicts as to Mr. Allen?
Yes.
Juror number 11, are these all your verdicts as to Mr. Allen?
Yes.
Juror number 12, are these all your verdicts as to Mr. Allen? So everyone in this jury, I'll ask you one more time, are these all your verdicts?
Yes.
All right, everybody answered yes for the record. Okay, I did poll the jury. You are excused then, folks. Thank you for your service. Don't forget your personal belongings. I thank you for everything. Have a good afternoon, okay? If you need anything, you can talk to the bailiff.
Okay, so I believe in that trial, that was the Alan Brown trial. He was accused of shooting a couple of police officers as well as a police dog. This particular case did not address the shooting police officers or anyone else. The crimes that happened in this jurisdiction only involved the police dog. There was no defense put on, is my understanding.
All right, the jury is outside of the courtroom. Is there a motion by the state?
Yes, Your Honor. I move for judgment on the verdicts as well as revocation of any bond.
All right, as to judgment on the verdicts, there are 9 counts here. They're all guilty counts, so there'll be a judgment on all the verdicts with the enhancer questions that are in the verdict. The court's also, based on the charges and the convictions here, going to revoke the defendant's bond and set the matter for sentencing and order a pre-sentence investigation. I will have the clerk give you a date and let me know if the date will work.
May 19th at 10:30.
Is that good for the state?
That works. Thank you.
What about the defense?
This judge's shirt goes really well with his
Right, we'll have to start over then.
with his robe. I like the black and the, what do you call that? What color is that judge's sleeve? Like his sleeve and his collar. It's like a mustard yellow, maybe? Yes.
May 25th at 10:30.
Good for the state?
Yes.
Defense?
Goldenrod.
That should be fine. Thank you.
I've only heard that color in relation to paper.
We'll see you then. Pre-sentence is ordered.
And that was 10:30, correct?
Yes.
All right, thank you.
Thank you.
All right, that's all we're going to see out of that court. He's got his convictions on all accounts, which is, I guess, expected. Didn't put on any defense. And didn't file the motion that you usually see there where they ask the judge to set aside the verdict and issue a directive otherwise. But all right, let's see where we're at. We're going back to this one. There we go. All right, goldenrod, baby poo. That's a better one. Pea green, Dijon mustard, Colonel mustard. All New Orleans Saints colors. All good answers. Grey Poupon. Pardon me, sir. Is your shirt made out of Grey Poupon? Okay. We had a house down the street that color, and we called it Baby Poo House. Red pen. Funny story that you bring this up. So now we've got a little break. Let me share this with you. I right out of high school, I did a brief stint in business, a brief foray into the business world, and decided that I was going to paint houses for a living. I did this first as an apprentice with someone else, and it was very telling to me to see the paycheck he would get from the customer and then compare it to the paycheck I was getting when I knew how much of the work I was doing. And so shortly after that, I decided to go into business for myself. And I did. And it was not as at the easy street I envisioned it to be. And so I started seeing exactly why he was charging so much and why he got to get a lot of the money. Ended up getting called back by him after I left him, and he said, "Hey, can you come back and help me on this job? I'll pay this much." And I'm like, "Sure." We went up to a house on the hill that is, when I say on the hill, it's the last house before you're too high on the mountain to build. Okay, and this is in Davis County. It's in Utah, and I think it's in Centerville. Yeah, it's before Farmington. So if you're driving north on I-15 from Salt Lake City towards Ogden, which goes pretty straight between the Great Salt Lake and the mountains, most of the houses are up on your right in Centerville and Farmington area. that's changing, but still way up on the hill, right at the very top, near the Haddads, if anyone knows that area. There's this house that we painted, and the homeowner asked that they paint the house in 4 different colors of green, and it was like fern green and very light green, and we just had all these different green colors, and we painted everything. We painted the redwood stained siding, we painted the brick, we painted the posts, the garage doors, everything in all these different colors of green, and sorry, I'm watching comments, and so this house was hideous. Absolutely awful. Okay, and I'm serious. You can drive by. I think it's still that color. It's my fault. It lowered the home value of all the neighbors' homes, but they wanted every inch of that house painted green. Okay, guys, keep it appropriate now. Keep it appropriate. Lisa, apology accepted. Thanks for catching that, Matthew. Anyway, so you say. You had a house down your street painted that color. I painted a house, just hideous, and I'm the reason. Well, they're the reason, but I'm also the reason why it was so awful. It's not intentional. It was. I'm telling you, these colors of green did not go well together. It was like if you could find colors in the same shade within that spectrum of green that would not work. Those are the 4 they chose. And they were awful. And we used hundreds of gallons of paint. And here's a little fun fact. This is where they make their money. There's where we made our money. Did we shape the shrubs as well? That would have been the finishing touch, Weather Watch. No, we didn't do the shrubs. But this whole house, it's like you can see it from the freeway. From over a mile away, you can see this house, and it just stands out like, whoa, what is that monstrosity? But painted over all the wooden siding, the exposed wooden siding that had been stained and everything. We destroyed that home. I think it needs to be demolished to get fixed. But we made all our money selling the paint because our labor was actually pretty cheap. But we'd buy the paint at our supplier's place, and we're paying like, I don't know, $9 a gallon for it. And then we sell it to them at like $30 a gallon. This wasn't me. This is my employer. This is how he made all the money so he could pay me, and he just made a killing. And then and the contract, he would write it out so that however much paint we use, that's how much we'd use it. But here's our set fee. So our fees stay the same. You just pay for materials. It was so bad. That wood was so dry it just soaked up paint like a sponge. Gallons and gallons and gallons of paint. But they loved it. So anyway, that's neither here nor there. That was not as fun a story as I thought it was when I thought about it. Let's see. We had a super chat in there, and I didn't get to recognize it properly. Let's see if I can find it again. If you give me just one moment. Let's see who it was. Was it Jeff H?
There's a GoPro video of a man breaking 7 ribs during a fall skiing at Whistler Blackcomb Ski Resort. No other person involved. Cold ground's hard.
Thank you.
Thank you, Jeff.
Are we ready for the jury?
We are now, Your Honor.
We are? Okay.
Here comes Gwyneth.
We're ready for the jury.
My own version of the cow story. Love it. So many layers of paint. So many layers. Applied by brush and roller. No spraying.
Bring the jury.
Bring the jury.
Can we be clear on time? I think they took a full hour. And do they...
7 minutes left. All right, jury.
Packed courtroom today. Absolutely packed. If they took a full hour, they only have 10 minutes. I guess they have 7 minutes left for redirect.
All right, thank you. Mr. Owens, you ready to proceed?
Thank you, yes. Just to be clear, because James is going to share the time with me.
Sure.
And is the plaintiff reserve any time for rebuttal?
They reserved 10 minutes, which I granted them.
And so do they have an hour and 10 minutes? And do we have an hour and 10 minutes?
They reserved 10 minutes, so you can proceed.
So we have 1 hour.
You can take 1 hour, and if it happens to go over because you're finishing a topic or something, that's fine.
Thank you so much. Well, folks, we didn't even know each other 2 weeks ago, and here we are. Thank you. It's a beautiful thing, I think, that we resolve disputes in our country in this way, just like Lawrence mentioned. You're plucked and really against your will, even if you had to fight it. In theory, one of these bailiffs could go arrest you and come and make you come here. So we don't do that with anything else, but why do we do it? Because it's such an important thing to resolve disputes in our country in a peaceful manner. So, thank you. I'm Miss Paltrow's, and I'm going to just call her Gwyneth. I'm Gwyneth's lawyer. I'm her spokesman this week. So she sat there for 2 weeks and been a punching bag. We've blown through a lot of these cute little Post-it notes where she's sending me stuff. But I take it very seriously because she's comfortable in a lot of worlds I'm not comfortable in. But she is not comfortable in this world. It is not a nice thing for someone to throw a press conference and say, like King Kong, you knocked him out and walked away, skied away. That is not what happened. And the court has actually dismissed the idea, and that's one of your jury instructions, that this was a hit and run. That took no small amount of work, by the way. But that is what she was faced with. It takes a lot of courage, does it not, for her to sit there for 2 weeks and be pounded like a punching bag. What did she lose? Did she lose, oh, that's too bad, you had to come in early and have a massage? No. This is what she lost. She was in love with Brad Falchuk. Dated for 2 years. They both had, very interesting, I think, 9-year-old sons and 11-year-old daughters. It's kind of cool. And they said, how are we going to get these guys together in a loving, fun time? They're very busy, where we can kind of all be together for a couple days and see if this will work, if we can blend our families together. We're going to make it relaxed. We're going to put a lot of planning. She put a lot of planning into that trip. And so here they are. It's a little delicate because anyone who's been through like trying to blend families, it's a delicate thing. So what happened? They got there. They're organized. First day of skiing. They have ski instructors. By the way, I thought it was cool. I don't know if you did. Her dad taught her to ski at Alta. And she has tender feelings about that. She's been tearful with me in describing those ski trips with her dad, because her dad died in his 50s. In fact, it was so painful she didn't ski for a long time after that because she would miss her dad. But when her kids were of this age, and we're talking with Brad was a big skier. We didn't get to hear from him, unfortunately, lack of time. But they were going to come, okay, let's get our kids together. So what did they lose? They lost a half day of bonding, and even more, because now everyone's stressed. That was the day when they bond up going up the ski lift. They bond having hot chocolate mid-afternoon. They bond relaxed, laughing around the fire.
They're having problems with the feed from the courtroom. It's not us. This is on their side, uploading. I'm going to try to see if I can pull another feed. Okay, let's see if I can take this one.
When they bond up going up the ski lift, they bond having hot chocolate mid-afternoon. They bond relaxed, laughing around the fire.
See, this one froze.
I told you when we first met, I wanted to concentrate on a couple things about Lady Justice here. By the way, if I didn't make it clear, you are Lady Justice. All right. Blindfold eyes. Because she's blind? No. She's smart. But she's not going to be distracted by chaos around her. Chaos like media, chaos like sympathy. Oh, don't we all feel bad for him? I would have liked, by the way, at least a discount on the camel ride on your request for damages, but that's another issue. The idea is, okay,
what?
We're going to focus. We're going to focus, and we've tried, and the judge has given you all these warnings. Don't be talking to people. Don't even talk to yourselves yet, because we want you focused. And that's Lady Justice. Now, I talked to you earlier about the scales of justice. This is a civil claim, meaning the preponderance of the evidence. The plaintiffs brought the lawsuit. That's why we're all here. His daughters say, isn't it terrible? These two daughters that he's brought here, his life is laid open. It's because of him. He hit her. He hurt her, and he wants $3 million for it. That's not fair. The easy thing for my client would have been to write a check and be done with it. But what does that tell her kids? It's cost of business. No, it's wrong. It's actually wrong that he hurt her and he wants money from her. And that's why we're here. All right. So back to the scales here on Lady Justice. He has the burden to tilt. Okay? Tie goes to her. Now, she has a $1 counterclaim. My wife said, don't waive the dollar, and I'm not waiving the dollar. But a dead even tie means neither get anything. And I'll walk you through that in just a minute. But let me suggest it's not even close. Let me suggest it's like this, the evidence here versus here, and let me talk to you about that. Let me mention a couple other jury instructions. So I talked to you about no sympathy, passion, or prejudice. We don't want you making decisions on that basis. I talked to you about the burden of proof. That is theirs. And then from today, let me talk to you about a few things. By the way, the burden of proof was evident because they get the last word. Because they have to tilt the things, you may have noticed this morning they could call a witness, and after I'm done, they can speak for a few more minutes. And that's what we do to the people who have a burden of proof. Instruction 30 that you were read today. Gwyneth Paltrow did not leave the scene of the accident without giving her contact information. Press conference 4 years ago. King Kong came out of the jungle, left me unconscious, and brushed off and went away. Utterly BS, and it's been discounted. It's not even before you. The judge took that away from you because it was so obviously false. 31 deals with spoliation. That's the GoPro issue. Spoliation is probably a word you've never heard before. It's a legal term. But the idea is if they destroy evidence, you can assume that it was bad for them. All right, so Terry, in fact, I should say Mr. Sanderson, in fact owned a GoPro. All right. He talked to his daughter that night, 6 p.m., so about 6 hours after the collision. She got off the phone with the understanding that he had a GoPro video of the incident and typed to him, I am so glad that there's a GoPro and that you're okay. All right. No one has the GoPro, but I'm telling you this. If you find that there was a GoPro and that he said, that will not help my case, delete. if that happened, you can conclude that it was against him, that it helped us, and wouldn't it have been nice if it had been around? Do you remember when we talked 8-9 days ago? I said, you're going to hear so much stuff about damages. So much stuff. But if you find that he hit her, you can ignore it. So we heard like a week of testimony about Mr. Sanderson's brain and how he thinks. He does like to be the center of attention. He likes to be in the spotlight. His own daughter said he would be dishonest for money or notoriety. Does that make you like uncomfortable? It makes me really uncomfortable. When Dr. Gibby was up there, he said, oh, he has a great relationship with his daughters. It's like, who? He says, two daughters. There are 3 daughters. You can't just pretend this stuff away. 3 daughters. It's pretty important, isn't it, for a witness to know that he's not in the least good relationship. And why? Because she said he was abusive, and a lot of other adjectives that I'm not actually will defer to you to remember. So Ms. Paltrow is asking for her dollar, but it's not about the dollar. It's not about. I mean, think of what her time is worth sitting here for 2 weeks. It's not about the money. It's about kind of ruining a very delicate time in a relationship where they're trying to get their kids together. That's what Terry Sanderson caused her. Pre-existing conditions. Oh my gosh. How do we not talk about what was going on right before and what versus what's happened after? He's 76. I mean, my parents, I'm not being flippant, they were dead by then. They certainly weren't taking 10 trips around the world. So we have to look at that. Those are the jury instructions. I do want to tell you the special verdict form, that was appropriate. Can you bring that up? Lawrence walked you through it, and I don't think there's any harm in me telling you what I want. Is there? I'm going to ask you to fill this out. This is what you go to the delivery, when you deliberate, these 3 pages. The last page really is nothing. So it's essentially 9 questions. And I want to show you how I want you to fill it out. I'm not trying to be subtle. All right, so was Gwyneth Paltrow at fault? No. If you answer no, go to question 3. So next page. Then you have to, that means Terry Sanderson's not going to take any money away from today. If you write no, so no on 1, you are done kind of in terms of his claim. Then you go to paragraph 3, which is our claim. Was Terry Sanderson at fault? Yes. We want you to say yes. Was his fault a cause of her harm? Again, we're asserting $1, but it was so much more. It made everyone nervous all afternoon. Was Terry Sanderson's fault a cause? Yes. And then, James, if you answer, regardless of your answer, go to 5. If your answers to question, so this is like a tax form where you have to like read it 4 times, sorry. If your answers to questions 1 and 3 are both no, 1 was, is Gwyneth at fault, you should not proceed any further. And you go to the end and sign it. And this is because you're trying to figure out, was she at fault? Yes or no. Was he at fault? Yes or no. Did it cause any damage? You can actually find today that neither were at fault. Skiing is an interesting thing. We strap sticks on our legs at the top of a very high hill and go down for fun. It's breathtaking. I've done it. I love it. But it has inherent risks. So the back of every ski pass you've ever seen.
Judge, objection. You've excluded this inherent risk of skiing.
We referenced this, Your Honor. You said I could argue.
It applies to resorts and not to people.
No, the argument is improper, so overruled.
So inherent risks, you've seen it on the back of every ski pass, and even your own common sense says, hey, if I don't go down this hill right, I could actually kill myself. So, skiing is different. It's even different than driving. I mean, we don't drive cars down hills, right? Down the icy hills. But we do ski down icy hills. The Deer Valley guy would say, we're never icy at Deer Valley. But nevertheless, it's kind of a dangerous thing. And so you can actually say, no, don't get me wrong. I want Gwyneth paid for the hardship Mr. Sanderson caused her. He hit her, he hurt her, and he's not entitled to sue her. I'm sorry, he's entitled to be here today, but he's not entitled to be rewarded for hurting her. That's not how this country works. All right, James, let's see. Then if we go, if your answers to 1 and 3 are both no, you should not proceed further. So if you found not at fault, you're done. You go to the end and your foreperson signs it. But if you keep going, otherwise continue to 6, James. I couldn't do this without James, if you can't tell. What % of the fault to you assigned to Gwyneth Paltrow? So then you have to figure out a percentage. It's possible that both people are at fault. And how this works is you take 100% pie and you find out, okay, Gwyneth's 10% at fault, Terry's 90% at fault. So a lot of things aren't just so obvious, like gray and white, black and white. We would, obviously, if you get this far, we'd want you to put 0 apportionment to her, Terry, 100%. I guess you could find that Gwyneth's entitled to 75 cents and not $1, believe it or not. Okay, then we keep going. James, whatever you can find here. What amount compensates Terry Sanders? And we just want you to go to 9 and give us our $1. There was a little issue raised about whether her attorney's fees could be added to that. The judges said, I'm going to deal with that. That's not in front of you. All right, so your topic is this $1. Believability of witnesses. This was one of your earlier instructions. How do I figure out who's telling the truth here? And I'm going to put Craig Ramon. First of all, Terry doesn't remember much. There was one just blatant misstatement in their closing, which was Terry could talk to a wall for 2 hours and have a pretty good conversation. That was before the incident. That was misrepresented as being after the incident. Every time that issue came up, I said, before? Yes, before. All right. Let's go to talking about evaluating witnesses. I'm telling you, if we were in law school and we had a class about eyewitness, how an claimed eyewitness actually sees what he thinks he sees, Craig Ramon would be the definition of a bad witness. And I'm going to give you some objective statements about that. He's at the end of the court. He says, I'm skiing, and there at the end, I'm colorblind. I have imperfect vision. I don't know what they're wearing. I'm looking at other things. I'm not focused on them. He said he hears and turns. Well, guess what? Eric Christensen, the ski instructor, who they accused of a cover-up, which was dismissed, heard and turned. They're the same. They heard and turned. Craig describes himself as an eyewitness. Eric said, I didn't see the collision. I just heard and turned. They saw the same things. Interestingly, Eric came right over, and now's appropriate time to watch our little fun video. I don't know if you like these animations, but we kind of put them together so that you guys can kind of envision all this information coming at you. So Eric Christensen, did you like the guy? The guy is like, oh my gosh, I love this guy. He's been doing it for 40 years. He teaches art on the side. He's been a lifelong resident. He's married to someone whose whole life is skiing. And he is not a liar. He is not someone who covers up. He is not someone who falsifies reports. All of those allegations were thrown out. So we're not dealing with Deer Valley. Interestingly, it's not just Ramon versus Christensen, because all the Deer Valley people, do you remember the cool Whitney who took the toboggan woman? I mean, she's an amazing witness. She's up there, oh, I'm assessing things all left and right, you know, nothing, but that's a little different. So we're going to play this, and I think Moses is in orange. And there's Terry. So Eric Christensen says he sees Terry out of the corner of his eye. Well, he looks and sees, because he's in charge of sort of protecting these kids. So he says he's always looking up the mountain. And then he hears and turns. And then the next view, the next one. By the way, no one but Craig has the guy spread eagle with his head down the hill. There's no facial damage to his face. His skis stayed on. You've heard from these structural bioengineering people. If he came and got hit like Craig described, his skis would have popped right off. You don't keep your skis when you get blown. Sanderson says he was airborne, that he was flying. First of all, I'm not going to get into the weight, have him sit on scales, but twice, by the way, not once, twice Mr. Sanderson said I'm 3 inches shorter and 15 pounds lighter. We're not talking about today, we're talking about then. Then he was 3 inches. I don't know if he shrunk 3 inches since then, but he described himself as pudgy. He's coming downhill at a faster pace. I mean, anyway, the structural engineering people, which is kind of interesting, not structural, biomedical engineering people, I don't know if you got bored in that part or was interested, but I'm telling you, the science does not work for Craig's theory. Okay, so we're going to play this. Mr. Christensen, am I in your way, Judge?
No.
There's Moses, Terry Oaks, Apple. It's a little hard to absorb, but here's Gwyneth, and there's Sanderson. Now, let me tell you what Sanderson said, and he said it just at the end of the day yesterday. I said, tell me what's going on right before the incident. He said there was a lady on his left that was kind of tentative. So I deliberately, I think I said, passing on the right. Pretty sure I did. So there's the woman he describes in green. And he's trying to he's watching her. He is blind in his right eye. He said, I use that term loosely. He's an optometrist, for heaven's sakes. He's blind in that eye from a stroke. He has helped him contribute to his retirement. Okay, so he's watching, and imagine this. I'm blind in my right eye, and I'm really mindful of not hitting this woman to the left of me. And then he said, nobody could have passed on my left except the gal I just passed. So that gal I was real conscious of because I still worried about her. And so as I went past her, I went inches per second past her. I just remember it took forever for me to get past her, and there were skis. And then that's when the collision happened. All right, so maybe run it one last time, James. So he's looking to his left with a blind right eye to make sure he doesn't hit the woman. He's looking to his left, and what happens? Gwyneth described, and praise to the judge for not letting this be reenacted with Gwyneth and being assaulted in front of us all. She is skiing, and two skis come in between her, and this is not a big hill. By the way, I mean, these are kind of photographs. This isn't just claymation here. And comes in, and she's like, what is happening? They're not going that fast, but Terry's going faster because his skis are coming in between her. It's because he's looking with his one, by the way, he has like half an eye because he has a cataract in the left eye, hearing's shot, and he says, I'm getting too old. I can't do everything I can. Well, I mean, I stopped playing church basketball after my knee injury. I'm like, I love it, but I can't do it anymore. Okay, so sometimes we have to give things up, especially when we're 76 years old. I'm sorry. I mean, that's life. But he comes in between her legs. She's going, what is going on here? It's not like a ski collision hit, you're out. And he's grunting, his body's against her. She's thinking, am I being assaulted? Like, because this isn't really a ski collision. And then they go for a little while. She said spooning. And then, and whatever the next imaging, next animation would be, James. And then they go to their right. Now, I don't know, you've heard the ribs issue. By the way, if you're 76 with osteoporosis, you can break your ribs. You may see, and this record's in your documents, these weren't dramatic breaks. I mean, two were not even distended, dislocated. What's the right word? Displaced. Thank you. Two were not displaced, and two were just very minor displaced. Did they hurt? I'm sure they hurt them. I'm sure they did. All right, so she is on top. Eric Christensen said she was on top, and their skis are intertwined. And what is she doing? She's like, okay, I see I'm not being assaulted. And he may well have hit his head. He does have a helmet on. So does she, by the way.
I'm
Craig
surprised the
Ramone's
animation
like,
doesn't have a
no
GoPro
helmet.
on it.
He tried to change his testimony on the stand, but I had questioned him like 5 years earlier. No, she didn't have. I was really surprised. No helmet, no mask. Give me a break. For anonymity purposes as well as safety, this is a person skiing with her kids. She's pretty focused on safety. Let me just tell you that. All right. So what's the first thing does? Eric Christensen, is this the last one? Is this the last of the animations?
Only 3 admitted, Judge. Only 3 were admitted.
I think there were 5.
3 full ones.
3.
Whatever you can take us to next.
Well, but you've already shown 3.
There were 3 videos that were that were entered in their total, and then there were 2 only partial. Is that right?
Correct. Yes.
Okay.
So whatever you can give me.
2 partials that didn't show the actual impact.
Only Craig has their heads downhill. Moses, who you'd love him if he's a cute little 16-year-old now. But we didn't get it. We only got to hear him. He skis over because he doesn't hear anything, but his instructor comes over. He comes over and he sees his mom on the ground. Now downhill because she's gotten away from this guy. Okay, I'm safe. The idea of an assault just entered her mind. She said for a couple seconds because she's going, what's going on? This is the overhead view, and run it as you can. Here's Miss Paltrow. Apple, Moses. Here's Miss Paltrow. Here's the beginning skier woman. Here's Sanderson. And she's making these small turns on the right. He's making big turns. He's a lot faster. He's a lot more advanced skier, I should say. All right. Here's Christensen. You remember we placed him. Carrie Oakes went on ahead with Apple. Apple told me she heard a commotion, but she was hangry for French fries, and she just wanted to get down the hill. Moses is here, and so there we go. Okay, any other animations? Looking uphill. Paltrow in black. Sanderson. Beginning skier in green. Woman. Watch Sanderson. And then we're done. So it's probably that third one, that two back, that's probably the most powerful of them in terms of showing you the layout. All right, how am I doing on time, folks? I want to leave James 10 or 15 minutes.
30 minutes so far.
Thanks. So I'm going to 10 after. Thanks, Judge. After they've separated, Brad Falchuk comes up, she skis down, but there's then this period of time. So here's Eric Christensen. Eric Christensen said, I came over to find out what had happened. They say he came over to bully him. Deer Valley employees who bully their guests get fired. He's been there 40 years. You could see if his grandfatherly demeanor makes sense under Craig Ramon's story. It doesn't. It doesn't. Eric comes over and he says, first thing I'm doing, I'm taking off skis. Remember, under all stories, no skis came off. That tells you something about the manner of the collision, doesn't it? It wasn't like Ramon describes, flat out straight. By the way, Ramon, oh my gosh, he says he's out cold for 2 or more minutes.
This is Owens.
And what did you do about it? Nothing.
Owens is speaking right now.
Nothing. Could you imagine looking at an unconscious person, splayed out, head down, skis on, for over 2 minutes? Could you imagine? I'm like, did you call 911? Did you check for breathing? No. Yeah. None of that. I mean, good grief. Give me a break. All right. Eric Christensen comes over and says, okay, let's take skis off. Remember, he had some personal knowledge because he knew kind of where Gwyneth was, and he kind of knew where Eric Christensen was. He knew where they were, downhill versus uphill, and he knew their skill level. He could tell, he said he could tell because Mr. Sanderson was an advanced skier because he didn't slide. I didn't really know this, but if you do kind of, you skiers will maybe know. If you can work your edges and you don't slide, apparently that means you're a more advanced skier. Okay, so he comes over, he's trying to figure out what's going on, but he actually knows some things. Gwyneth is pissed off. If you hit someone, do you yell at the person you just hit? No. The hittee, and I've been hit skiing, is usually the unhappy one. But she recognizes these things happen until he says, did you hit me? And now she's mad because not only has he hurt her and hit her, but now he's saying, no, I think you caused this. And then she's like, are you kidding me? You just ran in my effing back. And Moses heard it. Moses heard it. All right. So then, Christensen, who I think is just a fabulous witness. I think everything he said is just utterly true. It's consistent with everything. He took off skis. I said, was Sanderson ever out cold? No. If he was, it would have been like that. Gwyneth, was he out cold for 2 minutes? No, he wasn't out cold at all. Don't you think people would be going like crazy if there was a man splayed out on Deer Valley, head down, out cold for minutes? That's not a believable story. Eric Christensen now is engaging people. Gwyneth's mad, but she's okay in the sense that she doesn't need help. She can still ski, but she said her knee, which she'd already had surgery on, hurt, and she has sustained a blow. I mean, I don't know if you've ever been hit, even if you're in a football game and you're all padded up. She had sustained a blow. She was upset. And then this idea of him not sort of, she says, you know, you just did this. And then what did he say? I'm sorry. Does the person who got hit say they're sorry? No. The hitter says, I'm sorry. And he said it. I'm sorry. I'm sorry. Okay, now she's okay. Okay, he's not denying the stupid thing he just did. But, okay, now we got to sit around and kind of sort things out. Then Christensen goes to Sanderson. Tell me what you want to say. And he said, she appeared right in front of me. That's what he said in his report. She appeared right in front of me. That's consistent with Gwyneth being mad and saying, you just skied into my effing back. And it's consistent with Christensen seeing kind of what was going on. He was the uphill skier. He knew that. And there you go. That's, if everything's consistent, now if he'd said, I didn't do it, she hit me, okay, whoa, now we got to investigate. And then you recall, so okay, it's clear who did what. Christensen says to Ramon, your buddy just took out Gwyneth Paltrow. I think this was just after she skied away. And what did Ramon say? Did you correct him? No. That's the time to say, no, I saw it, and she hit him. That was the time. Ramon didn't say a word. He just sat there. He's not helping his unconscious friend, and he's not denying, under his story, what the ski Deer Valley representative has just determined. Your buddy took out her. All right. So that's the time to do it, not later. Remember, one of the things I said in opening is rely on the evidence before there's thoughts of lawsuits, because then you can kind of rely. People aren't thinking, okay, 10 minutes later, oh my gosh, Gwyneth Paltrow. Wow, that's something else. We were just in a collision with Gwyneth Paltrow. Now people are thinking, okay, wow, I'm famous. They're not thinking that yet. In real time, he's saying, I'm sorry, and then, are you okay? Everyone always asks this question, are you okay? And he said, I'm okay. Now, he tried to change it a little bit, and we had to go to his transcript, but he agreed. He said, I'm okay. And then ski patrollers come by. So, I mean, there would have to be a pretty vast conspiracy against Deer Valley for this to be a cover-up. And remember, they were already dismissed. Ski patrollers come by. They see some stuff going on. Everyone all right over there? Eric Christensen did not answer that question. Because this is a contact now between injured skier and ski patrol. Eric's a ski instructor. And so, what happened, Eric? He said they talked. So this isn't, we're not in there like trying to bully someone. Craig spoke to Terry privately. He said, Eric said, I couldn't hear it. And then, which obviously Terry at some point said he remembers Terry saying, are you okay? Are you okay? So there's a connection. And then what did they say? We're okay. And the ski patrollers left. All right, so that's what's happening in real time. Now we go to the paperwork. Why don't we fill out a big deal, get everyone's statements and everything? Because if this happens all the time on ski resorts, if everyone's okay, I mean, we don't have a scene about it. But they go down a little longer. They now know that Miss Paltrow was part of the collision. And then Terry, and you can believe him, but they now know. I'm not skiing too well. I don't feel that well. All right, fair enough. It did come 10 minutes after they found out who they had been involved with. All right, bring in Whitney. Whitney's an awesome, geez, I thought she was a fabulous witness. She pulls up, and she's all business, like, okay, I'm going to assess for unconsciousness. No. What happened? She says, what happened to Terry? He didn't say, I got hit. He says, I don't remember. I don't know. Did Craig immediately go in on that? They'll have to defer to her report. That was a legitimate question of mine. I'm trying to remember. James, when are you up?
5 minutes.
Are you up in 5? I can do that. That gives you 5 or 10?
Gives me 15.
Thanks. I'm going to be done in 5 minutes, folks.
Is he stalling to remember?
So Whitney's delightful, loads him up, takes him down, says, hey, before, I want you to remember 5 things. And this isn't like man, woman, dog. This is like, I got my degree in Michigan, I was Deer Valley Grand Slalom person, whatever. All these really detailed. I like horses, my horse's name, all this stuff. Remember it. Terry says, I remember. I knew I was now having a cognition memory test performed upon me. He goes down, and she then says, do you remember? And oh my gosh, he remembered. In fact, he remembered so well, he decided this is a good opportunity for me to text and post a picture of Whitney smiling and just talk about how wonderful she is. Whitney, meanwhile, is sitting there trying to figure out, okay, are any problems here? Are you seeing any signs of concussion? No, I'm not. Do you remember Dr. Edgley? I don't know if you thought that was cool, that a guy who heads up the U's acquired brain injury clinic has had an acquired brain injury. I thought it was kind of cool. Anyway, he goes, what do you look at? You look at period of unconsciousness. We have Craig versus all these people saying he wasn't unconscious. They even imply like Christensen didn't even care about us. He's yelling at us, he's bullying us, and then he's abandoning us on the conscious, drooling on the mountain. Give me a break. Is that what you know Deer Valley to be? So then, okay, he checks out at the main clinic. Then he's down to the Instacare. What is that Instacare PA looking? He's looking for I don't see any signs of symptoms of unconsciousness or concussion. because they're looking at memories, they're looking at periods of unconsciousness, and they're looking at, what was the third? Do you recall? Memory.
Ataxia. Ataxia.
That means inability to speech. I don't think that is what they were looking for. In any case, they're looking for any signs and the symptoms of concussion. No. Now that doesn't mean he didn't have a concussion, but it does mean this isn't anything severe at all. I mean, okay. Next day he goes to the VA. These are the people he knows. CT. Guess what? They're like all the same abnormalities as you had in your brain before. The problem is, and by the way, he then goes for 3 neuro assessments, and they all say normal, normal to above normal, in some ways really above normal. So no assessments, those are all his treating providers. Why would we have our experts go do neuro assessments when 3 separate treating providers that he knows and trusts and that no one's paying say above normal? Why would we do that? But the problem is he then goes to Gibby and Fong, and he just self-reports everything was normal beforehand, wrong, and now everything's terrible, wrong. He doesn't tell him he's flying all over the world, that he's biking, that he's the poster boy for fitness at age 75. He's posting every darn thing. I mean, this isn't like me sending out a private investigator and trying to find pictures. All I have to do is put Terry Sanderson. Oh my gosh, the guy's Mr. Activity. Heaven help me if I can be as active as he is at 75. All right, I have 1 more minute. I'm going to go back to Lady Liberty. So we talked about the blindfold, Lady Justice, excuse me. We talked about the blindfold, and we talked about the scale. The sword. The sword, we want you to use the sword. This sounds harsh because we're not beheading anyone. The sword is to defend a meritless claim. This is a meritless claim. You don't throw a $3 million bombshell in the courtroom, call her King Kong, and walk away. You shouldn't reward that. And Gwyneth, who could have just paid it out, paid the ransom. No, I'm not doing that. I'm not going to have someone hurt me and then ask me for a lot of money. I'm not going to do it. I'm going to sit here. I said, you're going to have to sit here for 2 weeks in Park City, and you can't even look at your phone. And she said, I'm going to do it. I'm not paying that. We ask you for the $1, not because she had to go in and get an early massage, but it screwed up a very carefully planned, important time in her life. Thank heavens the family melded well together. But we want our $1.
I want my $2.
Judge, can we approach briefly?
Sure.
Okay, so James gets a little break here. He's going to mic himself up. I'm hoping James just knocks a home run here. Young attorney, just getting started. He's got a kid or two himself. He's married. His wife sings. He sings. James plays the piano as well. Yes, you can find him on like Spotify. Let's see how this goes. They bifurcated the argument, so James is going to be talking about damages, right, or liability.
Mr. Egan, you may proceed.
All right,
whichever one we
Your
haven't
Honor.
heard already.
Are you guys hearing this? Okay. Okay, so it's my job
Can we just turn off his mic?
to talk about Mr. Sanderson's claim that he's not living the life that he used to live, and it's Ms. Paltrow's fault. Hope I can be helpful to you as we walk through some of this. I wanted to start by just pointing to this document. This, you remember, Whitney Smith was the ski patroller that arrived and wrote this report that day. A little bit later, Mr. Owens could not recall an important fact. This is the witness section at the bottom is not filled out. Mr. Ramon did not come forward and say, this is what happened, let me tell you about it. Whitney Smith would have written that in there if he did. She also pointed to, we also pointed to the fact that she did not write an X at that concussion and head boxes where she could have noted possible injury. She's, to use one of Mr. Sykes' phrases, she has no dog in this fight. She would have put X's there if she was concerned about that. She didn't. You also heard her talk about mild disorientation in her report, and that shows up here. And I think you've seen that the point, gosh, I'm sorry, this thing can be finicky. You've seen it. I'll just move forward for the sake of time. There's those mild disorientation notes, right? And she explained that she didn't see that as an indication of concussion. She just saw it as being kind of rattled from a ski collision. And that's relevant to damages because Mr. Sanderson is claiming that he had a concussion, and all of the symptoms that have come from the collision relate back to that concussion. I think there's considerable doubt that he even had one. He may have, and you could certainly find that, but you might find that he didn't have a concussion. I think, though, that I want to kind of frame this with a certain theme. Maybe you've seen a pattern over the course of these last couple weeks, or the last 2 weeks. On the one hand, you have real events, and then on the other hand, you have embellishments. On the one hand, you have objective tests, and on the other hand, you have subjective reports. On the one hand, you have what happened in the past, and then on the other hand, you have perception of what happened in the past. The realities of life, sometimes difficult realities, and on the other hand, you have anxious exaggerations. I think Mr. Ramon took the reality of the collision and spun it into an attention-grabbing story for friends about dramatic injuries and celebrity. He was talking a lot about that. Ms. Smith overheard it as she was caring for Mr. Sanderson. And then there were those comments that we found in the middle of trial where he talked about it, and you heard him explain that he'd been talking about it with friends. He knew a lot about Ms. Paltrow. He's very interested in this. I think he took that reality of the collision and embellished that what happened, what he saw. And Mr. Sanderson's taken the reality of his aging body, and he's turned it into a profound injustice perpetrated by Ms. Paltrow. It isn't that. The facts show that his health challenges started long before the collision, and they've progressed in a predictable way. I think you heard Dr. Hesh yesterday say, if you look at his medical records, you look through the history, you take the collision out of that timeline, it reads coherently. The prior stuff would predict the next stuff. You don't need the collision to explain what happens afterwards. It's not to say that he didn't have injuries in the collision. Nobody disputes the broken ribs. And those were certainly painful. They did heal. And then the concussion, if he had one, was very brief, as you heard multiple experts say yesterday, and had very mild symptoms that may have even resolved within that day. So even if you find that Ms. Paltrow caused the accident, I think you only have sufficient evidence to find damages that relate to those broken ribs and the concussion that resolved very quickly. The slow degeneration of bodies is hard to accept, and mental health challenges are hard to face. It's obviously human to want a concrete explanation for these difficulties. But as the court has instructed you, Mr. Sanderson should not receive the money he asked for if you find that his perceptions do not match reality. The law requires that he convince you that more likely than not, he has suffered real harm, that Ms. Paltrow is and that Ms. Paltrow is the cause of that harm, and he has not done that. Through the course of the trial, you've seen that Mr. Sanderson does have genuine problems, and I don't want to minimize that. Experts from both sides have talked about his anxiety and depression and the trouble he's had with family and relationships. before and after the accident. You've seen brain scans. Dr. Black came in here, and he was the only expert, I believe, that took you through all of them and explained how they, were back in 2009, look very similar to what you've seen going forward. They're connected to abnormalities related to aging and other conditions that might explain his problems. But Mr. Sanderson's argued that you should believe his experts because they evaluated him personally. The problem, I think, with that argument is that, as you've learned these past 2 weeks, these experts didn't carefully review his medical history, and they relied heavily on his unreliable reports about it. They also want you to believe what they've been calling the before and after witnesses, the family and the daughters, the friend, and then the girlfriend. And I think that you've learned these past 2 weeks that they didn't know Mr. Sanderson's health as well as they thought they did. And he was actually, they had, I think, acknowledged that he's good at hiding some of those issues, maybe totally understandably, and reluctant to share his troubles. So you have objective facts and then subjective reports. And the law requires you to find evidence, reality, not just the perception of problems. From our experts, you've heard a consistent, compelling account that Mr. Sanderson had these problems before that the concussion occurred, potentially, again, very briefly, if at all, and that those conditions that he's experienced afterward that he attributes to Ms. Paltrow are the predictable consequence of that prior history. They were, you heard them all yesterday. I guess you had Dr. Edgley the night before, but you heard them all, and it's a coherent, consistent story. I think you got a sense that they've read the records carefully, the objective records of treaters who have, again, no dog in this fight, just reporting what is going on for many years before and after the collision. Your Honor, I have till 25?
Yes.
Okay. 5 more minutes. I got a lot. I'm not going to get to all of it, but I'll try to get to the helpful stuff. Mr. Owens went through the various evidence about loss of consciousness and the different witnesses that have, I hope, persuaded you that Mr. Sanderson did not get knocked out for multiple minutes. But Dr. Eastfold gave you some interesting testimony yesterday. She said that the medical records after the accident are actually inconsistent with serious concussion injury. There was the cognitive assessments she pointed to that were normal. There was the balance assessment that was normal. You wouldn't expect it to be normal. And then there was the alcohol intake that actually increased, even though a concussion would reduce your tolerance for alcohol. Again, careful looking at the events in question, which I don't think you heard plaintiffs' experts do. Mr. Sanderson's perception is different, obviously. He not only thinks he was knocked out for minutes, but he said he had a profound cognitive trouble during this time with Ms. Smith, who said he was cognitively intact, could speak to him. He was writing articulate posts about her, could carry on conversation for hours. So you got careful evaluation on the one hand, and then you have extreme exaggeration on the other. And the law requires you to be careful in your evaluation. Mr. Sanderson sees the time immediately following the collision as a grim period that began a spiral, began spiraling his life out of control. I think he described the bright side before and then the dark side afterward. And I think it's important to recognize that, as we've probably told you too many times, a few weeks just prior to this collision, he was reporting some of the symptoms and the concerns he's saying connect to the collision, right? He's said he was getting old all of a sudden. He couldn't do things that he used to do. Get preoccupied with paperwork and other little things. And that's difficult, and I don't mean to make light of that kind of reality that aging brings upon all of us. But it's important that at that time there was no litigation. He's just reporting, and you heard from experts that point to that as a telltale sign of the kinds of things you would expect after the collision that he's attributing to Ms. Paltrow. Mr. Sanderson's told you that the collision forced him to be a recluse. And if we had time, I would pull up those pictures. We went through a lot of them, and I hope that wasn't overboard. you got a sense of just how much he has done since the collision, traveled more than some people have traveled in their whole lives. And I think it's that this $3 million, I don't know where the board is, $3 million claim, I think doesn't acknowledge that reality. Mr. Sanderson is better than he realizes that he is. And it's not that he doesn't have problems, it's just that he is better than he realizes he is, and it's hard for him to accept some of the decline that he's experienced. And he's, again, grabbed onto this collision as an explanation for it. You've heard from Dr. Hesch and Dr. Edgley about how litigation contributes to problems like he's had, and you heard even from his own expert, Dr. Goldstein, that he's obsessed with this case and it's not good for him, that moving on would be helpful for him. And I think that we all want resolution to this case. Mr. Sanderson's asking to be compensated for a ski injury that the evidence shows that he himself caused. And the evidence also shows that his life is not the mess he perceives it to be. Ms. Paltrow wants him off the mountain too, but she should not be responsible for the cost of that. And so we leave you with that argument. Hope that you can, of course, hope you're persuaded, and thank you for listening.
Thank you, Mr. Egan. Mr. Sorensen?
They've got about 10 minutes here, maybe 7 to 10 minutes.
Thank you. Thank you for being here.
Oh, Pete, I have this. Sorry.
Thank you for that.
Yeah.
We appreciate the time and attention that you've spent with us the last couple weeks going on kind of this journey. There's been a lot of fanfare, a lot of hubbub about this. You've seen a lot of technology. Some has failed, as we've seen today, but some has worked. And through all of that, I want to remind you of jury instruction number 24. Okay? And it says, when the lawyers are giving their closing arguments, keep in mind that they are advocating their views of the case. What they say during closing arguments is not evidence. If the lawyers say anything about the evidence that conflicts with what you remember, you are to rely on your memory of the evidence. If they say anything about the law that conflicts with these instructions, you are to rely on these instructions. Now, you've heard some pretty amazing narratives, a spin on the facts, and you could probably say it cuts both ways, both sides. But I want you to remember about this case that there are two stories here. One is Gwyneth Paltrow, and you've heard her defense attorneys lay out her case. You've heard her side of the story. But there's also another side, and that is Terry Sanderson. They've done a really good job of telling you about what Craig Ramon says about how he describes this whole thing happening, and what Gwyneth Paltrow says, or what Eric Christensen says. But the two stories that are important to remember are Terry Sanderson's and Gwyneth Paltrow's. Terry remembers skiing down the mountain, hearing a scream directly behind him, and then bam, as he put it, lights out. Okay? He's knocked unconscious. He's left on the mountain figuratively, as we've talked about, trying to figure out what's going on. When he comes to, it's chaos. He doesn't really understand what's going on. On the other hand, we have Gwyneth Paltrow, who says that she's skiing along and all of a sudden she gets hit from behind. It's up to you now to weigh that evidence, to see what you remember, what you recall, not the way that the attorneys characterize the evidence, but what you see in the record. And I will tell you that what you see in the record corroborates the story of Terry Sanderson. Terry Sanderson, I just walked you through his tale of what happened, okay? His versions of facts that happened. When he's hit from behind, he has to rely on the one person, remember that, the one person that says that they saw the actual collision and saw what happened. He has to rely on that. But it doesn't mean that it's not part of his story. It means that he's relying on an eyewitness that corroborates what he said. Also, we have the meetup group post that's been talked a lot about and the comments to that post. That's contemporaneous evidence the day of that corroborates the story that these two have shared with you. It says, and in Craig Ramon's own words, says, it scared the hell out of me. It scared him. It scared what he was scared. So that might be an account that you weigh as to why he didn't step in to try to give life-saving or life-supporting measures to his friend. He's scared. He doesn't know what's happening, and the person that he's relying on to take charge of the situation comes over and starts screaming at him. It's also important to remember that Brad Falchuk, who we didn't get a chance to hear from, and Kerry Oakes both contradict in major ways
So, Your Honor, he
story,
cannot
testimony.
reference the testimony of Brad Faltrow.
He admitted, Your Honor, and that was
Just a minute.
He admitted, Your Honor, that he did not see it.
Your Honor, that testimony is not in evidence.
Just a minute. Yeah, that's true. That was a stipulated fact.
That was a stipulated fact. So,
Thank you.
Brad Falchuk did not see it. Okay? Eric Christensen, in his own reporting, didn't see the collision. But yet, right afterwards, he injects himself into this chaotic event and, according to him, takes control. He has enough time. Think about this when you're weighing believability of testimony, okay? Eric Christensen has enough time and is all aware about the students that he's being paid to watch and to teach how to ski that are beginner students. Watch what someone's doing on the other side of the run at the same time with, as reported in the facts show, many people skiing on this run. It's a converging run that goes down to the bottom of the run where people can go and have lunch. He has the ability to pay attention to a young child who he's teaching, someone across the way, someone skiing supposedly out of control, and keep track of all this. He hears a scream and looks over and sees, as the animations that you've seen, sees him laying on the ground, or sees these two people laying on the ground. He then has enough time to be the first on the scene, supposedly, after telling Kerry Oakes, take care of the kids, watch them, because I got to go over and take care of this. And he does that all in just fractions of a second. Is that believable? I'll leave that to you to decide. I know the way I feel about it. So this witness, who the defense has said is grandfatherly, who's this perfect witness, is not really that perfect. Now again, I'll leave that for you to decide. Now, a lot's been made of what Terry Sanderson was saying or doing after the incident, right? You've heard, and I don't want your eyes to glaze over, that's why I'm not using any of the props, I'm just talking to you. But you've heard a lot about this email, right? The email Terry Sanderson sent later that night, or the first email and then the response back, okay? And I want you to remember this. The GoPro incident, or the GoPro video, I guess, and we'll talk about this GoPro email, is a response from his daughter, who sat here and testified 3 weeks before she'd been in her own ski accident. She was laying there with her leg up. She was under, as I think she said, she had pain pills at the time. She was aching an injury. And there might have been kids coming in and out of her room. She didn't remember exactly why she wrote what she wrote. Nonetheless, she admits that she wrote it. And she said here in front of you that it was clearly a misunderstanding to something her dad might have said when he was on the phone with her. That's the shred of evidence that they want you to cling on to try to say that Terry Sanderson did something like destroy a video of this event. That's our only piece of evidence that they'd put on in front of you to that fact. Now, again, there are many contradictions in this tall tale and the cartoons you've been forced to watch a few times. And I want you to remember, okay, there was testimony that Brad Falchuk was on the mountain, but he's not in their videos. He's not in their animations. Okay? You didn't see it, but there's testimony that he was right up there close. They left him out. They left out Carrie Oakes and her testimony. We had to read it in because she also contradicts the positions of the bodies after the incident. So they've done a really good job of trying to razzle-dazzle and trying to get you to look at a lot of other things that are not important, because we told you in the very beginning, when Lawrence Buehler stood up here, you'd hear a lot of "so what?" That's what they're saying about Terry Sanderson's injuries. So what? He was injured before. His injuries carry through. So what? So sorry he's left on the mountain. We'd like him off. So what? That's what you're hearing. Now, we have shown facts that are corroborated
incoming
by
poll
his medical records that show that from the day after this incident happened, there was a very serious decline. The people that knew him best testify under oath in front of all of us as to the changes that they experienced with Terry. His closest family members have seen those relationships affected. Terry's seen it affected. Again, I want you to weigh this evidence in the way that only you can. And I think that you can do it. I've seen all of you be very attentive. I've seen all you pay attention, and we appreciate that, because this is a very real situation for two people, the two stories that are at play in this. I also want you to remember there's been a lot of talk about what Jenny Sanderson said, what Jenny Sanderson reports, but she's the one that went on one of those international trips with him. So it can't be too strained of a relationship. You're not getting the full picture when you have excerpts taken out of context from a deposition that are read to you. You're not. He has 3 daughters. They all love him, and they all said that. Unfortunately, we didn't get the chance to hear some of the positives from Jenny, but their relationship is strong. She loves her dad, and he loves her. But she even said she's seen changes. Now, yesterday you heard Terry Sanderson say it's a hard thing to bring a lawsuit against the celebrity. Said they destroy your life, and they turned around and said it's your fault. It's your fault that this happened.
Your Honor, I object and would like a little conference, unless you want me to state my objection right here.
I think just overruled, and you can make a record later, but let's let him finish.
Thank you.
I don't want her lumped in with
Terry
other
Sanderson.
celebrities.
Thank you, Judge.
Thanks. They point the finger at Terry Sanderson saying it's your fault. You did this. You brought this on yourself. Terry Sanderson believes in justice, just like you've seen right here. It's been waved all over. And he wants the weighing of the scales the same way that Miss Paltrow does. But Terry Sanderson believes, and I think we've shown you, that on those scales, someone has facts that are weighing, and someone has a lot of fanfare that when you really pry it, it's a so what. It's a nothing. So, I charge you, and we thank you again for your time, hearing the evidence, listening to all of us, listening to the coughing, listening to the objections, listening to this, sitting through the sidebars. We thank you, but now it's you. It's on you. And we invite you now to weigh the evidence, and we empower you and trust that you will weigh this evidence the way you've heard it properly and find on behalf of Terry Sanderson. Thank you.
All right, so they're done. We have a poll up right now.
In a civil case, only 8 jurors are allowed to deliberate and reach a verdict. Because this trial was scheduled to last over this 2-week period, and because jurors may need to be excused because of an emergency or other extraordinary circumstances, 2 alternate jurors were selected in this case. Prior to going back and deliberating, the court is required to excuse the alternate jurors. Some jurors are relieved when they are excused prior to deliberations, but most are disappointed and even frustrated that they've invested their time and energy in the trial but are not going to be able to deliberate. Those of you who are excused, those 2, thank you for your service on the jury. Remember that you're actually not being released as a juror. until the verdict comes in, because there is an outside chance that one of the 8 during deliberations may be called away for an emergency. And so the 2 of you that are allowed to leave, you may be called back to finish the deliberations and to vote on the verdict form with the others.
It's not going to happen.
So please do not discuss the case with anyone. Please do not read anything about the case. Just keep the existing restrictions in place until further notice by the court, which will be after the verdict is rendered. Please leave your cell phone number with the bailiff so that they can notify you when the verdict has come in and even give you the results if you'd like. Again, we appreciate your time and attention on this case. So I've got in here all of your names, and I'm just going to look the other way and pick 2 out.
And announce their names.
Or your juror numbers, rather.
Thank you.
And so the 2 that are excused are number 15 and number 24.
Bingo.
Those of you who are not being excused right now, you've been given all of the evidence and instructions on the law regarding this case. Before you retire to deliberate, I need to give you a few final instructions. First, about questions. As you deliberate, you may be tempted to seek more information. If you do have questions, please write a note and give it to the bailiff, and I will review that note and the question that you have that pertain to the case, and I'll review it with the lawyers and decide on how to answer your question if it's appropriate. However, it's quite possible, and in fact it's probable, that we will not be able to answer your question. You should understand that no further evidence can be provided to you, and the instructions given to you contain the law which you need to reach a verdict based on the evidence presented to you. What to take into the jury room? Let me first say that you cannot take your cell phone and you can't have any outside contact during deliberations. So the bailiffs will give you some time before you begin deliberations to text or call anyone and let them know, hey, I'm about to go on be blacked out here while we're deliberating. And then they'll take all of your cell phones and they'll keep them in a safe place back by your deliberation room. You may take the following things in there with you. Your notes that you took, the jury instructions and any notes you took on those jury instructions. All of the exhibits admitted into evidence, they are being assembled. The lawyers will agree that, yes, we do have this is the correct exhibits with the clerk, and then they'll be brought back to you in a little bit. You're also the same with the verdict form. I have the original verdict form. It says original on top. This is the one that will be filled out, and the bailiff will bring this back to you as well. When you get to the jury room, please do the following before beginning your deliberations. Read over the instruction on selecting a foreperson and select a foreperson, and then you may begin. At this time, I'd like the clerk to administer the oath to the bailiffs.
Do you swear that you will take charge of this jury and take them to some private and convenient place where they may deliberate upon their verdict, allowing no one to speak to them nor to do so yourself unless so ordered by the court, and to return them to the court when they have reached a verdict or when so ordered? So help you God. Thank you.
You may now take the jury back. Thank you.
All right, the jury. Okay, the jury is getting lunch. But they might be done with their work before lunch is done, so we might have to wait for them to finish eating before they come back with their answer. I'm going to go ahead and close out the poll in just a second. If you have not voted, now is the time to do so. Let's see. I'm trying to finish up.
May be seated. Thank you, counsel. Mr. Owens, did you need to make a record on anything on that last objection?
Yes, thanks. There was just a reference. It's hard to sue a celebrity. I thought that was an unfair statement, given
he seems to manage.
It's this person. This is a person here, not a celebrity.
Is that Apple right behind?
I thought it was unfair to sort of slime her with Hollywood.
And the court anticipated that and noted, what I was thinking about was the fact that the plaintiff basically said the same thing on the stand, and I think he was just repeating that. So as far as, well, are there any exceptions that need to be taken on the record otherwise?
She has some very similar cheeks.
Okay. I wonder if there's been a motion filed by some members of the press concerning how to handle the reading of the verdict. Mr. Raymond, are you in the courtroom?
Mr. Hunt.
Mr. Hunt, is that right?
Yes.
Why don't you come up and present your motion?
The press wants to film Gwyneth Paltrow.
If you could first identify yourself, your bar number, and then who it is you're representing.
Good afternoon, Your Honor. Jeff Hunt. My bar number is 5855. I represent Court TV, ABC News, CNN, Daily Mail, the Associated Press, and NBC News.
I'm ready to hear your motion.
We did file a motion, Your Honor, to modify the court's electronic media coverage order and decorum order, which previously through the trial has restricted EMC coverage of counsel tables. And as the court knows, this is a case that's attracted substantial national and international attention. I think it's actually been a marvelous opportunity for the public to observe how the court reaches decisions, how cases are litigated, and we all benefit from that transparency, that accountability. That is what the EMC rule that was adopted by the Supreme Court was intended to serve. And as Your Honor knows, under the EMC rule, Rule 4.401, electronic media coverage is presumed within the limitations of the rule. And subsection 6 of the rule, there are several limitations for not showing the jurors, not showing minors, not showing exhibits that haven't been admitted, etc. Counsel's table is not within subsection 6. So as the rule stands, the presumption is that there should be electronic media coverage of counsel's table. And we just simply wanted to clarify for the court that when the jury comes in and announces their verdict, that the videographer and the still photographer for the Associated Press be allowed to show the public, as everybody here in the courtroom would see, counsel's table. I mean, that is the most important part of the trial. This is what we've all been leading up to. Everybody here in the courtroom will be able to observe counsel and the parties when that verdict is announced. And we simply believe that consistent with the rule, unless there is an overwhelming, and the rule says a compelling interest, not to show the parties and the lawyers during the announcement, that it should be allowed, and the court should modify the order to allow still camera photography and the video coverage. We've participated with Court TV in over 30 years of trials, live coverage. We've never had once a situation where the public wasn't allowed to observe the parties and the counsel when the verdict was announced. And that's for good reason. You've had 7 years of litigation, as I understand it. You've had 2 weeks of trial. And the most important people, the people that have the most interest in the outcome of this litigation, is the parties and their counsel. And the public ought to be able to observe them when the verdict is announced. And again, under the rule, Your Honor, the burden is on the party seeking to impose an additional limitation under the EMC rule to come forward with some explanation for why that would be particularly harmful or prejudicial. And there simply isn't any reason for that. If you look at the reasons, the factors that are in the rule, all those factors weigh in favor of allowing EMC coverage of the verdict announcement.
How do you envision this happening physically?
I'm not sure where Wes would like to be positioned, the still photographer. Imagine.
There would be a still camera right here.
Okay.
But without an operator, that is being remote. Is that possible?
I'm not sure if that works for still, but
yes.
the video would just be as the video would normally work.
Right.
For the still.
I think this lawyer is going to get more out of this moment than Terry will.
Yeah, there was a still camera up here before, Mr. Hunt, but I don't know how much control the photographer had over that camera, and it had a very big, long lens, and it was focused on one individual.
But it could be fired remotely from here, though. He says he could fire it remotely from that position, the camera.
But can they? I mean, if it's
the aperture.
Well, I'm just wondering if it would be focused on one individual or be focused on both counsel tables at once. I mean, how do you perceive that?
Well, today I don't have the ability to set this thing up since I wasn't able to the other day.
Okay.
He didn't bring his remote trigger.
So at this point, physically, what it would require is a photographer to be standing over here and taking pictures. Is that what I'm hearing?
Yes, I don't have the remote with me today.
Okay. And I mean, the court TV camera is very unobtrusive. I don't see it. I don't hear it. It can pan and move and do all sorts of things without anyone noticing it. I realize that right now, I mean, this will be the end of the case. So the concern of an interruption of the proceeding is different, but it's still there in terms of decorum. How can we maintain court decorum and still
have the photographer seated on the ground in front of the bench?
It is there, Your Honor, but we can station the photographer there in a place that's unobtrusive. The jury's here. The focus is going to be here. It's going to be very brief. It's not like we're asking.
And why can't the still photographer take stills off of the court TV feed?
I'm not. The quality's not going to be there.
It doesn't work.
Just different.
I'll hear it from both sides.
Yeah, there's just different modes of capturing the image. The still photographer is just set up, designed just for that. The images are richer.
And in your experience or your client's experience, how have other courts handled the still photography?
We've usually had the still photographer positioned in a place that's unobtrusive and for limited periods of time and not able to go in and out of the courtroom. It's just there.
So we're going to have a huge telephoto lens.
I'll hear from you again, but I just want to hear from the parties.
Sure.
Mr. Sykes?
We're going to have a verdict before the
We have no objection to this. We think it's reasonable. Right now, there's this tripod over here with the camera on it is covered with a kind of a black robe, like two judicial black robes here. And I think if Mr. Bomber was to stand there, and we'll take the screen down. I think that would be fine for us. We don't think that would be obtrusive or violate decorum.
We're fighting over camera positions right now.
Mr. Owens?
And the daughter's gone.
Thanks, Your Honor. First Amendment's important to us.
But, wait for the but.
There's certainly been a public benefit, I think, to having this in the public sphere. We've noted 3 violations of the decorum order. The very first day my client walked into the court, after I assured her there would be no photographers in the lobby, there was one right in her face as she went through security. Then suddenly one day another camera appeared, and then a third violation we felt. I don't know if you found a violation, but I have still photos of her being taken just yesterday. So we're all for the First Amendment. The idea that the public should see what we see, the public isn't seated in the well of the court. The public is seated behind Miss Paltrow. The jurors have an interest here. This is stressful for jurors
to have a still photographer standing right where that screen is as those folks come in. I think even if their picture isn't taken, I think it's strange. I think it will be stressful. Mr. Sanderson actually has a privacy interest here too,
which has not been asserted.
I thought it was insightful of Your Honor to ask about how this would physically change. If nothing would physically change, and if they're looking at the defense counsel in its totality, defense counsel's table, we would have no objection.
Mr. Hunt? So the defense wouldn't have any objection if nothing changes physically in the courtroom from the way it sits right now?
That's fine, but I still think it would be unobtrusive and completely consistent with court decorum to have the still photographer there for the minute or two that it took to announce the verdict. It's not going to, they'll have already determined their verdict. It's not going to add any additional stress. They have known that there's been media coverage throughout the trial. We disagree that there's been any violation of the decorum order. Counsel has not approached me about that. We're not.
I know you, but I didn't even know you existed in this case until an hour ago.
I've only represented the media in Utah for 30 years.
Yeah. I know you, but I didn't know you were even involved in this case.
So we're not here about that. We're here about my motion, and it sounds like we squared away the court TV, the video. We'd ask Your Honor for the 2 minutes, unobtrusive. Mr. Sykes makes a good suggestion of moving the stand-up, and we think that that can be accomplished, and the public will be richer for it. We're going to have descriptions about the reaction anyway. The press is going to report that, so why not have the images and the video that actually show what the reaction is so the public can judge for itself what the reaction is. That's the most accurate way to report this to the public. Thank you.
Thank you. Well, given the fact that there is a presumption in the rule, and given the First Amendment, the court will grant the request as long as, for the reasons stated, as long as that is used to sort of stand between the photographer, the still photographer, and the jury. So we can turn that sideways. The still photographer can stand quietly, and I assume your camera makes no noise?
No, sir.
There's no flash?
No, sir.
Okay. You can stand next to the existing camera then, and
he's going to get paid for his pictures.
When the verdict is read.
Those are the pictures everyone wants. It's so much better than the video quality.
Is there anything else before we adjourn at this time?
Can I throw out an issue that will need to be addressed at some point? Your Honor has had a protective order in place in terms of speaking with the press. After the verdict is delivered, is that protective order lifted as to speaking to the press or issuing press releases? I ask because we've received a lot of inquiries. I think the protective order and the decorum order, I think, talk about the evidence, for instance, depositions.
The jury's ready to come back. Being
held confidential in perpetuity. But the press issue, I think, is appropriately lifted once the verdict is delivered. So there you go.
I don't quite understand your request. For clarification, are you asking to continue the protective order, or are you asking for confirmation that the protective order will be released?
As to the press.
As to the press,
we want it to be released. We don't want certain, for instance, depositions that were taken that were marked confidential. Anything that was not. For instance, I have boxes and boxes of things that didn't come into trial.
Right.
I don't want that. I want those held.
Everything that was marked confidential, according to this court's confidentiality order, remains confidential.
Correct.
In perpetuity.
If it's been entered into evidence in this court, it's obviously not confidential.
And it becomes public.
And then we do want we do want to be able to speak to the press after the verdict.
But we don't want them to take
pictures. Do you have any
right
objection to that, Mr. Sykes?
No.
Okay. So once
can't
the
have it
verdict
both
is
ways, come
read, the informal agreement between the sides that they won't talk to the press until after the case, that's then no longer there, and they can talk to the press. And the press can talk to witnesses, the press can talk to jurors if they so desire, and I'll explain that to the jury. And I'm going to ask the press to please acknowledge and respect the wishes of the witnesses and respect the witnesses or the wishes of the jurors. And if they don't want to speak to them, or if they want to wait or maybe later, please respect that. So I expect that'll happen.
Another thing that Pete just mentioned, the decorum order prohibits any cameras in the courthouse. I think that should be lifted now. I mean, because it's cold out there and wet out there, and they shouldn't have to be out there, and we shouldn't have to go out there to talk to the press if we want to.
Well,
now that
I'll consider that, but it's the reason that there's the standing order that there not be press doing things other than inside the walls of the courthouse, other than through a decorum order, or special orders, is for other reasons. There's security reasons, things like that.
Lame.
So I'll talk with those that have some control over that and get back to you on that.
I didn't mean that to sound the way it just did.
Anything else before we adjourn?
I think
Not finally adjourn, but
a sad excuse,
take a
though,
recess.
to say you can't use cameras. in the
Okay, so
courthouse.
what I'm going to do is when I'm alerted that there is a verdict, I will let the head of security operations, Chris Palmer, know that that's happened, and he will then let all the press know that in approximately 20 minutes or longer, if we need that, at least we'll wait at least 20 minutes before we bring the jury in and read the verdict. So if the lawyers will please leave a cell phone number contact with Jody, then we'll have we'll call you as well if you're not on premise. All right. Thank you. We're in recess.
Okay, we're going to have, oh, sorry. Let me turn this off here. Right there. And turn this one back on. That's me. Yes, we're going to get the party horns out because you guys can celebrate for whichever side you feel wins in this one. So party is ready to go. Let's bring this back. Okay. Party horns are ready to go, yes. And we'll have the volume up too until the actual verdict. I think we're going to have a quick verdict. Missed what the judge said on the cameras. Basically, the lawyer representing pretty much all of media in Utah, all the big media outlets in Utah, including Court TV, as for their presence here right now, argued and said Utah has a presumptive media coverage law that says it's assumed that media will be allowed to cover this. And because of that, the burden rests on the person wanting to restrict that right to prove that there is an overwhelming or necessity to limit those rights. And so they basically threw it back at Gwyneth Paltrow's team and said, hey, why should we not be able to? They didn't have any good reason. They did say, well, they didn't behave last time, but really there were they weren't able to cite any specifics other than a cameraman was in the lobby, which sounds like he broke the rules, taking a picture the first day when she arrived. Other than that, they said they don't have any objections, so they're going to bring in, they're going to use the existing camera system that's set up for video cameras that can currently see Gwyneth Paltrow. They'll use that. Now they can show her. Okay, that order's been lifted. So effective immediately, they're going to be able to show her as soon as they come back and the table and all that. And they're also going to have a still photographer. His name is Wes, and he's the guy who has the Rapunzel braid. You'll see that possibly, maybe not, because he's going to be hiding in the corner now by the jury box. And he's going to be able to stand there and take pictures of the counsel, both tables, with his long lens, which will get right up and personal, really high resolution. And those are the pictures you're going to see. The still photography, I realize we like video, but the still photography pictures are the ones that you're going to see on the professional thumbnails of videos about this. They're the ones that are going to show up on the websites as you read the account of what happens. That's going to be going through the Associated Press and everything else. They're the guys who hit me with copyright strikes all the time. Yay!
No, they're not stolen.
But that's it. She's not coming back. Who's got the bet on whether or not she shows up in court? I'm not sure if she has to be there. I don't know the rules about that. Media counts as if we're all walking into a courtroom. By law, we're allowed to walk into any courtroom and watch to monitor the system. Being a celebrity doesn't nullify that right. Thank you, Tag. And newspapers. Have you ever seen a real newspaper? Yes, Crusoe. I've been to a museum. I've seen a newspaper. I know what they look like. Just throwing you under the bus there. She's not coming back. It's not for entertainment. A lot of people say, poll if she shows up. Let's do that. 100% she's gone. We'll do a poll just to see if you guys are right on this one. Oh, we've got a poll going already. I need to stop that one first. We're going to end that poll. It's on the jury deliberation. Looks like the results are 1 to 2 hours are 51%, 2 to 4 hours, 24%. Shut up already, we've decided, is 18%, and 4 to 8 hours at 5%. So all of us are looking like we're getting an answer here today, which is good. I accidentally almost closed the stream there by clicking on the wrong button. Sorry about that. Will GP ghost us for the verdict? That's going to be the poll. Will GP ghost us for the verdict? I think I spelled it all right. By ghost us, I mean, will she disappear? Will not be visible when the verdict's read. Let's see. This court is not for amusement or photo ops for people. I would not come back if I were her. Right. But the press conference she wants her immediately afterward, and they wanted to lift the rules for her benefit afterwards so they can give a press conference. That is for her benefit. And she can't just have it her way. It's not all just for her.
I was kicked back, taking it easy.
I sent her all this. Perfectly Imperfect says, I don't understand all this super negative towards GP. She is still a regular citizen and entitled to defend herself. She's people, just because she's famous, y'all crawling all over her. Negative, I don't know. I think she's behaved a little bit aloof during this, but I don't really have anything for or against her personally. I actually liked her as Pepper Potts in Iron Man. She has left. Did she leave, like completely leave? I don't think she'll do the conference. No, just her lawyers will be there. But they've prepared a message. Let's see. I'm betting she'll be back. She's been there the whole time. That shows a lot of respect. She didn't have to be there the whole time, but she has been there the whole time. Anytime the jury's there, she's been there. Now, if she leaves for the verdict, I think that will look bad, that she was just doing it for show for the jury. GP may have enjoyed the attention more than we think. I think that may have been her daughter behind her, who is, I believe, an adult now, 18 years old. But when they said they were going to allow the camera, when they cut over to it again, she was gone. She had left. Okay, Johnny Depp didn't stay. You can hear my kids in the hallway singing or something. She's right. That's right, Scott. She's been there all this time. Why leave now? Yeah. Is Iron Man worth watching? Never saw it. If you like superhero type movies, it has some funny moments. Okay. Time to top off the water mug. Yes, it's time to take lunch. I've got a new thumbnail for the video up because we're on verdict watch. We're going to reset and take lunch. We have a 20-minute notice. Okay, the judge has given us 20 minutes between when he's told the jury's ready and when they're going to announce it. So we are not going to miss it. We're going to take a break. We're going to then grab some food because we've really gone over, and then hopefully tonight we're going to have a result. So I'm going to put a window open, but I'm not going to go live until we get a verdict. So if they take more than a day, we probably will not be back unless there's like a police chase or something. Let's see. Yes, I'm working on the cinnamon rolls. My wife is actually running another test with a new recipe. She says, all these years I've been making it wrong, which is phenomenal, really good. All these years I've been making it wrong. I've got a new recipe she's going to try to make it even better. So I will have to, take one for the team and be the taste tester on that. I'll grab some cinnamon rolls. Gwyneth has more class than to not show up. I think she will. I think she'll be here. Let's see what the poll says. That we're almost 50. Well, about 60-40. Looks like 58% say that she's going to ghost us, and 41% say that she's going to disappear. 42%, because YouTube always loses a percent somewhere. You work at a place that makes cinnamon rolls? Kenny Official, we're about to give you a recipe. We're going to publish Mrs. R.A.'s legendary cinnamon roll recipe soon. It'll happen soon, possibly over on her channel. I'm just saying, she's over 1,000 now, so she's super excited, and I've agreed to do something over on her channel. Maybe that's where we're going to make it published, but we'll link to it and everything. Hopefully a verdict by the end of the day. Yes. Hot chocolate, cinnamon rolls. Yes, I need some more of both. All right. Thank you very much, everybody, for being here. It has been a lot of fun. We are going to wrap up for the lunch. How do I know when the verdict comes in? I've got my peeps. Dallas, where I get notified right away. And so I'm going to be all set up, ready to go, so I can just hit a button and be back here with you for all the action. We've been here this far. We're not going to miss it now. So it's all going to be good. I'm going to have my stream going full blast. If there's a peep from the courtroom, I'm going to hear it. And you guys will be there too. Just make sure you have your subscribe button clicked and the bell rung. That way you can join us and you won't miss it. Won't have to watch the verdict on replay. What's more depressing than that? Hopefully that won't be you today. If for some reason you're not able to join us when we go live again with the verdict, hopefully today, please tonight when you go home, hug the people you love, smile at someone, make them feel a little bit better. A little happier, and I lost my train of thought. And stay safe until we go live again, which will be soon. The window, it's going to have a time on there because I have to put a time in there, but it could happen at any time. So please just be watching the alerts and keep your ear to the notifications. We'll see you guys in a little bit. Thanks a lot.